Morning, everyone. We'll be with you shortly. I'm just having difficulty getting through to Westgate, and I don't see the appellants on.
Good morning.
Yeah. Mr. Lynch. All right, good morning to the panel. I'm trying to get through to Westgate. I'm having very little luck. The appellants are not with us on this call yet. If there aren't any administrative matters that you wish to discuss with counsel, would you like to retire to the breakout room? You're muted, Sir Christopher. There you go.
All right. Are there any can you hear me?
Yes.
Yes.
Are there any administrative matters that anybody wants to discuss?
Yes, sir.
Yes.
One question. Will Ms. Greening be responding to questions 7 and 8 after Mr. Lynch before I respond?
I don't know.
Yes, good morning, everyone.
Good morning.
President. In my respectful submission, I've really covered most of the questions in 7 and 8 as regards my appeal, and I didn't want to bog the court down with repetition.
Right.
I concur with what Mr. Pettingill said yesterday in reply to those paragraphs or to those questions as well. So any comments or replies or submissions I do have would really just be on the back of any notes I've written down from yesterday's session, and just to say that I reiterate everything I've already said thus far.
Right. Well, there we are. That's it, I think.
My Lord. Morning.
Good morning.
Morning, my Lordship. Your Lordship raised yesterday, I think, a significant issue with respect. I've had the ability to discuss with Mr. Lynch, and I think that he is going to address it. But that is the issue Your Lordship raised of the public interest aspect of this and the clear concern that the court is raising with regard to cases that may follow, should Your Lordship be minded to take the approach that these standbys are in fact unconstitutional and should be retroactive. And then it seems to be that the question arises with regard to public interest. I believe that Mr. Lynch intends probably to address that, and I certainly join with what he has to say. But I'm wondering if Your Lordship would welcome or consider any further written submission on that, because I thought I may put something together, not necessarily to argue, but at least to submit something in writing, if that would assist.
I can't tell whether it would assist until I receive it.
Yes, I'd like to think it would assist, but yeah.
I have something to say about it as well, in reply to the question that the President put to Mr. Pettingill yesterday, but I won't need to put them into written submissions. It would just be a brief reply.
Well, perhaps you could give a brief reply, and Mr. Pettingill, if you want to put something further in writing, produce it, and we'll see whether or not to entertain it.
I'm obliged, Your Lordship. I may just go on the back of what Mr. Lynch has to say, but I appreciate that. Thank you.
Well, we haven't got any appellants.
The prison officers said that the link they had wasn't working, so I've just resent it to them and they're going to try to get in now.
Right. So we're starting with Mr. Lynch when we get the prisoners.
Okay, we are on record now. I see the appellants. So I'm now going to call the case. Roberts, Smith Williams, and Brangman against the Queen. The appearances as before my Lord President, Sir Christopher Clark, and Justices of Appeal, Jeffrey Bell and Anthony Smelly. My Lord President.
Yes. Yes, Mr. Lynch.
Good morning, everyone. Can I deal first of all with a matter which has, I feel, been something of a cloud over both last week's submissions and this week's, and that is the consequences of a ruling by the Court of Appeal that these appeals should be allowed, and how that might affect future cases and potential appeals. And one, in my respectful submission, should not shy away from the very real public policy concerns that have been expressed in some of the authorities we dealt with last week, and what Mr. Mahoney has sought to argue also last week. Your Lordship raised this again yesterday with one of my learned friends, and I should like, if I can, please, to try and see if there is a way in which the court might be persuaded to adopt a particular policy. The first thing to understand is that there is a three-stage process. That is to say, leave needs to be obtained, and then under Section 21, the court would have to determine that there was a miscarriage of justice and allow the appeal, subject to the third criteria, which is the application of the proviso, that the miscarriage of justice was substantial. So in those circumstances, this three-stage process that the court will wish to consider in any case. And in doing so, the criteria that they may seek to apply, and I don't for a moment advance this as the features that the court would necessarily say were the only features that they would apply, but they might consider the following. Firstly, that any application must be evidence-based. There must be evidence to support the submission that there was a greater number who were stood by. And the evidence as to the circumstances, if there is to be reliance on the circumstances, that needs to be evidence-based as well. And I will return to that in dealing with the questions 7 and 8 that your lordships have posed when dealing specifically with our case. I'm concerned, as the court may be, that assertions about what may or may not have happened at a particular time without any evidence to support it is a potential problem, and one which we submit ought not to be permitted where simple assertions are made, but should be reliant upon actual evidence being adduced, whether from a transcript, whether from an affidavit or some other source. Secondly, that on a number of occasions, your lordships have postulated the question, well, what if it's just one more over in a process? And one can readily recognize that it would be perhaps a little extreme in certain circumstances, and I don't say in every case, and that the right approach must be that if it is one over, it is prima facie a breach of the constitutional right, and therefore ought to, prima facie at any rate, satisfy the necessary test. However, if it were one over, and if it were in particular circumstances that might properly be advanced as to how that came about, it may be that the court would feel that the application of the proviso would be a proper exercise of that discretion. The difficulty, of course, is that once it's one over, what does one say about two over? Or is it three over? And there is a rather unedifying approach that one might take, well, stabbing a guess in some way at what might be regarded as being too great a number. And so what we would argue, and I propose to submit, again, in answer to the questions that you posed, is that if you start from the approach that it is prima facie a breach of their constitutional right, then there needs to be evidence to support a proper basis for saying why one or so, and I say or so, would be a proper exercise of the discretion of the proviso. I think lastly, one other consideration might be this. If the court took the view that you had passed the threshold and that the appeal ought to be allowed, but in considering the proviso, would an overwhelming case be a feature that the court could properly consider? I raise it only because it seemed to us that in considering the proper approach to be taken in the application of the proviso, that where there was an overwhelming case, would that be a proper basis to apply? So I postulate there a number of ways in which the court might ameliorate the worst potential floodgates that Mr. Mahoney conjures up in our minds as to what might happen should you allow this appeal. And in our submission, there are ways in which that can be properly restricted so as not to do that, or to allow the kind of wholesale storming of the Bastille by all of these defendants currently residing at Westgate. So I hope that in part deals with what has been a consideration, I know, for the court, as it has been for us in the making of these submissions. Can I then turn to...
Yes and no is the answer to your hope. I mean, thank you for those suggested criteria. But the first is that any application must be evidence-based. But since everything that happens before the jury selection is recorded, there ought to be no difficulty in getting the details of that. And you then say that if other circumstances if particular circumstances are relied on, there must be evidence about that. An assertion about what may have happened is not good enough. But the position is that we may find ourselves, take a very typical case, decided 7 years ago. If you look at the transcript, it shows that there were 6 standbys. And what exactly happened on some of the occasions is unclear from the transcript and may not be within the memory of the advocates. So saying, if you're relying on some special circumstances, you need evidence of it, from a public interest point of view, ignores the fact that in the nature of things, evidence may not be clear from the transcript and may not be available from anywhere else. So problem number 1 is that criteria number 1 seems pretty unlikely to knock out any case in which there is, for instance, 6 standbys. Number 2 is that if you only get 4, it might be extreme in some cases. But as you say, you say it might be possible to apply the proviso, but what will no doubt be said is, well, if you get to 4, how will we ever know that if number 4 hadn't been stood by, the verdict would have been or might have been different? And what is exceptional? Mr. Pettingill said, if you suddenly found that the juror was a terrorist, well, that does seem exceptional, but most unlikely, certainly in Bermuda. And then lastly, you say, well, you can apply the proviso, no substantial injustice. There are a number of problems in relation to that. Firstly, getting leave. Well, I suppose getting leave only requires that it's arguable that there was substantial injustice. But your example of circumstances in which substantial miscarriage, your example of circumstances in which there might be no substantial miscarriage is if the case is overwhelming. Well, that may be true, but that's a limited number of cases.
Of course, I'm not offering a panacea for the conundrum that we're in.
Yes.
What I'm suggesting is that there are ways, and no doubt with with further consideration, other criteria might properly be added. I simply, in dealing with the question your lordships raised yesterday, been considering how it might properly be confronted. And it seemed to me, at any rate, that these were some of the criteria that might properly be applied to limit the number. And I recognize straight away that there are difficulties at every stage.
Yes.
And,
We have the vista of the Court of Appeal doing nothing for the next 3 years except going through appeals.
I think that's a vista that is being conjured up to, in some way, I hesitate the word, but to intimidate the court into applying a principle which would effectively kill off all of these appeals, so as to avoid that potential outcome.
Well, if we allow the appeal and find that there is a deluge, I will remind you that you suggested that this was a point of intimidation. Right.
All right. Can I turn then to the questions that you postulated in the letter?
Of course.
So turn to paragraph 7, and you'll forgive me if I read it out because obviously the appellants haven't heard it. But the court also wishes to go through, to the extent necessary, the standbys relied on by the appellants. It wishes to indicate that one possible analysis is that there is no appearance of bias, or at least no substantial injustice, unless the circumstances in which the jurors, above 3, who were stood by and not subsequently ruled out for cause or excused, would lead a fair-minded observer to conclude that there was a real possibility that the jury was biased because the prosecution had stood by the juror in question in order to secure his or her absence from the jury because he or she might be unfavorable to the prosecution or unduly favorable to the defense. That is to abuse its position in order to stack fashion manipulate the jury rather than for some other reason. On this basis, the fact that more than 3 had been stood by would not necessarily mean that there was any appearance of bias. Further, it could be said that if what happened in the course of the process was that the Crown stood by a juror first or second time around in circumstances where, for instance, the juror asserted some reason why he or she should not sit or should be excused, that would not give rise to a real possibility of bias or substantial injustice, even if there was inadequate consideration of the justification for his not being a juror, because there would be no indication that the reason for him being stood by was to assist the Crown.
Yeah.
So forgive me for reading out that question, which raises a number of issues. And I seek to deal with those in our submissions that we put together day before yesterday, at paragraph 25 of those submissions.
Mm-hmm.
The position here is this. In our submission, the proper approach to take is not to look at each individual juror's standby and the circumstances under which each one came to be asked to stand by, but to look at the overall impression that the fair-minded observer would have. The test is the appearance of bias, not the real possibility of bias, but the appearance of bias. We measure that by importing the fair-minded informed observer, viewing the process as a whole, and that person would conclude that there was a real possibility that the juries selected were under conditions that were favourable to the Crown. And in that regard, I remind the court of what the Chief Justice said in dealing with the case of Trott, and invite the court to consider whether this is correct. In conclusion, it is my view that section 519 subsection 2 of the code is so heavily weighed in favour of the Crown that a fair-minded and informed observer would conclude that there was a real possibility that the jury selected by the exercise of the Crown's right to stand by was biased in favour of the Crown. It follows that this conclusion necessarily means that the accused person is denied a hearing by an independent and impartial tribunal and is sufficient to establish a breach of section 6.1 of the Constitution, and it follows that the provisions of 519 can no longer be operative as they are inconsistent with the fundamental right established by the Constitution. So the question here really is this, isn't it? If that is the correct exposition of the law, if that's right, that it means, doesn't it, that once you have a breach of that constitutional right, a fair-minded and informed observer would conclude that there was a real possibility that a jury would be biased in favor of the Crown, irrespective of the number, because they had an unlimited number to choose from. And no analysis is made there of, well, 2 or 3 might be regarded as okay, or 4 might be okay. No analysis made. It's the fact that you have that power and it being used of itself that creates the impression in the mind of the fair-minded, informed observer. I can't hear your lordship, Mr. Justice Smelly. I can't hear you. Very faintly indeed.
Yeah, I'm sorry.
I'll turn my volume up.
My microphone is giving a bit of problem. But do you accept that this exposition of the law goes wider than the circumstances of Trott itself?
It does. It does. Yes, it does. What it seeks to do is on its face lay a principle which goes beyond the actual facts of the case. I accept that.
Well, as I read the Chief Justice's judgment, he's saying that the fact that the Crown has a much greater right of standby is is unacceptable, as it were. And that a reasonably informed observer would conclude that a real possibility that a jury selected by the exercise of the Crown's right to stand by was biased in favor of the Crown. He must mean that the observer would conclude, he's not talking about the exercise by the Crown of the same right of standby numerically as that of the accused, or accused right of peremptory challenge. But he does seem to be saying that if a jury is selected by the exercise of the Crown's right to stand by in excess of 3 persons, that is sufficient to establish a breach of the Constitution. And that is, I don't know what, I've forgotten what paragraph you're quoting from. No, it's
paragraph 39. It's paragraph 39.
Yes, it is. Well, yes, but then he follows it up at paragraph 59. He says, I'm satisfied that the disparity between the accused persons and the Crown's right to challenge jurors, the disparity gives rise to a real possibility that the jury may be biased in favor of the Crown. Such a state of affairs offends the appearance of impartiality, which is an essential element of the fundamental right. He then says in 60, I'm also satisfied that the extreme disparity created in the jury selection process also results in the infringement of the principle of equality of arms by making the position of the accused extremely weaker than that of the Crown. And it was for these reasons that the court declared the section was inoperative to the extent that it allowed for a disparity between the amount of standbys afforded to the Crown and challenges without cause afforded to the accused person. And that would seem to me to contemplate that it was unconstitutional to the extent that it allowed for a disparity. And if in exercise of the power there was in fact a disparity, in a sense a fortiori, that would be such as to cause the reasonably informed observer to think there was a possibility of an unfair trial.
Yes. So
unlimited as to the circumstances.
Yes. Yes. I mean, it clearly contemplates that the defense have, or did have in that case, the right to 3 challenges, peremptory challenges.
Yes, yes.
And so to the extent that it was in excess of that, whether by 1 or 50, matters not. The principle is the one that he addresses. And in our submission, it would be wrong to look at the 1, if your lordships understand the point I'm trying to make, that it is the fact that he's using 4. So the impression that it gives, the unfairness that it creates, is the use of 4, not the use of 1. I understand, of course, that having 1 more, even just using 1 more, is only 1 more than what the defense would have. But if one's looking at the appearance of bias, you can't simply rely on that 1 and say, well, actually, there was an excuse for that 1, and maybe we oughtn't to take too much account of it, because on further analysis, we can see that extra 1 actually made a difference, only to the extent that they were standby, but we now realize that person could have been challenged for cause. I mean, that kind of analysis, in our respectful submission, is the wrong approach to take. The right approach to take is he used 4. And if he used 4 in those circumstances, that is the breach of the principle that is being spoken of by the Chief Justice, which is why I invite you to consider whether that is an accurate exposition of the law, which we argue that it is.
Oh. Well, on that basis, once you get to 4, that's it.
I accept. I mean, of course, that's right. The only issue, to come back to what we were saying right at the very beginning, is that if there is just 1 more in the circumstances of a particular case, it may be that the court is able to say that I am going to apply the proviso in this case for X numbers of reasons, which might include the fact that it was only 1 more. And that is all I was seeking to do. But as I hope I've made clear, that it is the overall impression created by the use of that power over and not just over and above the individual number that the defense would be allowed, but the impression it creates by the use of all 4. So to conjure up the scene, if I may, jurors being numbers being plucked out of a bowl and jurors being called 1, 2, 3, all go straight into the jury box, no difficulty. And then 4, standby, 5, standby, 6, standby, 7, standby, even only 4 times before it comes to jurors being applied again. And in our submission, that is what is the mischief here. And it matters not that it was 1 more, it's the process by which it is being utilized overall.
But we get back to where we started.
In the application.
We get back to where we started,
yes,
with the possibility of some exceptional circumstance. Over 3 is fatal.
Over 3 is fatal. Yes, of course. I mean, how widely one would need to draw the exceptional circumstances, I don't know. I mean, it would have to be a proper basis upon which the court could find that the overall impression created in that particular case, where a 4th was used, might not create the kind of bias that would justify the court concluding that there wasn't, that the proviso shouldn't apply.
Sorry, I got lost in the negatives there. Can you repeat the sentence?
Well, yes, of course I can. I'll try and take some of the negatives out. That the if there were a case where 1 more than the 3 currently permitted was used, and the circumstances of that 1 more was such that the court felt that there was no longer the degree or impression of bias that would justify concluding that the proviso should not apply? In other words, can the court say there was no substantial miscarriage of justice? A miscarriage of justice, yes, to overcome the first hurdle, but when applying the proviso, was it substantial? And that would be a gateway that it would have to pass through before your lordships would be prepared in those circumstances to discharge jury, to order a retrial, if that were the conclusion. Certainly set the conviction to one side.
In relation to how we might view the Trott judgment, if you can you hear me?
Yes, I can.
Right. Would you comment on paragraph 9? Do you think it affects the context?
Let me just find, yes. Here's Council Green. Yes. Well, therein lies the issue that they set to one side, as your lordships know, the original affidavits and the consideration to be given to the specific factual background to that case. That was set aside to deal with principle rather than the specific factual background. What I'm saying is that in future cases, should there be some future cases, and as indeed there is in these cases before your lordships now, there is a factual matrix which the Crown seek to rely upon, which is unsupported by any evidence. And that is the complaint.
Supported by evidence, would you be saying that consideration of it would be precluded?
No, not at all. Not at all. That is the point I'm seeking to make, is that where, for example, let's take an extreme example. Supposing there was a case from 15 years ago in which it could be demonstrated beyond doubt that young black men were being excluded from the jury. There were only 4, but they only needed to exercise 4 because there were only 4 young black men on the whole panel. That in our respectful submission would be a factor that you would wish to take into account. And in those circumstances, you might say, well, 4 beyond any doubt creates that impression. On the other hand, as was postulated yesterday, in a murder case of a black man against a white man, and a number of white middle-aged ladies were being challenged, would that be a proper basis? And again, the court may have little doubt about the circumstance, but it's a question of having the evidence to support it, not a mere assertion. Well, my recollection is that 2 of them were of a certain age, or 2 of them were of a certain type. That is not going to assist the court in our respectful submission, and shouldn't be taken into account at all. It has to be factually.
So wait a moment. Leaving aside the question of evidence, if there's a case of a murder of a white man by a black man, and the Crown stands aside 4 middle-aged ladies, does that give an appearance of bias or not?
Well, you have to start from the premise that if 4 is, as I said at the outset, that prima facie, that is an abuse of their power, that it's 4.
Yeah.
If one were to add to that, if, for example, they were middle-aged black ladies who might have sons of the age of the defendant sitting in the dock, that might impact on any decision that you make. If, on the other hand, it were the other way around, you may take a different view. And so what I'm saying is that the circumstances of each application should be taken into account, unlike in Trott, where it was deliberately set to one side in order to deal with a matter of principle. In future cases, it will be necessary, where it is possible, to have evidence of that. And that might make a difference to the approach being taken by the court. But you have to start with a line somewhere, and the line has been drawn currently by Parliament as 3. So the use of 3 is not to be regarded as an abuse. Once you're above that, it is. One way one might look at this is to ignore the case of Trott altogether, to ignore the legislation that has been introduced, and ask oneself, well, if this were a fresh application being made now, without the benefit of either the Chief Justice's ruling or indeed the legislature's acceptance of a breach of its constitution by the Section 519, if we were dealing with it afresh, the question at the moment would be simply, has there been a breach of the Constitution? And if your lordships concluded that there had been a breach of the Constitution, what would be the remedy? In returning to your question, in our case, that is to return to our appellant, Mr. Kyrie Smith-Williams, the Crown agreed that they had stood by some 6 potential jury members without cause, certainly without cause stated at the time. This represents what would have been effectively half the number of potential jurors who could have sat on the appellant's jury. 100% increase on their right. And before I embark on the exercise of examining the specific jurors who were stood by, we submit that it does not lie in their mouth, the Crown's mouth as it were, to try and attempt to reconstruct the scene at the time. And I'm quite anxious that the court should understand we are not suggesting, and we cannot suggest in this particular case, that there was what process was being used by the Crown in seeking to identify individual jurors that they were asking to stand by. And it would be dangerous and wrong to do so in the absence of actual evidence to support it. We have no recollection at all of the color of the juror's skin, the age of the juror, the appearance of the juror, the social standing of the juror, the sex of the juror, albeit I accept some of the names might give that away. It's not automatic these days anyway. And any other characteristics that might influence a peremptory challenge or a standby. We simply can't recall it. And if we could, with any degree of certainty, it would be put in an affidavit and furnished to the court. By virtue of that mechanism.
Isn't that what happened with the affidavit of the jury officer, who was able to say she checked the names against the records at TCD and was able to give the racial composition at least?
Yes, I mean, where there is evidence to support a particular proposition, then I have no difficulty with it.
Right.
What I'm saying is that there must be evidence rather than conjecture.
I'm just saying that there was evidence in the form of that affidavit.
There is an affidavit, yes.
But I'm still, I'm afraid, slightly lost as to what evidence, as it were, would be admissible. You appear to be saying that 4 is 4 or any number above 4 is prima facie an abuse of the Crown's position.
3.
Yes, 4 or anything above it. Okay,
No,
anything
3.
above 3. Anything above 3 is an abuse.
Prima facie.
Prima facie. But what I'm interested in is what happens secunda facie. You know, that proposition contemplates that evidence could be adduced, which would mean that what was prima facie an abuse of power was not in fact an abuse of power. And I'm not quite sure what evidence you are contemplating.
Well,
Evidence of what?
Evidence of what happened, firstly, evidence of any particular pattern of selection might be of value. It is evidence of that kind. At the moment, for example, Mr. Mahoney seeks to argue that, well, one or two of these people who we did stand by actually would not have been eligible to sit on the jury. Well, we don't accept that for one moment, and I'll come to them when we look at the schedule that we have. But in our submission, what is necessary for the purposes of establishing whether or not the threshold is reached to justify a finding that the conviction should be set aside and considering whether there should be a retrial, are issues where evidence in relation to a specific individual might be the case. For example, suppose that one of the jurors that was stood by in our case, a group of 6 as a minimum, if the position in that was that one of those could properly be said was being stood by for a good cause, and simply it was not dealt with in that way. It was a mistake not to have dealt with it in that way, but it should have been, and it is self-evident that that person could not have sat on the jury. That might be a different matter. That might be a matter upon which the court could say, well, on the basis of that evidence, we're not satisfied that there was a substantial miscarriage of justice. That is the only point I'm seeking to make. It's where evidence is being relied on, a factual background of why a particular standby is made or is not made, needs to be supported by evidence. And as I say, one of the problems at the moment is that if you start to rely upon people's memories of what might or might not have been the position, it becomes a dangerous exercise, and one which we would submit ought not to be entertained. If there is no evidence, then you have to proceed purely on the basis that these are the challenges that were made, or the standbys that were sought to be asserted.
But you appear to contemplate that in an appropriate case, let's assume that all the standbys were made without the Crown saying a word, other than standby.
Yep.
Or probably stand down, but let's assume they said standby for present purposes. I think you're saying that if then you got 7 standbys, it might be open to the Crown to say, well, I know we didn't say anything at the time, but in fact, X, as we knew, plainly couldn't sit, and Y has an extremely good reason why he or she should be excused. Is that right? Could that evidence be given, although it wasn't given at the time?
Well, let me put it in this way. I think if the Crown come back to the Court of Appeal in response to any application with where there are, say, 7 standbys, and 3 or 4 of them were ones which they now seek to justify, the court might not entertain that. I think if there was a case in which 4 had been stood by, and there is a clear case where one of those persons should not have sat or could not sit for obvious reasons, but nothing was said at the time, whilst at first blush that would create that impression such as to justify setting the conviction aside, in our submission, where it can be demonstrated that that particular juror could not have sat, she's the wife of a judge, or the judge, or something beyond any question that could not have sat in the case, then I think that the court would want to take that into account, and they would want to consider whether that took it beyond the threshold of a substantial miscarriage of justice.
That's considered in the context of the consideration of the proviso.
Yes, it would be considered in that context. So you'd have already gone past the first two hurdles of leave and granting the appeal, but in consideration of whether to apply the proviso, that might influence that decision. But it can't be a wholesale version. It can't simply be the case that, well, we've got 3 or 4 now that we look back at it, we can see that these 3 or 4 might not have been eligible, but there was no actual exercise being done. And of course, the court will want to be careful not to ex post facto, as it were, try and make the judgment call of what the judge would or would not have done in any particular case where it was contentious.
Yeah.
That brings me to the end of those principled submissions. What I would like to do is to look at the schedule that's been produced by the Crown and deal with a number of the individual jurors that were.
Can we do that? Can we do that as part of the second process?
Yes, of course.
Okay.
All right, then I'll leave that to one side.
Yeah.
Thank you.
Oh, sorry, just before you finish.
Yes.
You say that prima facie anything above 3 is fatal, but there may be special circumstances in which the court would determine that there was no substantial miscarriage of justice. So you appear to indicate that that's only likely to be the case in circumstances where there's 1 or 2 extra standbys. But another possible approach is that you put yourself into the shoes of the reasonably informed observer at the time when the standby exercise takes place. And if it is, well, either if it is apparent from what was said by the Crown that the reason why it was standing by was nothing to do with trying to get a partial jury, but was because the juror said that he had an appointment, or because the juror said he knew one of the witnesses. It could be said that in those circumstances, the reasonably informed juror wouldn't think that the Crown was trying to rig the jury, and accordingly that ought not to count. Those standbys ought not to count. Because there was no indication, because there was not merely no indication that there was improperly to stack the jury, but an indication of why exactly they were acting.
Well, I think, again, this is the point I was seeking to make earlier about having an evidence-based consideration of the particular circumstances. Because first of all, you start from the proposition 3 is prima facie an abuse. Secondly, if you're going to place yourself, as your lordship suggests, in the position of the fair-minded observer, a well-informed observer, if you're going to sit in his seat, it's the overall impression that it creates. And I don't want to cut across anyone else's appeal, but it does seem to me that if somebody is appearing to say stand by, and stand by, stand by, stand by, and continues to do that, and only later is seeking to argue their particular reason for a standby, that might create the impression in the casual observer, if you're sitting in that seat, of an attempt at least to rig the jury. Whereas the case where someone seeks to take advantage of a panel that he looks at behind him, where there are 4 young men, all potential jurors, and he only exercises his standby for those 4 when they are called, because they are the only 4 there. but it's clear that if that were to be evidence-based, that was the position, your lordships might take a very different view, even though there was only 4. One might argue that even if it were only 3, it looked that way.
Sorry, you're assuming
So
that
it's in the seat of the of that fair-minded observer, because the fair-minded observer might take a different view, even if the only 3 were being used, if the only 3 young black men in that court who were potential jurors were being challenged.
We're getting to a rather different and new point, aren't we, Mr. Lynch?
Well, we are. And we're moving away from the issue. I'm simply concerned to establish that if there is to be assertions of particular circumstances in any particular case, that does need to have evidence to support it.
Okay. Thank you. Right.
Okay,
Sorry, could I just go back to Mr. Lynch and ask one question? Because that, Mr. Lynch, that last example, where there are only the 3 standbys, but if one looked at the jurors in question, one could see that the standbys did indeed create an appearance of bias. If you do that exercise in the 3, doesn't that suggest that if you have a greater number, say 4, and the objections were on the basis that they were, well, the standbys were of 4 middle-aged white ladies, that one ought to be looking at that as well, other side of the same coin?
Yeah, I think if there's evidence to support a particular proposition, that well, this is what happened, this is the pattern that we're drawing, then of course it is a consideration. But as I say, you have to start from the premise that 3 is the prima facie to be interpreted in a particular way.
Yeah.
Yeah.
Is there another way of proposing that where there are more than 3, the onus is on the prosecution to justify, to present the evidence, the kind of evidence you have been discussing?
Yeah, I think if they want to seek to justify it, they should, of course, call evidence. It may be that there is evidence in the hands of the defense. They may be able to say, again, depending on recollection, who was present, what notes might have been taken, any number of factors, which might provide evidence to support a specific context in a particular case. So, as I say, it may be that there are cases out there potentially in which some evidence can be supported from the defense point of view to demonstrate that a particular pattern was being adopted. On the other hand, to take your lordship's point, if the Crown are seeking to justify a greater number than the 3 for good reason, then the first hurdle they have to overcome is, well, why on earth didn't you say anything at the time? You know what the procedure is. You must be deemed to know what that procedure is. And to seek to, as it were, I hesitate to use the word abuse, but to abuse your position by saying stand down or stand by more than 3 times, it must be something that they should seek to justify. Yeah.
But let's assume that 6 people have stood by with no reason being given. And the Crown produces an affidavit. Well, in relation to those 6, it's quite plain to us that the 3 were bound to be stood down anyway. And it was quite plain to us that the other 3 had a reasonable excuse for not being there. What is the position then?
Well,
but we said nothing at the time. Other than stand by.
So you go past the hurdle of bias. It has the appearance of bias. You've overcome that hurdle. The question now is whether or not you're going to determine that this is does it fall within the category of miscarriage of justice under Section 21? If it does, then can you consider it further as to whether it is substantial so as to apply the proviso? So where there was evidence supported by way of an affidavit which set out reasons of that kind, then that might be a proper basis upon which you could say it isn't substantial. Our problem with it is this, is that an attempt to recreate it is going to be difficult in any event. But assuming that we are satisfied that the facts set out there are correct, the first thing you'd have to ask yourselves is not to place yourself in the position of the judge and having to determine now, ex post facto, whether or not, if there had been a discussion or an argument about whether a particular juror could or could not sit, you would find it in one way or another, because there are a multitude of factors at the time that a judge might wish to properly take into account that we cannot, in particular in relation to a panel that is before him, a case that might be already of some age, and the need to find a jury out of that panel so that the case can commence. We're not going to be placed in that position. This court would not have that insight. And so it would be wrong in our submission to conclude that simply because there might have been an argument to exclude a particular juror, that would necessarily be a justification for doing so now. And we certainly, when we come to look at the number of the jurors that were stood by in our case, will be arguing that that is the position. I mean, an obvious example is that in a case where there is no challenge to the police evidence, then the fact that one of the potential jurors is the wife of a policeman is neither here nor there. Yeah, it seems to us. Whereas in another case, it might be crucial. You've identified this person as the wife of a policeman. There's a wholesale challenge on the police evidence, and you might think that it would not be fair to have the wife of a police officer on the jury. So there may be any number.
Assume that the Crown stands by somebody they know to be the wife of a policeman, and they don't want to reveal in public that she is the wife of the policeman, but they know she is, and she is, and they say stand by.
Yes.
And let's assume she's number 4, or doesn't matter, whatever number she is. Can they adduce evidence subsequently that the reason why they did that, although they didn't say it at the time, was because she was the wife of a policeman? And that therefore either there's been no miscarriage of justice or no substantial miscarriage.
Well, I think you might get to the substantial, you might, and that'd be a matter for you, or the exercise of your judgment. What I would argue would be that if that were the case, the right and proper way to deal with it is to put it down. There's a procedure that can properly be followed here. If there is a real concern that you don't wish to disclose this individual is the wife of a policeman, there's no reason at all why counsel can't, as has happened, as Mr. Mahoney's identified on a number of occasions, they lean across to counsel and say, look, this is the position here. And there may not be any argument at all. There may not be any argument, and it can be made perfectly clear by agreement.
I'm sure it can be done. I'm sure it can be done, but we are concerned with circumstances in which it wasn't done, whereas it could have been. Well, yeah. And I'm still not clear whether, in the example that I've given, she is the wife of the policeman, and the police evidence is being heavily criticised, and the Crown, for reasons good, bad, or indifferent, simply asks her to stand by. Whether, when it is said that she was one of the excess standbys, the Crown can say, well, I know we didn't say so at the time, but this was the position, and that was entirely justifiable on our part.
Yeah, but herein lies the problem, because as I said at the outset, it's not just the one juror each time, it's the overall impression created. And the fact is, that is number 4. What happened to the other 3?
Yeah.
There was no proper basis for them to challenge at all. You're entitled to do that, but if you're going to use them up that way, then that's your problem. And let's be clear, there is a list provided to all of us in advance. They know who's on that jury panel, just like we do. And it is often the way that that list will disclose a name that you know can't sit for whatever reason. Mm-hmm. And it's simply inviting that person to stand by. It's not one. It's It's 1 out of 4, and there've been 3 for no good reason.
Right.
Can I remove myself from the firing line now?
You may. You may.
Thank you, my lord.
Where have we got to? I think Ms. Greening, did you want to make any observations, or are you happy to adopt what's been said already?
Yes, good morning, my lord. In relation to the question that his lordship asked yesterday about well, what Mr. Lynch has been answering this morning. Yes, I have a couple of comments to make. I shouldn't be more than 10 minutes.
Fine.
These are my thoughts about this, and I have thought about it overnight since the question was posed. We must remember, and I'm sure that we all do, that this is an extremely unusual situation that we're in. And as happens occasionally in the law, we have reached a crossroads, as it were. By and large, we can all agree, I think, that the adversarial system provides balance and fairness in the criminal justice system, but Section 519, the old Section 519, has finally been seen for what it is, which is entirely out of place and out of keeping with what we are doing globally in terms of progression, equality, and getting rid of these power imbalances and perpetuations of inequality. We cannot look at this appeal in my submission, with these appeals, without looking at the historical roots and context within which the Section 519 provision was in the criminal code in the first place, which, as I submit, is one of discrimination. It was designed to perpetuate power imbalances, which include racism and classism. So when I use the terms racism and classism, racism in particular in Bermuda, I'm not suggesting that we look at the jury under a magnifying glass and say, oh, this one was black and this one was white. I'm just talking about the general context in which this provision historically was put into our system. This unlimited right of standby and abuse of the provision, which is in my submission, has been in my submission, what has happened, which has been abolished now because of its unconstitutionality and appearance of bias, cannot be seen in any other light than to discriminate. It flies in the face of the right to a fair trial and the right and the well-known principle or phrase to be tried by one's peers. Those two things, Section 519 and these principles that accused people believe that they're coming to trial under these principles are not consistent. I don't know if his lordship is aware, but in the trial for Governor Sharple's assassination in 1977 here in Bermuda, the prosecutor was actually allowed and entitled to select the entire jury himself, and the accused was convicted and sentenced to death. Now that sounds extreme, but I raise that because obviously, well, I would think all of us agree that that was entirely unfair back then, but it sounds shocking, but it's not that far away really from what was happening up until this Section 519.
How did the prosecution manage to select the entire jury? Did it just sort of stand by people?
I think he was entitled to select the entire jury himself.
Miss Greening, I thought the position was that they had a special jury in that case.
Yes.
And the special jury meant that you actually had a different pool of jurors.
That's correct.
I'm not sure that the prosecutor was in fact entitled to select the jury.
Well, there was a special jury in which there was a special pool put together for that trial, and so.
I mean, I was here and I do remember that. Yes.
Yes. Certainly. I mean, it's not that far away from what's happening here. Certainly, in terms of its appearance, and we've been turning a blind eye for decades. lawyers that have been here doing trials for decades are embarrassed now that they have, lawyers that are even here in this appeal are embarrassed that they never thought or had the courage or whatever to stand up and make the constitutional application that Mr. Pettigill and I did at the Trott trial. And so it would be entirely, well, with the greatest of respect to this honorable court, it would be unlawful not to apply the correct test for fear of the consequences. I've made lengthy submissions last week on the correct test, and I submitted, importantly, for this submission, inter alia, that the saving provision in the Amendment Act now, 2020 Amendment Act, clearly allows for appeals where something more than a new law replaces an old law. And I think that's accepted by the court, and that's what we're discussing now. What is that something more? This is in line with Mr. Lynch's submission on the requirement for evidence. These are fact-sensitive appeals, hence the affidavit evidence that was submitted and what's coming later today, hopefully. This is why my client's second affidavit made specific reference to Mr. Musselden being present at the jury selection process, because he was the director of the DPP when I filed when the affidavit was filed. I was trying to force him to file his affidavit evidence in reply, but then he went off to be a judge, and obviously it's not appropriate for him to do that now. But I was just acutely aware of the fact that this is a fact-sensitive situation that requires an analysis and consideration, careful consideration of the facts in each case.
Could you just write? You said that you're summarising your submission by saying the saving provision clearly allows for an appeal where something more than.
Well, I was calling it technical. I was calling it technical appeals from the Johnson case, which says that it eschews technicalities.
Right.
But if you look at the Joggi and the Ruddock and Joggi case, yeah, it talks about it has to be more than a new law replacing an old law. Substantial injustice is only demonstrated where something more than that can be shown on the fact.
Yeah. Right.
I mean, another example that comes to mind is, and I always refer to Scotland because that's where I trained, but it's sort of like saying that only women who have been sexually harassed moving forward can benefit from the Me Too movement. And I know that in Scotland particularly, there are literally thousands of lawyers and judges now working full time on the backlog of historical sexual abuse cases that we now know and accept need to be dealt with for justice to prevail. It wouldn't be on at all to say, well, yes, it's just going to be far too difficult for us to set up these committees and special courts to deal with what you're now coming forward to report to the police. I'm sorry, but it will have to only be people that are sexually harassed or abused moving forward. Unfortunately, that's where this court finds itself today, in a situation where we hadn't until recently realized how out of place Section 519 is with the Constitution. We have realized it, the Chief Justice has realized it now, and we're going to have to apply this honourable court will have to apply the correct test, and that test has been carefully laid out in my previous submissions.
In that regard, Ms. Greening,
I'm sorry?
Having regard to your last point, that this is a fact-sensitive exercise.
Yes.
Are you not implicitly accepting that where the Crown had exercised more than 3, that as a matter of fact must be regarded as a breach of the constitutional right? Indeed, that is what I understood your primary submission to have been. Well,
in my particular appeal, it's not a matter of more than 3. So I do agree that where there's more than 3, the court that will get the appellant past the leave stage. It will get the appellant past the test of substantial injustice, and then then the court will need to apply, as Mr. Lynch has said, the Section 21 miscarriage of justice test, and decide what the appropriate disposal of the appeal is after that. So yes, but I'm also in my submission saying that where constitutional unfairness can be demonstrated, i.e. an appearance of bias, where the law makes it clear that real bias, and there is no difference between real bias and an appearance of bias, where the facts in a particular jury selection process can show an appearance of bias. For instance, in my case, where 33 were stood by, 13 of which were stood by with absolutely no explanation whatsoever. It only came to light later on when the second standbys were being called out by the judge that there were reasons and excuses for those recalled standby jurors not to sit. The test of the appearance of bias can be made out. So yes, my lord, to answer your question, the answer is yes, but there are other examples as well than the numbers threshold that would, in my submission, demonstrate substantial injustice and lead to a miscarriage of justice. So in conclusion, my little history lesson is just to remind the court that it is not appropriate. In fact, I would be as bold as to submit that it would be unlawful for this court to do anything other than to apply the correct test and to disregard the consequences, because that would be entirely unfair and fly in the face of what we're trying to achieve here.
Yes, I follow what you say, that the fact that maybe one may have opened a complete Pandora's box doesn't entitle one not to comply with the law and to apply some incorrect test.
I think the words, I tried to write down what His Lordship said yesterday, and I appreciate that His Lordship was just thinking out loud.
Yes.
The practical reality is that the likely test has to be much higher because of the deleterious effect of the public interest. And that's where my ears pricked up, and I started to jot down my notes to say, we can't change the test. We can't raise the standard just because we're worried about the consequences.
No. But you said, I follow with that submission. You said a moment ago, this was a fact-sensitive exercise, but where there were more than 3 standbys, that would get the appellant past the leave point and the substantial injustice point, which is really the same. Well, under leave, he'd probably have to show that there was an arguably a substantial injustice. And then the question would be whether there was a substantial injustice. And then you have to apply the substantial miscarriage of justice test. But if before you get to the substantial miscarriage of justice test, you've already decided that there was a substantial injustice, quite difficult to see how the substantial miscarriage of justice takes one any further.
My lord, in fairness to the other appellants, because the facts relating to my appeal with Mr. Roberts do not deal really with that threshold, it might be fairer for the other lawyers to answer that question, because they have been thinking very hard and carefully about the numbers threshold, whereas I have been thinking very hard and carefully about the appearance of bias and how that fits into the Constitution.
Okay.
So I wouldn't want to start making submissions that I haven't really properly thought about as hard as Mr. Lynch and Mr. Pettingill have, because it relates to their appeals as opposed to mine.
Yes. Right. Thank you very much. Now, where have we got to? I think we've got to Mr. Mahoney.
Yes, I should have said.
My lords, I will not be too long because of my arguments were submitted last week.
Yes.
But I just want to start out with the, since all three appellants through their attorneys place a lot of emphasis on the reasonable observer and what the test would be and so on. I wish to start out by going back to the what would appear to be the locus classicus case of Miller and Dixon again and versus Elgin. And just to briefly state that the circumstances of that case is different from these appeals. That case is more in line with the Canadian case of, or cases of Cantor and Sanson and so forth, where they are referred to be in the system. If one look at the case itself, paragraphs 1 to 4 of the case.
Just a moment.
Yes, sir.
You know-
It's at page 98, Joint Bundle of Authority.
Thank you.
Sorry, what page? What paragraph?
1 to 4.
So, sorry, which paragraph?
First paragraph.
The first paragraph, okay.
Yes, sir. Each of these four appellants, the accused, was the subject of criminal proceedings before a temporary sheriff between the 20th of May 1999 and the 11th of November 1999. Mr. Miller was convicted on indictment of drug offenses in the sheriff court at Elgin on the 27th of August 1999 and was sentenced on the same day to a term of imprisonment. Ms. Payne pled guilty to assault and other offenses in the sheriff court at Dundee on the 16th September 1999 and was sentenced to a term of imprisonment on the 12th of October 1999. Mr. Stewart was summarily convicted of driving offenses in the sheriff court at Dundee on the 16th of February 1999, but appeared in the sheriff court again after the 20th of May 1999 on the 28th of June 1999 and was then sentenced to non-custodial penalties. Mr. Tracy was summarily convicted of offensive weapon and assault offenses in the sheriff court at Dundee on the 23rd of September 1999 and was sentenced to a term of imprisonment on the 8th of November 1999. All the accused were represented by solicitors. It was on the 20th of May 1999 that Section 44(1)(c) of the Scotland Act 1998 came into force. The Lord Advocate thereupon became member of the Scottish Executive. As such, by virtue of Section 57(2) of the Act, he had no power to do any act incompatible with any of the convention rights defined in Section 1 of the Human Rights Act 1998, unless the act in question fell within Section 57, subsection 3. It was on the 11th of November 1999 that the High Court, Lord Justice Clark Cullen, Lord Prosser, and Lord Reed gave its decision in Stars and Roxton and Stars, holding that temporary sheriffs were not an independent and impartial tribunal within the meaning of Article 6, subsection 1 of the European Convention on Human Rights. Before the High Court and again before the board, the accused made the same very simple complaint that the Lord Advocate, thus the respondent procurators fiscal, who conducted the prosecutions, acted incompatibly with the convention right of the accused under Article 6, 1 by prosecuting them, etc. In a nutshell, sir, these are actually cases in which this was their appeal. This was not a case in which they had actually appealed. There was a conclusion of litigation, and they are seeking to reopen their appeals.
Yes.
So this was not a case of res judicata in the sense. And that's why I say this was the kind of case that was more in line with the Canadian case of Cantor, where there is reference to matters or cases that were in the system when the law is changed.
Yes.
And So I've also did some research on the case, and I've noticed that in none of the practitioners' handbooks that we have is Miller referred to as a case that deals with the finality principle or a change in law case. It is not referred to as an exception. It doesn't fall under any of those categories. And
sorry, sorry, I'm not quite sure that I'm following you.
Yes, sir.
They were all summarily convicted, and that was in the end of 1999. That's in paragraph 1.
Yes, sir.
But then there was an action in the High Court saying that the Lord Advocate had acted incompatibly with the convention right. So this was seeking to reopen the case, was it?
This was these were the matters appealing. They went on appeal, and that's why we based on the change in law. But none of these matters had actually gone on appeal before. So the law.
I'm sorry.
Yes, sir.
Were the proceedings before the High Court on appeal from the sheriff?
Sir, they actually appealed based on they appealed to the High Court.
Yes.
Based on the Stars case.
Right.
There is no suggestion that they had actually appealed their convictions before or sentence. So this was their first appeal.
Yes.
I think paragraph 72 assists that point that I'm trying to make at page 133.
Yes. Right.
The appellants in 3 of the 4 appeals before us have been convicted and sentenced by temporary sheriffs during the period between 20th May 1999 and 11th November 1999. In the 4th case, Stuart, the proceedings began and the convictions occurred
right.
20th of May 1999, but the proceedings continued after that date, and the sentence was imposed on the 28th of June 1999. So these appeals only relate to matters after the 28th of May. In one case, Miller, the proceedings were on indictment, while the other 3 cases were summary proceedings. In Payne, the accused pled guilty and was subsequently sentenced. In Tracy, the accused was found guilty after trial and subsequently sentenced. The 4 cases represent different situations, but all give rise to the same problem. Following on the ruling in Stars, the appellants sought to have the effect of that decision applied to their own cases. So there is nothing there indicating that they this was their first appeal.
Yes. Right.
The cases now before this court are actually seeking to reopen their appeal.
Yes.
This case, Miller, is not an authority to be relied on in respect of the finality principle. In other words, reopening an appeal that has already been concluded.
Right.
And I've just gone on to say that in all the practitioners' handbook, in all the legal search system, this case is not cited or referred to in anything to do with finality principle or the right of appeals. It is really an authority that deals with apparent bias.
Mr. Mahoney,
yes, sir.
To be understood, to be saying, are you, that these appeals should not be entertained despite the amendment law because of the finality principle?
That is so, sir.
That is what you are saying?
Yes, sir.
I didn't understand that to have been your position before.
In my position, sir, I thought My apology. I thought that was my position from last week.
So they shouldn't be entertained at all. They are precluded by the finality principle. That's what you're saying.
Yes, sir.
Yes, well, that is what I understood you to say. And there are a number of non-English and non-Scottish cases which appear to have a particularly strong application of the finality principle, in particular the Canadian cases, which say that once you're out of the system, everything is final.
Yes,
But in England, as appears from Joji, the finality principle is not, as it were, final, because there is an exception to the finality principle, because the court may give leave if not to apply the law as it has been said to be would or might produce substantial injustice for the appellant or the applicant. That's your problem.
well, I'm aware of that, sir. However, I do notice that there is I noticed counsel, Mr. Lynch, had indicated that there should be a test in that once you go over 3, there should be some evidence to justify why there was standby over 3, which is a problem, because at the time, the law was that the Crown could stand by prospective jurors, and I'll come shortly to that when I take the court through the Blackstone provisions. And there was no requirement to provide a reason. Then there was a change in the law, and in effect, counsel is arguing that the law should apply retrospectively, requiring prosecutors to now provide reasons for standing by jurors when at the time of the case, there was no provision for them to provide reasons. And that is why I'm submitting to this court that that should not be the law, because the law is a change in the law does not apply retrospectively.
Well, sorry, we go round and round in circles. You say, I quite follow what you say, that you weren't required to give reasons at the time, and therefore didn't give reasons. And the law should not apply retrospectively, in effect, to compel you to do so, or to say that you lose if you didn't or don't. And if there was an absolute provision about retrospectivity, you would be entirely right. But the difficulty I keep on coming back to is that the principle of retrospectivity is not absolute. And if the position is that what happened a long time ago was unconstitutional, it's difficult to say that it shouldn't be regarded as a substantial injustice because what you were doing was in accordance with the law at the time, although that law was unconstitutional.
Yes, my lord. However, the case law are quite clear in that mere change in the law by itself does not open the door.
I know that.
Yes, sir.
Yes, sir. But the problem, sorry, we are really going around in circles. A mere change in the law doesn't alter the position. But if the court comes to the conclusion that it would be a substantial injustice to the accused if he continued to be dealt with under the old law, it may reopen the case and apply what under the Constitution was always the provision of the Constitution, and what under our common law system is to be treated as having been the law at the time, although only revealed subsequently.
Well, my lord, I've already, unless the court wants me to go back over all my submissions that I made last week,
Yeah.
and by the submission, sir, that actually all three of these cases are just seeking to have the conviction overturned on the mere fact that the law has been changed and that the Crown stood by in excess of 3 persons without more. For there to be substantial injustice, there have to be something more than just the mere numbers. If it was an example, for instance, it turns out that apart from that, there was a situation where the judge knew the 4-person, and there's some evidence of that there was some discussion. That's another example of a substantial injustice, which is something separate and apart from just the mere numbers.
Well, you see, that is what I rather thought your argument was, that it has to be something more than just the mere numbers. Indeed, that is what the saving provision says. But it doesn't go so far as to say that a change in the law shall have no retrospective effect, so as to preclude a revision of these particular convictions.
Yes, sir. However, the actual change in the law, sir, based on the authorities is that the law does not operate retrospectively. You have to have something more. I don't know if the court is not understanding me, but the authorities suggest that mere change in the law by itself is not enough. If there is something more, the court will be entitled to go back and review the case in respect of that something more.
But in that regard, as I understood one of Mr. Lynch's point, in a sense, you could regard this as an appeal based on there having been a breach of the constitutional right to a fair trial, not simply a change in the law.
Sir, but that is part of the development in the law. And even in Ruddock and Jogi, they made reference to authorities that indicate that even where a provision has been declared unconstitutional, it doesn't operate retroactively.
Does Jogi say that?
Yes, sir. Paragraph, I think is 100 or 101.
Ryan, where Jogi is to be found?
I'm sorry, so I did not anticipate that I would have to go back over the submissions I did last week.
It's in the supplemental bundles of authorities. Pages 34 to 71 of the Judge's Supplemental Bundle of Crown Authorities.
Thank you, sir. So paragraph
Oh, yes, I see.
100.
Just a moment.
That's one we've been taken to before.
Yes.
Yes, sir.
Can you tell me what page it's on?
It's at page 67.
Yes. Right.
Made reference to cases of Contextual and Fletcher.
Well, wait a minute. Let's just see what it says. I remember this. The effect of putting the law right is not to render invalid all convictions which were arrived at over many years. The error identified of equating foresight with intent to assist, rather than treating the first as evidence of the second, is important as a matter of legal principle, but it does not follow that it will have been important on the facts to the outcome of the trial or to the safety of the conviction. Moreover, where a conviction has been arrived at by faithfully applying the law as it stood at the time, it can be set aside only by seeking exceptional leave to appeal to the Court of Appeal out of time. That court has power to grant such leave and may do so if substantial injustice is demonstrated, but will not do so simply because the law applied has now been declared to have been mistaken. So the proposition for which Joji stands is that basically the fact that you were convicted under the old law doesn't mean that you're entitled to have your conviction set aside, but it can be set aside if you get exceptional leave, and the court has power to do that if but only if substantial injustice be demonstrated. So Joji is not authority for the proposition that the new declaration of the law never applies to old cases. Doesn't say that.
May I continue, my lord?
Yes.
This principle has been consistently applied for many years, nor is refusal of leave limited to cases where the defendant could, if the true position in law had been appreciated, have been charged with a different offense. An example is Ramsden, where a defendant who had been convicted of dangerous driving before Gosney had held that fault was a necessary ingredient of the offense, was refused leave to appeal out of time after that latter decision had been published. The court observed that alarming consequences would flow from permitting the general reopening of all cases on the ground, that a decision of a court of authority had removed a widely held misconception as to the prior state of the law on which the conviction which was sought to appeal had been based. No doubt, otherwise, everyone convicted of dangerous driving over a period of several years could have advanced the same principle. Likewise, in Mitchell, Lord Justice Godfrey Lane restated the principle thus: it should be clearly understood, and this court wants to make it even more abundantly clear, that the fact that there has been an apparent change in the law, or to put it more precisely, that previous misconceptions about the meaning of a statute have been put right, does not afford a proper ground for allowing an extension of time in which to appeal against convictions. For more recent statements of the same rule, see Hawkins and Cottrell and Fletcher, and Sir Igor Judge, R&R. Together, the case is referred to. I would just, in regards to Cottrell and Fletcher, if one goes to Queen and Bestel, there are extensive quotes from that case in Bestel, which is located at, Bestel is at page 1.
Yeah.
Take the court to paragraph 11.
Mhm.
Change of law cases on the principle of finality. In the Queen and Mitchell, the defendant was convicted of possessing cannabis with intent to supply. He was granted leave to appeal against sentence. In the meantime, the Court of Appeal held in Queen and good trial that cannabis within the meaning of Section 37, subsection 1, Misuse of Drugs Act, did not comprise merely the leaves and stalk of the cannabis. Possession was unlawful only if it was of those parts of the plant from which resin could be extracted. On appeal against sentence, it was demonstrated fortuitously, since the prosecution's expert happened to be in court, that the defendant had been in possession of parts of the plant from which no resin could have been extracted. The defendant applied for an extension of time within which to appeal against conviction. Lord Justice Lane, later Chief Justice, acknowledged the principle of finality applied by the court in the Queen and Ramsden, in which the court declined to reopen out of time a conviction for dangerous driving following the Court of Appeal's decision in the Queen and Gosling, that driving is dangerous only if the driver was at fault. However, the court was informed that the defendant was about to complete a concurrent sentence imposed for handling stolen goods. If no action was taken, the defendant would be required to serve a further sentence of imprisonment in respect only of an offense which, under the change law, he had not committed. In the circumstances, the court exercised its discretion to permit an extension of time. Lord Justice Lane said, "This seems to us, therefore, to be the very rare case where the court should exercise its undoubted discretion to allow the extension of time and grant leave to appeal against conviction. We wish to make it clear, however, that this is not to be taken as an invitation to all and sundry who have been convicted of this type of offense to present application to this court for leave to appeal out of time, because they will not be granted with very much enthusiasm." Mr. Andrew Mitchell, excuse me, sir.
Sorry, Mr. Mitchell.
Mitchell, QC, on behalf of the prosecution in Mr. Bester's application, submits that the Queen and Mitchell would be decided differently today. The defendant had been convicted properly under the law as it was understood at the time of its trial. The appeal against sentence was before the court. It is more likely, Mr. Mitchell submits, that if Queen and Mitchell were to be decided today, the court would allow the appeal against sentence, quash the sentence of imprisonment on the possession count, and impose in substitution an absolute or conditional discharge. The court would recognize the need to prevent at least the appearance of injustice. That need could be met by applying the principle of finality, but ameliorating the effect of its application. Having regard to our examination of later decisions of both divisions of this court, we're inclined to accept Mr. Mitchell's submissions. The Queen and Hawkins Paul, the court was considering the consequences on other previously completed cases of a change in interpretation of Section 15 of the Theft Act 1968 by the House of Lords in the Queen and Credit. The defendant was seeking an extension of time, 7 months, in order to take advantage of the change in the law. The court refused the extension of time, concluding that on the facts, there had been no substantial injury to the applicant because his admitted dishonesty would have permitted other charges under the 1968 Act and the Theft Act. The court accepted the submissions made on behalf of the prosecution described by Chief Justice Lord Bingham in the Queen and Hawkins.
Mr. Mahoney, forgive me interrupting you, but forgive me interrupting you.
Yes, sir.
I wonder if we could go on to the passage which really matters.
That's what I'm going on to, sir.
Well, where are you going to?
It's right under Lord Bingham, Chief Justice Lord Bingham observed at page 240.
Well, that's not what I was referring to. Well, okay. Read out, but well, what Lord?
May I continue, sir?
Yes.
That practice may on its face seem harsh. On the other hand, the consequences of any other rule are equally unattractive. It would mean that a defendant who had wrongly and unadvised accepted that he had acted dishonestly and fraudulently and pled guilty, or who had been found guilty and chosen not to appeal, would after the event seek to reopen the convictions. If such convictions were to be readily opened, it would be difficult to know where to draw the line or how far to go back. Counsel on behalf of the applicant suggests that there is a readily available line of demarcation which would distinguish those serving sentences from those who had completed their sentences. That, however, would not, in our judgment, be an altogether satisfactory line of demarcation in the case of those who are serving sentences for other offenses, as well as for offenses against, in this case, section 15, subsection 1. It is plain, as we read the authorities, that there is no inflexible rule on this subject, but the general practice is plainly one which sets its face against the reopening of convictions recorded in such circumstances. Counsel submits, and in our judgment submits correctly, that the practice of the court has in the past, in this and comparable situations, been to eschew undue technicality and ask whether any substantial injustice have been done. In suggesting that there is and has been the practice, reference has been drawn to the Queen and McHugh.
I'll just pause there for a moment.
Yes, sir.
What Lord Chief Justice Bingham is saying is that there is no inflexible rule about seeking to appeal when the law has been shown to be different, but that counsel submits, and in our judgment submits correctly, that the practice of the court has in the past, in this and comparable situations, been to eschew undue technicality and ask whether any substantial injustice has been done. In other words, what he is saying is that you can have a review of, I can't remember whether this was a sentence or a conviction, on account of the law being subsequently changed, not as a matter of course, but if substantial injustice had been done.
Yes, sir. However, if you look at all the principles together, as Ms. One cannot just use the technicality of the change in law to say, well, that's sufficient, that equates to substantial injustice.
Right. I follow that.
Yes, sir. If we go further down to, there is a paragraph, similar considerations arose in the case, the appeal of R&R.
Yes.
In which the defendant sought an extension of time in order to take advantage of a decision of the House of Lords in the Queen and saw that to establish guilt of conspiracy to commit an act of money laundering, the prosecution was required to prove an agreement and therefore an intention to deal with money whose source was illicit, not merely that the source of the money might be illicit. The court held that the defendants would have had no defense to substantive offenses in which proof of suspicion was enough, charged on the same facts, and extension of time was refused. Lord Justice Hughes considered several of the authorities on the issue of extension of time following changes in the law. He said at paragraph 30, it is very well established practice of this court in a case where the conviction was entirely proper under the law as it stood at the time of trial to grant leave to appeal against conviction out of time only where substantial injustice would otherwise be done to the defendant. The Queen and Lesser is an early example of emphasis that absent special reasons and application out of time will not be allowed. Paragraph 36, Lord Justice Hughes noted in the Queen and Counsel, the House of Lords had recognized the practice of the Court of Appeal, but the particular construction of the Human Rights Act apart, it is clear from both the speeches that this court's practice to grant leave out of time only where substantial injustice would otherwise be done is recognized and indeed is endorsed.
Right. Well, there is the principle stated twice.
Yes, sir. And in Contextual, paragraph 15, sir. Lord Justice's statement was approved by Sir Igor Judge in the Queen and Contextual, which he said at paragraph 46. In short, the principle is that the defendant seeking leave to appeal out of time is generally expected to point to something more than the mere fact that the criminal law has changed or been corrected or developed if the appeal is effectively based on a change of law and nothing else, but the conviction was properly returned at the time after a fair trial, it is unlikely that a substantial injustice occurred. And all I'm saying, sir, is that these appeals effectively are just based on the change in the law. And that's why there is all these submissions about numbers over 3. But to borrow Miss Greening's word, these are just technical appeals. You count, we're over 3, appeal should be granted. Or appeal allowed, sorry.
Well, Mr. Mahoney, to the extent that they could also regard as fact-sensitive appeals, as Ms. Greening also said, are you maintaining that they are treated nonetheless by the principle of finality? Which, as you have
I didn't hear the last part of what you said.
Do you still maintain that, notwithstanding the acceptance, it seems, by all defense counsel, that these may involve fact-sensitive inquiries, that they would nonetheless be precluded by the principle of finality as you regard it? And notwithstanding that, of course, as we have just seen from the passage you have brought to our attention, it's not an absolute principle. It allows for appeals where there may have been substantial miscarriage of justice.
Yes, sir. I agree that it is not an inflexible rule. However, the mere fact of the numerical difference by itself, as per what I just read, is not sufficient ground for substantial injustice.
Yes, well, that is what I always understood you to be saying.
Yes, that's all I'm saying, sir.
One might regard the proviso to the amendment as saying the same thing.
And that's why I'm also submitting that the suggestion that one should go and do the math on the numbers, and then over 3, the Crown, there is a evidential burden being placed on the Crown to respond if they choose to explain, cannot be right. Because at the time when these trials occurred, the law was that the Crown could stand by persons, unlimited number, without giving an explanation. To enforce that requirement on the Crown now, in effect, would be seeking to apply the effect of the change in law retroactively to something that was legal and proper at the time. Especially memories, I'm not sure if we had court smart in regards to some of the cases. I'm not sure for how long the recordings are kept. I'm not sure if some of the prosecutors are here or some of the players are still here. And even if they are still here, we're talking about memories. So if such a burden is placed on the prosecution, in effect, everybody is at liberty to have their conviction overturned because it comes down to a memory game. I could just briefly bring to the court's attention, there is an authority that I came across that dealt with the applicable test for apparent bias. I'm just going to read the help.
Can you tell me its name?
It is BOI and BOJ.
Oh, yes.
I'm not sure exactly where it is. Please.
Yes, we've got that somewhere.
It's located in the joint authority bundles, my lord.
Thank you.
This is the Singapore case, Mr. Mahoney?
Yes, it is. Its citation is 2019-3 Law Report of the Commonwealth, LRC. And I'm just just looking at the held of what was held in the interest of time. It was the applicable test for apparent bias was whether there were circumstances that would give rise to a reasonable suspicion or apprehension of bias in the fair-minded and informed observer. On a substantive level, there was no material difference between the reasonable suspicion of bias test and the real likelihood of bias test. Indeed, it was difficult to see how a reasonable person might reasonably suspect bias without considering that there was a real likelihood of bias. However, there was both conceptual and practical merit in adopting a standard terminology. As the test for apparent bias involve a hypothetical inquiry into the perspective of the observer or what the observer would think of a particular set of circumstances, the test was necessarily objective. A reasonable suspicion or apprehension arose when the observer would think from the relevant circumstances that bias was possible. In establishing whether the observer would harbor a reasonable suspicion of bias, the court had to be mindful not to supplant the observer's perspective by assuming knowledge outside the ken of reasonably well-informed members of the public. The reasonable observer would also be informed. While the observer should not be taken to have detailed knowledge of the law or court procedure, he or she would be apprised of all relevant facts that were capable of being known by members of the public generally, and he or she would also be able to consider what had been seen or read together with its proper context. The observer would also be fair-minded. He or she would be neither complacent nor unduly sensitive and suspicious. He or she would know the traditions of integrity and impartiality that administrators of justice had to uphold, and would not jump to hasty conclusions of bias based on isolated episodes of temper or remarks taken out of context. The observer was the sort of person who always reserved judgment on every point until he or she had the traditions of integrity both sides of the argument. To establish prejudgment, which amounted to apparent bias, it had to be established that the fair-minded, informed, and reasonable observer would suspect or apprehend that the decision maker had reached a final and conclusive decision before being made aware of all relevant evidence and arguments which the parties wished to put before him or her, such that he or she approached the matter with a closed mind. I'm relying on this, sir, because I noticed that there is counsel in their submission would suggest that once Crown Counsel stood by a particular juror or number of jurors, the presumption would be automatically, I believe they're suggesting, that the reasonable observer would believe that that particular juror was stood down because they would be unduly favorable for the defense. In the context of a small jurisdiction like Bermuda, sir, that is not necessarily so. Because a standby may very well be in respect of someone who the prosecutor may be aware may be unduly favorable for the Crown itself. For example, in the case of that lady who was the HR representative in charge of the DPP's office, I think is Copeland or Copeland, can't remember. Yes, sir. I can't remember her name right now, but in such an example, sir. So in respect of the applying the test in the context of Bermuda, one cannot automatically assume that the reasonable observer will automatically conclude that a standby was because this person was going to be unduly favorable for the defense. On that topic, I would like to go to the Court of Appeal decision from Ontario, Canada, the case of the Queen and Chauhan. That is in the Joint Bundle of Authority at page 618. Paragraph 61, which is at page 638. And as the Honorable Court would recall, this is a case that went on appeal to the Supreme Court, but the written judgment is still unavailable.
And the Supreme Court dismissed the appeal, is that right?
No, the Supreme Court upheld the appeal. What had happened is that the Crown appealed to the Supreme Court because the Court of Appeal held that the particular section applied retroactively, not retroactively, did not apply to cases that were in the system before the change in law, abolishing parental rights.
And the Supreme Court said it was all procedural.
Yes, sir.
Yeah.
So the Crown's appeal was upheld and the appeal was refused. At paragraph 61, under the heading, the right of an impartial tribunal. Paragraph 62, to determine whether a tribunal is impartial, the question is whether a reasonable person, fully informed of the circumstances, would have a reasonable apprehension of bias. The informed person begins their analysis with a strong presumption of juror impartiality and a firm understanding of the numerous safeguards in the jury selection process designed to weed out potentially biased candidates and to ensure that selected jurors will judge the case impartially. The reasonable apprehension of bias has never hinged on the existence of a jury roll, or for that matter, a jury that proportionally represents the various groups in our society. The test for impartiality includes a twofold objective component. First, the observer. The person considering the alleged bias must be reasonable. The observer must be informed of the relevant facts and view the matter realistically and practically. The reasonable observer does not depend on the views or conclusions of the accused. Second, the apprehension of bias. That too must be reasonable in the circumstances of the case. In applying the test for impartiality, a court must be cognizant of the well-established and undisputed fact that racial prejudice can lead to a risk of empaneling prejudiced jurors who will not give a racialized accused a fair trial. As this court observed more than 2 decades ago in the Queen and Parks, leave to appeal refused. Racism, and in particular anti-Black racism, is part of our community's psyche. A significant segment of our community holds overtly racist views. A much larger segment subconsciously operates on the basis of negative racial stereotypes. Furthermore, our institutions, including the criminal justice system, reflect and perpetuate those negative stereotypes. These elements combine to infect our society as a whole with the evil of racism. See also Williams at paragraph 58. It is also an established fact that widespread prejudice affects juries. It introduces the risk that jurors may not be impartial because of racial prejudice. Partiality in the sense relevant to section 11D as both an attitudinal and behavioral component. Parks at page 364. In order to be partial, a juror must not only hold biased views, but also allow these to influence their deliberation.
Must not only hold.
Sorry, thanks, sir. Must not only hold biased views, but also allow these to influence their deliberation. Various in-court mechanisms are available to protect against juror bias and ensure the constitutional guarantee of an impartial jury is met. Notably, section 638, subsection 1B of the Criminal Code permits an accused and the Crown to exercise any number of challenges for cause on the ground that the juror is not impartial. The challenge for cause is a two-stage process. First, the judge must determine whether there is a realistic potential or possibility for partiality. Second, if the judge permits challenges for cause, potential jurors are questioned to determine if they will be able to act impartially. The in-court mechanism also protects against jury partiality. For example, section 632C of the Criminal Code permits the presiding judge at any time before the commencement of the trial, before or after the juror's card has been selected by the registrar, or before the prospective juror has been challenged, to excuse a prospective juror for reasons of personal hardship or any other reasonable cause that, in the opinion of the judge, warrants that the juror be excused. Under section 632C, the presiding judge may alert the entire jury panel about the nature of the offense charged and invite those who would find it difficult to be a member of the jury chosen to try the case to identify themselves. After brief inquiry, the judge may excuse jurors on the basis of personal hardship or any other reasonable cause. This authority is not a substitute for a challenge for cause and must not be used to circumvent the threshold required for a challenge for cause. This procedure also has the value of transparency. Another in-court mechanism is the standby authority of the presiding judge. Under the recently amended section 633 of the Criminal Code, the presiding judge may stand by potential jurors for personal hardship, maintaining public confidence in the administration of justice or any other reasonable cause. This standby authority is available after a prospective juror has been called under section 631(3) or 3(1), and thus is available before after challenge for cause has been heard and its truth determined. The language of personal hardship and any other reasonable cause duplicates that in the excusal authority of section 632C, but the language maintaining public confidence in the administration of justice is new, and as a matter of statutory construction, covers different ground. In this case, for example, the trial judge used it to direct a prospective juror who had been found impartial on the challenge for cause to stand by. The basis for his exercise was the appellant's belief, communicated to the trial judge through counsel, that a rude gesture had been made by the prospective juror when asked to face the appellant. We did not receive any submissions that would permit me to mark out the boundaries of this additional authority. Suffice it to say that its presence is of further assistance in ensuring the constitutional requirement and impartial jury. Additional procedures also exist to ensure that the actual and apparent impartiality of the jury as empaneled continues throughout the trial. The open instructions to the jury, periodic reminders about the need to keep an open mind and to withhold judgment until deliberations, trial and final instructions about permitted and prohibited use of evidence, and of course the charge to the jury. A final point concerns the role of representativeness in jury selection under section 11D and its relationship to impartiality. Representativeness is an important feature of the jury, but its meaning is circumscribed. Representativeness promotes impartiality through the process used to compile the jury roll, not through its ultimate composition. An accused has no right to a jury roll of a particular composition, nor to one that proportionally represents all the diverse groups in our multicultural society, nor to a particular number of persons of the accused race on the jury roll or selected jury. Just briefly, paragraph 91 to 92. I went through all of that to indicate that when one is looking at impartiality and randomness, one also have to look at the whole system and the structure, dealing with jury selection and so on, not just what happened in court. At paragraph 91, which is at page 647. Further, the standard applied to determine impartiality as well as independence is an objective standard. The question to be answered is whether a reasonable person fully informed of the circumstances and relevant considerations, viewing the matter realistically and practically and having thought it through, would conclude that the jury was not impartial. The fully informed person must appreciate the existence of racism in society, but the application of this standard does not depend on the subjective views of the accused. We recognize a strong presumption of juror impartiality, and we require cogent evidence, not conjecture or speculation, to rebut it. It is not rebutted by the existence of racism in society as a whole, nor by a determination that prospective jurors may be challenged for cause. Fully informed of the safeguards in place to ensure the selection of an impartial jury, and the in-trial mechanisms to ensure that the jury, once empaneled, remains so, the reasonable person would nevertheless have to conclude that, absent peremptory challenges, a jury would not likely decide the case fairly. No such conclusion would logically follow. And finally, paragraph 105, 106. 105 is at page 651. Section 11F of the Charter guarantees the benefit of a jury trial to an accused charged with an offense for which a maximum punishment is imprisonment for 5 years or a more severe punishment. A central component of this right is representativeness, which plays a larger role in the constitutional guarantee in Section 11F of the Charter. This is so because representativeness is a component of the right to the benefit of trial by a jury. But the meaning assigned to representativeness under Section 11F is the same as that allotted to it under Section 11D. Representativeness protects an accused's right to an adequate selection process. The state discharges its obligations of representativeness when it provides a fair opportunity for a broad section of society to participate in the jury process. An accused's right to the benefit of a trial by jury does not extend to proportionate representation at any stage of the jury selection process. Neither the process followed to compile the jury panel roll, nor the in-court process to select the jury to try the issues on the indictment. Again, the point is, sir, in looking at the jury selection process, one have to look at the whole range involved. Closer at home, I draw the court's attention to Blackstone, which is in the Joint Authorities bundle.
And whereabouts?
All right, I'm not sure of the page number, but at paragraph D 13.22.
Sorry, what page?
Can I proceed, sir?
Yes.
Oh, sorry. It is fundamental to the jury process that the jurors who try an accused are selected at random. That said, however, it is recognized that there will be circumstances in which the interests of justice require some intervention in that random selection process. The methods of replacing one or more of the prospective jurors called into the box as a result of the clerk's ballot with others from the jury in waiting are A, for either the prosecution or defense to challenge for cause, B, for the prosecution to ask a juror to stand by, C, for the judge to exercise his discretionary power to remove a juror. Continuing at D 1323, challenges for cause. A challenge for cause may be made by either the prosecution or defense. It is either a challenge to the whole panel of jurors known as a challenge to the array, or to an individual juror known as a challenge to the polls. At common law, either party could challenge the whole panel summoned for their case on the ground that the person responsible for the summoning acted improperly or was biased. Although this act is preserved by the Juries Act 1974, it is now almost dormant. Historically, challenge to the array was made when the sheriff responsible for summoning the jury had an apparent interest in the outcome of the trial. More recently, such a challenge is more likely to relate to the racial or religious composition of the jury. Specific malfeasance in the summoning was also a ground of challenge, as when jurors were summoned at the express request of prosecution or defense, or had been selected on grounds of their religion. We are not dealing with a case of challenge for cause. However, I have read that to show that, like in the Canadian situation, the case that we looked at in Chowan, one have to look in respect of randomness as a whole. And what happens in the courtroom, in the actual selection of the persons who will sit on the panel, sit on that particular jury as a part of a system as a whole. So it would be incorrect for us to isolate that portion that occurred in the courtroom and then pass pronouncement to say that it was biased and unfair. when the law is you have to look at the whole system together. And since I'm on the point, since race seems to play a significant part of the submissions of counsel, I'll continue to.
Sorry, just a moment, just a moment.
Yes, sir.
You say you have to look at randomness as a whole.
Yes, sir.
But just a moment, I've lost you. Oh, help.
I'm sorry, sir. I could repeat if you.
No, I'm sorry. I've. All right. You say that you have to look at randomness as a whole, but if the position is that the Crown, what happens is that the juror list is called, and they have been randomly selected. But if the Crown let's assume that amongst the first 5, the Crown stands by 2, 3. Well, let's assume among the first 10, the Crown stands by 4. That destroys the randomness. Does it not?
No, sir.
Well, if things had worked randomly, they would have been called. They would have been selected randomly, and they would have been called in some order. And that's what you'd get.
Well, my lord, that's why I read D1332.
D13.
In 22, sir.
Mm-hmm.
It's fundamental to the jury process that the jurors who try and accuse are selected at random. That said, however, it is recognized that there will be circumstances in which the interest of justice requires some intervention. The Canadian case suggests that randomness should be looked at in the round. From the time when the panel is struck and they are summoned and so on, rather than isolating it to what happened in the courtroom. But even so, in the courtroom, as per D1322, standing by a particular juror is an acceptable part of the process of random selection of the juror. Unless I'm reading the section wrong.
Right.
And I will move on to D1325, since race is going to, well, it is a factor, it seems, in these appeals. D1325, racial or religious composition of the jury. In the absence of evidence of bias or improper conduct by the person responsible for summoning, the jury panels being imbalanced racially or not, reflecting the overall racial or religious composition of the catchment area from which jurors are summoned, is not sufficient ground for challenge. See Danvers and Broderick, which were both approved by the Court of Appeal in 4. The principle of these decisions will apply equally to other apparent imbalances in the jury panel as to the proportion of men to women. And there is a further section that deals more
So wait a minute, I don't, Caroline, excuse me. Right. I don't understand it to be said the jury was not impartial because of its racial composition.
No, sir. However, there is an assertion that there was jury rigging or something along that line,
Yes.
or I can't remember the exact terminology used.
Fashioning the jury seemed to be.
Yes, sir.
But that yes, but it wasn't being said
being fashioned on racial lines.
I beg to differ, sir, because you'd notice that the examples being tossed about were young black men, black as opposed to white.
Mm.
How many blacks were stood down?
That was the position in Trot, Mr. Mahoney, but I don't think we've heard yet, at any rate, that was the position in respect of any of these three appeals, have we?
Well, sir, I think Miss Greening, in what is to come, there's an allegation of young black men being stood by because the prosecution or the prosecutor was fashioning the jury. Initially, Mr. Lynch last week, I think he has withdrawn that now, but initially there was some assertion of 4 black men, young black men being stood by in a row. Mr. Pettingill, in his submissions, relied heavily on Trot and was seeking to assert that there were 10 jurors who were stood down were mainly of Afro-Caribbean descent.
Yeah, in Trot.
Yes, sir. And in respect of that, sir, I have forwarded the respondent's affidavit in Trot so that the court will have a more balanced view as to exactly what transpired during the jury selection process in Trot.
That's your affidavit, correct, Mr. Mahoney?
Yes, that's my affidavit, sir.
Yes, that affidavit has been sent on to the members of the court. But my Lord President, I'm wondering if this is a convenient moment. We've been sitting for 3.5 hours now.
Yes, I think it probably is. Yes, I'm so sorry. Well, we'll adjourn and see you all in an hour. Thank you.
Thank you, my lords.
Thank you, sir.
I'm just waiting for the appellants to make themselves available.
Right.
Okay.
Are we all assembled?
Yes.
Yes, sir.
Yes. Mr. Mahoney, where's Mr. Mahoney?
Yes, sir.
Oh, yeah. I assume Miss Smith is available tomorrow, is she?
I'm not sure, sir, but she is. I could check, sir, and get back to you in about 15 minutes.
Could somebody do that for you?
Yes, sir.
I don't want to break for 15 minutes now.
No, not me. My colleague, Miss Kingdean.
Oh, Lord, I'll go and check now.
Right, thank you.
You're welcome.
Right. Okay.
Sir, just one question, sir.
Yes?
May I just get confirmation from Miss Greening that she will not need Mr. Pedro? Mr. Pedro has been waiting all morning. We did ask him to stand by in case.
Miss Greening?
Yeah, yes, good afternoon. I will not require Superintendent Pedro.
Okay, thank you.
Right. Yes, Mr. Mahoney.
Yes, sir. So I'm still on the Blackstone.
Yes.
The reason I'm going through all of this, sir, is so that we can have the actual principles, so that when we're going through the respective jury lists,
Yes.
we have the very quick with the principles that should assist us in understanding what happened and what should not have happened. So at D1326, at the last paragraph there, in the absence of any challenge from the parties, a juror may in effect challenge himself by stating, if be the case, that he is not qualified. The case referred to there is Cook. The summons sent to each juror is accompanied by a notice which sets out the ineligible and disqualified stuff and warns him of his duty to inform the court if he comes within any of them. I don't think we have that here, but the principle is that a juror may indicate to the court that they can disqualify themselves. Moving on to paragraph D1333, standing jurors by.
Yes.
You're right. This is a right possessed by the prosecution, but not the defense. Although in Chandler, Chief Justice Lord Parker observed that in an exceptional case, the judge could, in his discretion, stand by a juror or allow the defendant to do so. CRIM PR 25.83 provides that the prosecution must announce the exercise of its right before the jury completes the oath or affirmation. Standing a juror by differs from challenging him for cause, in that counsel need not give a reason for the standby. It differs from the peremptory challenges formally available to the defense, in that the juror is not conclusively removed from the jury, but will be recalled to the jury box should the entire jury panel be exhausted without a full jury being obtained, at which stage the prosecution must either accept him or show cause why he should not serve. In the leading case of Mason, 1981, Lord Justice Lawton, given the Court of Appeals judgment, summarized the position thus. In our judgment, Mansell and the Queen established beyond argument that prosecuting counsel have a right to request that a member of the jury panel shall stand by, and that this right can be exercised without there being a provable valid objection until such time as the panel is exhausted. And when it is, if the Crown still wants to exclude a member of the jury from the panel, a valid objection must be shown. Continuing, Lord Justice Lawton added a rider that he expected the prosecuting counsel would act responsibly and would not request a standby unnecessarily. Guidance as to the use of the right. Now, my learned friend, Mr. Pettingill, drew the court's attention to this particular area. However, I would add that in Bermuda, we don't have the Attorney General's guidance as exists in the UK.
Yep. Mm-hmm.
So I will not read what counsel already read before the court at the top of the 1334. I'll just go to 1335 since the previous section was already read. On the assumption that the guidelines are loyally followed, the importance of the right of standby has been vastly reduced. Counsel will exercise the right only in the tiny minority of cases which involve national security or terrorism, or ordinary cases where a juror is obviously unsuitable. Thus, the chief function of the right now seems to be to avoid the clumsy mechanics of a challenge for cause where the parties concur that a juror should. In addition to the example, I'll just pause here, sir. There was a part of the question as to what is the position if a juror is stood by after a note has been handed up or shared. I think the present legislation actually took that into account, whereby you can excuse a juror by agreement. It was not so termed prior to the amendment, but that was the practice where a note is shared between counsel, and more often than not, we usually agree. Not all the while, but more often than not, we would agree, and the person is stood by or stand down. Continuing, in addition to the example given in paragraph 5B itself, Reverend sir.
Mr. Mahoney, can I just go back to your last comment? Because you said that where there was an agreement with counsel that there would be a stand down, which I understood to be the same as a juror being excused for cause. Wouldn't it be necessary for the judge to either make that decision himself or essentially effectively bless the decision of counsel?
Well, sir, what normally happens is you may get a letter that is shared with counsel. Sometimes it's a bit ambiguous. You're not certain exactly whether the person should be totally excused or not. So for instance, in one instance, I think it was with Mr. Lynch in the matter that we had. I can't remember what it was, but when the letter was shared, I think the person had some illness or some medical appointment. We looked at each other. Counsel, by his facial expression, indicate he had no problem. We stood down that witness.
Yes, but that's the point.
Yes, sir.
You only have the power to stand by.
Yes, sir.
Shouldn't you invite the judge to treat the juror in question as excused?
I've done that on occasion, sir, but that particular judge may not necessarily wish to excuse at that point. You may, for instance, in the LeVeck Roberts case, there are one or two examples where even although we indicated that the person gave a letter, we said stand by, or the judge invited us to say stand by. We say stand by, the person comes again. And even on that basis, the judge said, well, I will not let you off at this point.
Right, but sorry,
Yes,
the example was where you had an agreement with counsel on the other side.
Yes, sir.
They would, quote, stand down.
Stand by, sir.
Sorry?
The practice was to say stand by the juror. I think properly the judge could have excused the person. Sometimes the judge do excuse the person at that point.
We can move on.
Yes, sir.
You used the term stand down, which is why I asked the question.
Oh, okay, sir. But sometimes the person is excused immediately, sometimes they are not.
Right.
Let's try and recap.
Yes, sir.
Under the new arrangement, you can excuse by agreement.
Yes, sir.
Right. What you were saying was that in the past, a note would be maybe shared between counsel, and it is agreed that the person is stood by, I think you mean.
Yes, sir.
So that has happened in the past.
Yes, sir.
Right.
But as I said, sometimes the judge will excuse the person on the spot. Sometimes the judge allows the name to come back a second time before a decision is taken to excuse.
Mm-hmm.
And we saw that most evidently in the LeVeck Roberts process.
Right.
At paragraph 1336, even in the absence of a formal challenge from either party, the trial judge has a residual discretion to exclude from the jury a juror selected by the initial ballot. The existence of the discretion can be traced back to Lord Campbell CJ's judgment in Mansell and the Queen. And I think that's where section 15, I think, of the Jury Act gives the judge a discretion to excuse jurors, independent of challenge for cause.
Mm-hmm.
Now I move quickly to D1338, which is racial and religious balance of jury.
1339.
Yes, 1339. I'll just read a head note and then go over to 1340 because the principles are set out under 1340. From time to time, judicial intervention has been sought to ensure that at least some members of the jury come from the same ethnic group as the accused. Although examples from the case law refer to the racial composition of the jury, the same principles have equal application to attempts to affect the religious composition of the jury. I will switch over to D1340, guidelines for approaching the issue. It is the latter view which was found favor with the Court of Appeal. In Ford, F appealed against his conviction on the ground that the trial judge had refused an application for a racially balanced jury. The main points established by Chief Justice Lord Lane's judgment are as follows. A challenge to the array of jurors summoned must be on the ground of bias or other irregularity on the part of the summoning officer. Therefore, the racial composition of the jury panel cannot of itself found a challenge or justify the judge in discharging the panel and ordering the summoning of a new one. B, summoning of jurors is a responsibility of the Lord Chancellor. It is not the judge's function to alter the composition of the jury panel or give directions about the area from which it should be drawn. Justice Wolf's direction in Bansal to the effect that the panel should be drawn from a part of the court's catchment area in which a high proportion of Asians live was made without benefit of full argument and was wrong. C, nor should the judge consider a complaint that the jury panel is not truly random because it contains a lower proportion of persons of a certain race or ethnic group than live in the court's catchment area for jurors, unless, of course, the disproportion can be attributed to bias or impropriety on the part of the summoning officer. If the disproportion may be due to maladministration in the procedures for summoning jurors, that must be corrected by administrative, not judicial intervention. D, the mere fact that a juror is of a particular race or holds a particular religious belief cannot found a challenge for cause by a party on the ground of bias. E, the judge may not use his power to stand by or discharge individual jurors selected in the ballot from the jury panel for the purpose of securing a jury of a certain racial mix. To do so would conflict with the principle of random jury selection. In effect, the judge would be altering the composition of the jury panel with no irregularity on the part of the summoning officer had been done and upholding a challenge when there was no ground in law for it. The judge's intervention should be restricted to the exceptional circumstances indicated in Mansell and the Queen. Insofar as the judge in Binns had been prepared to stand jurors by until a balanced jury had been obtained, he was in error. F, in short, there is not, as had been suggested in Fraser and Bansal, any principle that a jury should be racially balanced, and it is impermissible for the judge to use his residual discretionary powers over the composition of the jury as a device for obtaining such a balance. In Smith, the Court of Appeal considered the standing of Ford in the light of the HRA in 1998 and the ECHRR 6. It held that the approach in Ford had not been superseded by the HRA in 1998. Lord Justice Hill said, "We do not accept that it was unfair for the appellant to be tried by a randomly selected all-white jury, or that the fair-minded and informed observer would regard it as unfair. We do not accept that on the facts of this case, the trial could only be fair if members of the defendant's race were present on the jury. It was not a case where consideration of the evidence required knowledge of the traditions or social circumstances of a particular racial group. And in respect of the principle that attach to race and religious belief, I would also seek to add that the principles apply equally to gender and social standing."
Yeah.
D 1343. Checks for previous conviction. This may be more relevant to Ms. Greening's applications. The one inquiry that the prosecution are likely to make is into the criminal records of the panelists. This practice was approved by the Court of Appeal in Mason. In that case, the police provided prosecution counsel with the results of checks as to whether the panelists summoned at convictions. Counsel stood by certain jurors, some but not all of whom were disqualified by their convictions, without informing defense counsel of the reason. Lord Justice Lawton, given the judgment of the Court of Appeal, justified the police action as being part of their usual function of preventing crime, being an offense to serve on a jury and disqualified by convictions. Further, the court could see no reason why the information obtained should not be communicated to prosecuting counsel, who could then make such use of it as he considered fit. The practice of supplying prosecuting counsel with information about potential jurors' convictions has been followed during the whole of our professional life. It is not unlawful and has not until recently been thought to be unsatisfactory. Prosecuting counsel is under no duty to transmit the information to the defense, although he may do so if he so wishes. I will come back to Mason, sir, in dealing with Ms. Greening's application. With your client's affidavit. So I will go more in depth with that. But in closing, sir, I just want to address two particular points. Mr. Lynch indicated to this court that we get the jury list in advance. That is not so. We get the jury list on arrival in court. By the time we arrive in court, the prospective jurors are already sitting in court.
And all counsel get it at the same time, Mr. Mahoney?
We get it at the same time. So we have no advance notice as to who will be on the panel. And usually we have less than minutes to try and ascertain whether any person is here that is known or related to any police or anything like that. And
so I missed that last, I missed one of those words that I think is, you have minutes to decipher whether they're something or related to the police.
What's that?
Sorry to interrupt, but I think that that was important for me. You said that you have minutes to decipher whether the juror is something, I didn't hear that word, or related to the police.
Is known?
No, okay, thank you.
Yes. And I say or related to the police because we have had their jurisprudence in this court. I think there's a case of Terrence Smith, which a conviction was overturned due to the fact that some of the jurors were likely to have had some connection to parties in the case.
Well, I think you got to be careful, Mr. Mahoney,
Yes,
with
sir.
Terrence Smith, because in that case, as I recall, there was a specific assent to the jury, the juror in question serving by counsel for the accused, and the Court of Appeal said that that wasn't enough, that it needed to be, he needed to have instructions in writing.
No, I agree, sir, but because of that case, the principle emanating from that case, we are particularly cautious because the same principle apply across the board.
Well, yes, I can understand that.
Sure. And we have had instances where after conviction, for instance, I think it was, I can't remember the two cases, but where after the fact, there was some indication that one juror was possibly friends or connected with a police officer who was in the case. So situations like those are things that guide us in when we get the jury list, we have to make a quick assessment as to the possibility of any prospective juror being connected to anyone in the case. Outside of that, we have to rely on the honesty of the jurors, or if the police officer may indicate to us that this person knows me, this person is my wife, or so on. But I'll address the court further on that.
Right.
Plank of my submission was already made at the start, sir, and I don't wish to repeat it at this point. In effect, I'm submitting that we are back in the same position as the case of English, the Canadian case, which is on all point with the matter before this court, or the matters before this court.
Was that the case that said you have to be in the system in order to be able to rely on a change of the law?
No, sir. English was the case wherein after being in Canada.
Yes.
Right. So Jamaica Trot applied Tyson, which applied Bain with the equality of arms principle, and as it related to standby. And English, after Bain and the law was changed in Canada, English sought as a ground of appeal to say that in my case, the prosecution stood by more.
Yes.
Or more accurately, the prosecution had greater right of standby than what I had to challenge peremptorily. And the Court of Appeal shut it down.
Yes, but was that because in Canada, the finality principle doesn't have exceptions?
Excuse me, sir? I don't think so, sir.
Well, I'll have to look at it again.
Yes, sir.
Right. So can I just see where we've got to? You say that the mere fact that more than 3 were stood by is not is not an injustice.
No, by itself is not sufficient to pass the test of substantial injustice. I read that in one of the cases cited in Beston.
Right. So the mere fact that the more than 3 have stood by is not sufficient to pass the test of substantial injustice.
Yes, sir.
But so in order to pass the test, what do you need to do?
There have to be something more, sir. Something other than that point alone.
Whose onus of proof is that?
Excuse me, sir?
Whose onus of proof is that?
The appellant, sir.
Right. And presumably, that means that the exercise of going through what happened, so far as standby of jurors is concerned, is a relevant one.
Yes, sir. Well, those are my submissions.
Right. So is this the position? You have to go through what happened and do what?
I'm
And
sorry.
see if there was some indication of bias. I don't, what is the exercise that one is performing?
Well, I'm not sure, sir, because if if we are going through just to highlight, okay, the numbers are over 3. Next question is, so what? What else
Yes.
that you're relying on? So, for instance, Mr. Pettingale was was submitting that the mere fact that you go over 3 would give the reasonable observer the view that it is a prosecutor who is running the show. The reasonable observer knows that it is a judge who controls the court. Especially in these modern times where everybody are exposed to social media and television shows and so on. Everybody who enters the courtroom knows that it is the judge that controls the court proceedings. That's why we stand when the judge enters the courtroom and not when the prosecutor enters the courtroom.
Right. I'm still not quite sure where we are. You go through, see what happened. The first thing you have to do is to see if the numbers stood by were over 3.
Oh, that's to me directly, sir, or everybody?
Well, everybody, the appellant, the Crown, the
Very well,
court.
sir.
As I understand it, you say you have to go through what happened and see if the numbers ultimately stood by were over 3, because if they weren't stood over 3, we can all go home. Is that right?
Me, sir? Yes, sir. And
Right.
if they're over 3, sir, I'm still saying that it is irrelevant in light of the authority, because that by itself, without more, is not sufficient.
Yes.
And I believe that that's...
And what would be sufficient,
Excuse me,
if
sir?
anything? What would be sufficient, if anything?
Well, for example, for Ms. Greening's client, they have added an additional ground, separate and apart from the numbers, to say that the jury was stacked and was manipulated. I'm not saying there's any substance in that argument, but that is an additional point apart from the numbers that that appellant is seeking to rely on. The appellant, Brangman, has nothing more other than the numbers were beyond 3. Likewise, the appellant, Smith-Williams, give or take the application for fresh evidence.
Yeah.
So beyond the fresh evidence application, there's really nothing apart from the numbers, the math of the numbers being over 3 that they are relying on.
So it wouldn't matter if there were 11.
That is so, sir. It has to be something more.
Right. Now, and what I think you say is that in order to show something more than the numbers, you have got to show an appearance of bias in the selection of the jury, other than the fact of the numbers. Is that right?
Yes, sir. let me use an example. Let's say, for example, there is an allegation of bias and jury stacking.
Yes.
In one examine the jurors who actually sat on the panel, you had all white. The case law would suggest that that by itself is not a ground of appeal.
Yes.
However, if one wanted to ignore what the case law said, then that would be something more. Another example just crossed my mind. Let's say, for example, you have a panel, and as it turned out, let's say the defendant, Roberts, was an MOB person or MOB man. And subsequently turned out that everybody on the panel were Parkside or had Parkside connection. That would be something more than just the mere numbers of standby. That would be clear evidence of bias or apparent bias.
Right. Right. Okay, so numbers isn't enough. There's got to be some clearer indication of the appearance of bias, which might be the case in the example that you've given. If it's a case against don't interrupt. If it's a case against an MOB man and they're all Parkside men. But the decision of the Chief Justice appears to be that the mere fact that there is a disparity between the number of people who can be peremptorily challenged by the defense and the number who can be stood by the Crown gives rise to a real possibility of bias and is also inconsistent with the principle of equality of arms, such that, as I read him, he appears to be saying that once you get a disparity, in other words, the ability to stand by more than three is in fact exercised, that of itself gives rise to a real possibility that the jury may be biased in favor of the Crown. Now, is that simply wrong?
Well, sir, the ratio decidendi of the Chief Justice, he pretty much adopted the ratio decidendi in Tyson, which adopted the ratio decidendi in Bain. And if you look at all three decisions, the reasoning are similar in many. Yeah. And that's why when you look at the case of English, the question is, having changed the law, or after the declaration of that particular provision in the law as being unconstitutional, what is the effect on cases that occurred before, in which does the finality principle apply, as in these cases? And English is saying, notwithstanding all of that, because in English, the appellant was seeking to rely on the ratio decidendi in Bain, the decision in Bain, which is a foundation case upon which Trott eventually rests on. The court of—
You say that Trott was following Tyson, which adopted Bain?
Yes, sir.
Right. And you say in English the appellant was relying on Bain?
Yes, sir. To revisit or to, as a ground of appeal, to challenge his conviction.
Mm-hmm.
And the Court of Appeal said that that was a ground that was going nowhere.
Yes. Just a moment. I've forgotten which Court of Appeal that was.
It's at page 515 of the
Yeah.
bundles, I think.
Yes.
Authorities for the respondent.
Yes. Yes. Well, it is true that the Court of Appeal in Newfoundland said that the change in the law took you nowhere. But if you go to page 533, you about just above the second hole punch, in Bain, defense counsel at trial had objected to this procedure and successfully moved that each party be limited to 4 peremptory challenges and that the Crown be denied the power to stand by jurors. The Supreme Court of Canada held that the process of jury selection was inconsistent with the Charter, which had a provision about fair trial by an independent and impartial tribunal. The jury selection was not challenged by defense counsel at trial. The Bain decision was rendered after the trial took place. At the time of trial, the jury selection procedure had not been declared invalid, and inasmuch as 4 judges on a panel of 7 of the Supreme Court suspended the declaration of invalidity for 6 months, the Bain decision cannot be applied retroactively in this case to upset the decision at trial. So English says in Newfoundland, Bain can't be applied retroactively. But as I've said rather too many times now, the approach in relation to the application of retroactivity in England is not the same as in Canada.
Well, sir, I cannot assist the court any further. I've gone through this and I've gone through the authorities, which apparently seems to suggest that the mere change in the law does not apply retroactively. Well, it doesn't apply retroactively, and the mere change in the law by itself is not ground for substantial injustice.
Right.
So I can't assist the court any further.
Right.
I've gone through the authorities. I've done the best I can, sir.
Okay. Right.
Mr. Mahoney, in that regard,
Yes, sir.
how do you see the proviso operating?
Excuse me, sir?
In this context, in the context of your last observation, how do you see the proviso operating?
Well, my lord, assuming the court is, well, in the context of the proviso would be applicable in these circumstances, sir.
Well, what it says literally is that the fact that the Crown might have stood by more jurors than the defense is not enough to set aside a conviction. But doesn't that also imply an acceptance that there may be other circumstances that would justify the conviction being set aside? In other words, an implicit recognition of the English version of the finality principle.
That is so, sir.
And sorry, when I said the English version, I meant English law, not the Newfoundland approach.
I wasn't sure exactly. Yes, sir. But yes. Lord President?
Yes.
Oh, sorry. I thought you.
Well, I think I think you were answering yes to Justice Smelly's proposition. Is that right?
Yes, sir.
Right. So we're back to where we were some time ago, that the relevant principle is that prima facie there is no retroactivity unless there is or may be a substantial injustice if the matter is not applied, the law is not applied retrospectively.
Yes, sir.
Right. So the question for us is whether or not there is a substantial injustice. So it might be suggested that in giving leave, the court had already expressed a view on that. But the question is whether or not there is a substantial injustice. You say that that has to be something other than the mere numbers.
Yes, sir.
Right. Okay. Right. Well, thank you.
You're welcome, sir.
Now, very good. Where have we now got to? Is there any possibility of having the evidence now? Hello?
I'm prepared to proceed on the Brangman selection, my lord. That is this.
Yeah, the question was evidence.
Yes,
Oh, sorry, Mr. Oh, I apologize.
Don't worry.
I think the answer, Ms. Greening.
yes, my lord. Yes, Mr.
Not yet.
Is Ms. Smith available?
She's available now, yes.
Yeah, she's available now.
Well, I think I mean, subject to, I'm open to suggestions on from any quarter, but it would seem to me it might be quite sensible to deal with the evidence now, and then we can deal with going through the standbys all in one go. Does that seem sensible?
Yes, my lord.
I'm
Is
quite
the-
prepared.
And in terms of order, would it be so who is tendering themselves for cross-examination?
Well, your client is tendering his.
Yes, first question I suppose that should be asked is the affidavit evidence on the papers sufficient for examination in chief? I'm assuming that's
Yes.
that's sufficient.
I mean, speaking for myself and subject to any other observations,
Yes.
if he swears to the truth of his affidavit, that will be his evidence in chief. He doesn't need to give it again.
Very well. So that's what I thought. I just wanted to check.
Yeah.
So he should go first then, because the burden is on us. The burden is on us.
Absolutely.
And he can. The only thing he was asking me about is whether he would be put into a separate room either separate room or the other two appellants leave the room. I'm not sure how that would work.
I don't think so.
Perhaps
These
he's
are
going to sit where he is and
these
swear
are public
by-
proceedings. If
Yeah.
we were in court, they'd all be there.
Yes. Okay.
And this is just a Zoom version of it.
Well, he's. I can't see him right now because I haven't scrolled. Okay, he's there.
The
Yes.
prison authority will have to unmute the mic, and Mr. Roberts, if you can bring your chair forward so that you're closer to the camera. Are we ready to swear the witness? My Lord President?
Yes, we are. I'm so sorry. Yes, we are. Yes.
So in your right hand, Mr. Roberts, and you repeat after me, I swear by Almighty God
I swear by Almighty God
that the evidence I shall give
that the evidence I shall give
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Thank you, Mr. Roberts. You can have a seat.
Yes.
Do I need to just confirm with my client that the second and third affidavits, the second affidavit of LeVeck Roberts, was that an affidavit, Mr. Roberts, that you swore and signed on the 16th of November?
Yes, Greening.
And then there was a further affidavit, the third affidavit of LeVeck Roberts. Was that an affidavit that you swore and signed on the 3rd of December, 2020?
Yeah,
And do you maintain that position that the contents of both of those affidavits are true to the best of your knowledge and belief?
yeah.
Very well. President Malords, I invite the court to accept that evidence as examination in chief.
Yes. Very
Mis-
good.
Mr. Roberts, you'll now be cross-examined by the respondent, Mr. Mahoney, if you just sit where you are.
Sorry, afternoon, Mr. Roberts.
Hey, sir.
Okay. Can you recall the courtroom that your trial occurred in?
I'm not sure of the numbers, but I think it was down the hill, close to Front Street.
Right, that's courtroom number 3 on Front Street.
Yeah,
A much smaller courtroom than courtroom number 1 on the hill.
is it smaller than the one on the hill?
Yes. Are you
Yes,
agreeing?
I believe so.
Okay. And when you're in the prisoner's box, well, you agree with me that you have where the judge sits. In front of that is where the clerk sits, correct?
Yeah,
And then in front of that is an area for counsel.
yeah,
And then you have a second area for junior counsel.
yeah.
Right. But the area where counsel sits only accommodate 3 counsels per row because it's small.
Can you repeat that question,
The
please?
area where counsel sits can only accommodate 3 counsel per row.
I would believe 2. I had 2 counts.
Yes, but in the area that counsel sits, in the first row, only 3 lawyers can sit in that row. And in the second row, only 3 lawyers can sit in that row. You
Are
agree?
you talking about behind the dock, sir?
No, in front of the dock.
On the left, it was you and Nicole Smith, and on the right, I had
No, you're not following me. I'm talking about the seating area where all the lawyers would sit. So you have where the judge sits, then where you have the clerk sits, and then you have the first row where the lawyers would sit. And I'm suggesting that only 3 lawyers can sit in that row.
I'm not really understanding your question, sir.
Okay. Well, I'm putting to you that where the lawyers sit, the 2 rows, there are 2 rows that the lawyers would sit in. Only 3 lawyers can sit in each row.
I'm not really sure what your point.
Well, don't worry what his point is. Is what he is suggesting correct? That there are 2 rows of counsel, and there can only those rows can only fit 3 people in each row.
I don't believe so.
Okay, well, continuing. Behind the row that the lawyers sit is a dock.
Yeah,
Okay? And the dock is at a higher level than where the lawyers sit.
no, it's just behind.
I'm suggesting to you that where the lawyers sit is at a lower level than the dock where the prisoners stay.
It's just behind, sir.
And you and your co-defendant, Christopher Deere, would be sitting in the front row of the dock,
Yeah,
looking down on the lawyers.
yeah, we're facing the judge, yes.
Right, facing the judge, you would be looking down on the lawyers.
Yeah,
Right. And immediately behind you and your co-defendant, Mr. Deere, Christopher Deere, each of you had a correctional officer sitting behind you in the dock.
yeah, one officer, if I remember correctly, yes.
One each.
I'm not sure, I just know
Okay.
we're required to have an officer there.
All right. And where the Crown sat, we were closest to where the jury box was. You agree?
Yeah.
Okay.
Sorry, where who sat?
The Crown Counsel.
Right.
We are to the facing the judge, we would sit to the left, closer to the jury box.
Yeah, that's what I said, yes.
Right. And immediately beside me was your lawyer, Mr. Richardson.
Yeah,
And beside Mr. Richardson was Mr. Mussenden for your then co-defendant.
yeah,
Right. And sitting behind me was Ms. Smith.
yeah,
And sitting behind Mr. Richardson was Mr. Attridge.
yeah.
And sitting behind Mr. Mussenden was Mr. Dante Williams.
I don't recall.
Okay, Mr. Mussenden's Jr., you may not recall who it was, but Mr. Mussenden's Jr. was sitting behind him.
He could have been, yeah.
Okay. In respect of that empaneling, you agree that there were close to 60 or so jurors in the courtroom.
What's your question, sir?
I said, would you agree that there were close to 60 or so jurors in the courtroom?
I don't know about 60, but it was a good bit.
Right. And the door to that courtroom, or the doors to that courtroom, if you're looking from where the judge sits, the doors are to the left of the courtroom.
Yeah,
Right? The door that the jurors would enter in to the courtroom was the first door. Well, from the judge, it would be the second door to the left.
yeah, the one at the back.
Right. And you agree that as you come into the passage, coming towards the dock, seats go right up to the wall of the courtroom. So if you come through that door and turn towards the prisoner's dock, or turn towards where the judge sits, there are some seats to the left, correct?
Yeah,
And the seats go all the way up to the wall on the left. There is no space between the seat and the wall on the left. Do you agree?
not understanding your point.
Not the point. I'm asking you, do you agree that the seats on the left go straight up to the wall? There is no space between the wall and the seats on the left.
Yeah,
Okay. And you agree that when the empaneling was going on, all the jurors were in the room, prospective jurors.
yeah,
Right. You agree that there is no way from where the Crown was sitting that they could see, with all the people in the courtroom, they could see someone standing at the back door on the left.
no, I don't agree.
your lawyer raise any objection during the impaneling of the jury?
You can repeat that?
Did your lawyer raise any objection during the impaneling of the jury?
I don't think so.
Okay. Throughout the trial, you are aware, well, you actually spoke with your lawyer throughout the trial.
Yeah,
Right. Whenever you had a concern, you just tap the window and Mr. Attridge would turn around and look up at you, correct?
yeah.
Right. Did you raise any concern to Mr. Attridge during the impaneling?
No, I didn't.
Okay. When you went on appeal, did you raise any concern about the impaneling on appeal?
My first appeal?
Yes.
No, sir.
Right. And I think on that occasion, Mr. Pettingill was your lawyer?
Yes,
Okay. You said that during the impaneling, Inspector Pedro was there?
yes, that's in my affidavit.
Okay. Suggesting to you, Mr. Pedro was not there at all on that day?
That's what you're suggesting?
Yes.
If that's your observation.
Mr. Pedro did not enter that courtroom until about 2 weeks after the trial had started.
Are you asking me?
I'm suggesting to you.
You're suggesting that he wasn't there?
He didn't enter that courtroom until about 2 weeks after the trial had started.
That's not true.
And at no point.
Mr. Mahoney,
Sorry.
I don't think he answered your first question about Mr. Pedro being there on the first day. Can he confirm in terms that he recalls Mr. Pedro being there at the time of the jury selection?
Yeah.
What? So what was the answer, sir?
Can you ask the question, please?
Yes. I'm suggesting to you, Mr. Pedro was not in the courtroom on the day of the jury impaneling.
I say that he was.
I'm suggesting you're incorrect on that.
You're suggesting.
And at no point did you see, by the way, where you said the police would be standing while we're impaneling the jury.
Where the police will be standing?
Yes, you said that they were in the courtroom. Where were they standing?
Where you will come in the second door, as you said, where the jury comes in.
Okay. I'm suggesting to you that at the time of the impaneling, with all the jurors in the room, there was no space there for the police officers to be in the room.
There was space.
And at no point did any police officers communicated with either myself or Ms. Smith during the impaneling.
They did communicate with.
At no time did any of us look at any police officer or any police officer nodded at us.
Yeah, you was looking back at where they were standing.
I'm suggesting to you, sir, that from where I was sitting down below, with the courtroom being full and the dock obstructing my view, there is no way that I could have been communicating with the police standing at the door on the other side of the room.
If you look back, you will be able to see.
When you were sitting there doing the impaneling, where were you facing?
When every juror's name was called, I would look back to see what they look like.
Okay. So as a name was called, you immediately looked behind you?
Yes.
Okay. And you're saying while you're looking behind you, you saw me nodding or indicating to some police officer there?
Yeah, depending on what that juror may have looked like.
What's that? Sorry, I didn't get what you said.
I said, depending on what that juror may have looked like.
Suggesting that nothing like that happened at all.
Yeah.
No further question.
Is there any re-examination?
Yes, there are two questions, my lord, in re-examination. Mr. Roberts, you were asked by Mr. Mahoney whether you spoke to your lawyer during the impanelment of the jury at your trial, and you said no. Why did you not raise this concern that you're raising now with your lawyer?
At the time of trial, I was very young and I didn't know the law.
You were asked about Pedro and whether he was there on the first day of trial, and you initially answered, "That's in my affidavit." Why did you say that?
Because that's what I had observed on the day.
And final question. It was suggested to you in Mr. Mahoney's last question that nothing like that happened. In other words, you had said that you saw Mr. Mahoney looking back at the police when the jury's names were called, and he's suggesting to you that nothing like that happened. You replied, yes. What do you mean by yes?
Meaning that when a juror's name was called.
Yes.
Can you repeat just the last part of the question? Sorry.
Mr. Mahoney said to you, or suggested to you, that nothing like that happened, meaning when you said that Mr. Mahoney was looking back at the police when the jurors' names were called, he's saying nothing like that happened.
I say that
you said yes, and I'm asking, what do you mean by that?
Meaning it did happen.
So what did happen?
Beg your pardon, sir?
What you say it did happen. When a juror's name was called, what happened?
Mahoney was looking back.
Is that the end of your answer?
Yeah.
Looking back at what?
At the juries.
Mahoney was looking back at the jury.
Yeah.
When Mr. Mahoney, you said that Mr. Mahoney looked back when the jurors' names were called at the police who were sitting.
Oh, sir, I'm sorry, I must object because counsel is now, I think the re-examination is to clarify. He has given his answer and now Ms. Greening is pretty much leading him on into something else, into what he didn't answer.
I misunderstood the question, sir.
Mr. Mahoney asked you or suggested to you that at no time did he look back, and you said you were looking back at where they were standing.
Meaning the officers.
Referring to the police officers.
Yeah.
Then his last question to you was, I suggest to you that nothing like that happened. And you simply said, yes. I'm asking you, what do you mean by yes?
Meaning he was looking back at the office.
Those are my questions. Thank you, Mr. Roberts.
Can I just ask, I want to make sure that I've understood the geography of the court. You said that in front of you were 2 rows of lawyers, and then the clerk, and then the judge. Do you remember that?
Yeah.
And you were asked how many jurors there were in the room, and it was suggested that there were 60, and you said that there was a good number. And you were asked about the door to the room, and it was suggested that if you look from where the judge was sitting, the door is to the left of the courtroom, and you said from where the judge was, it's the second door to the left at the back.
Yes.
Do I understand that what you were saying was, put yourself in the position of the judge, assume you're sitting where the judge is, the door to the room is the second door on the judge's left-hand side?
Yes, the appellants come in the first door, and the police officers and jurors come to the back one.
Right. And as you come through that door, where are you in the courtroom so far as the dock is concerned? Are you behind the dock, or level with the dock, or between the dock and the judge, or what?
I would say I think I'll be level.
No, not. Oh, well, sorry. Assume somebody comes into the court from what is the door second to the left, if you're looking from where the judge is. When he literally walks through the door, assume he walks straight ahead, would he walk into the dock, or in front of the dock, or behind the dock?
That would be behind, I believe.
I thought so. Right. Right. And the police officers that you were talking about, have I understood this correctly? They were standing at the back of the room behind the dock.
Yes.
Right. Thank you. Does anybody have any questions that arise out of that? Right.
Yes, sir.
You do you? Sorry.
Yes, sir. Just to clarify that. So if you're standing, you agree that if you're standing where the judge is, the Crown Counsel, well, the jury box would be to the right.
Yeah.
Right? And Crown Counsel, as you agreed, would be also to the right of the judge. Correct?
If I'm the judge sitting in, the counsel will be to your left.
Sorry?
If I'm sitting how the judge was sitting, counsel will be on the judge's left.
No, the doors are to the left.
That's where counsel, that's the side counsel sits on.
No, just listen to the question, please. The doors are to the left from sitting where the judge is, correct?
Yes.
To the right is the jury box.
Yeah.
Below the judge, there is the row where counsel sit. Correct?
Yeah.
Crown Counsel would be sitting to the right of that row next to the jury box.
Yeah.
Right. And the doors would be to the left, near to where defense counsel generally would sit. Correct?
Yeah, the door would be to the left of counsel.
Yes, that's where that would be the door closest to where Mr. Mussenden was sitting.
If Mr. Mussin's facing I am, that would be on the right.
No, if Mr. Mussenden, let's say you're at the judge's, where the judge sits. Mr. Mussenden would be at the end of where counsel was sitting.
Oh, yes. Sorry, yeah.
Right. So you would have Mr. Mussenden closer to the left, Mr. Richardson in the center, myself and Ms. Smith to the right, closer to the jury box.
Yeah.
And dead center behind that is where the dock was.
Yeah.
Right? Okay.
And you're talking about, when you talk about left and right, that's looking at it from where the judge is sitting.
Yeah, if we're looking at it from the judge is sitting,
Yep.
the dock is in the middle.
Yep.
Prosecution would be where Brangman is, and defense would be where Smith Williams is.
I'm sorry, that's not terribly helpful. What I have understood is assume that you are sitting where the judge is. You follow me?
Yeah.
So the judge is sitting looking towards the dock. The jury box is to the judge's right.
Yeah.
The door to the court is the second left, looking from where the judge is sitting.
Yeah.
Right. And Crown Counsel is closest to the jury box, so on the judge's right.
Yeah.
And defense counsel are to the left, looking from where the judge is.
Yeah.
Right. Thank you. Right. Well, that's your evidence is over. The following is occurring to me. You all know this court, and speaking for myself, I have sat in it, but it hasn't been in use, I think, for quite a while. But I presume it's physically still there.
It's not accessible,
isn't it?
It's condemned.
It's condemned. Oh, this is the mold, is it?
Yes.
So nobody can even go in and take a photograph.
I have a photograph of it.
Oh, right. Well, would you like to circulate the photograph to the parties? And if it's agreed that that is a photograph, an accurate photograph of the court, it would be helpful for me, and I think my brethren to, well, Justice Bell probably has a better memory than I have, but I think it might be
I've got
helpful.
a good recollection.
Yes, well, I have a vestigial recollection, but
for my part, I was about to suggest an agreed sketch among counsel.
oh, right.
The photograph will do even better, I would think.
The photograph would be better. Okay, well, let's try and do that. Right. Have we got Miss Smith available?
My lord, I just got a note that she stepped out for a minute.
Right.
Not too far away, sir.
Okay.
But she's on her way back, so I'm not sure what that means.
Where is she on her way back from?
Miss Kingdean, can you assist?
Didn't
From
quite
where,
indicate. She said she just stepped out of the office and she's coming right back. She said she's actually not too far away.
Okay. Well, shall we just break off for about 5 minutes and you can bring us back when she arrives?
I've sent the pictures to the judges, and the council should get them shortly.
Okay.
My lord, I'm happy to whip up a sketch and circulate it if that helps. It's one of my hobbies.
Yes, yes.
Yeah. Thank you.
All for artistic endeavor. Right.
Yeah.
Ms. Smith is back.
Good afternoon, my lords.
Good afternoon.
I hear her, but I don't see her.
I can't see her.
Yes,
okay. All right. Good afternoon, Ms. Smith.
Good afternoon, Mr. Coelho.
Are you familiar with the oath to be taken?
Yes, I am.
Are you prepared to swear it or affirm it?
I can swear it, thank you.
Would you recite the oath, please?
I do swear by Almighty God that the evidence that I'm about to give in this case shall be the truth.
Thank you, Ms. Smith.
Thank you.
Give me a moment. You sent us Ms. Smith's full statement, and I can't quite find it, Coelho.
My lord, it's in the supplemental bundle of authorities at page 156.
Well, it is, but
effective copy. So
we had an effective copy. Can you remember where you sent it to me?
I'm resending it.
Oh, thank you.
Okay, it's just being sent.
Just a moment.
Mr. Coelho, my screen froze and I'm just back in. So it froze while Ms. Smith was
giving her oath.
Being sworn, but I haven't heard anything from her yet.
She's not being questioned yet.
Okay, thank you.
Just a moment. Well, what you've just sent me is...
Hers is the second attachment. First affidavit of Nicole Smith.
Oh, yes, thank you so much. Thank you. Yes, I've got it now. Sorry about that. Right. Let's proceed.
Ms. Smith?
Yes.
So Coelho will swear or affirm you.
Witness has been sworn.
We've done that.
Oh, sorry. Could you state your name, please, and where you work?
Nicole Renee Smith, the Department of Public Prosecutions.
And you appeared as co-counsel in the matter of LeVeck Roberts and Christopher Deere?
Yes, I did.
And in respect of that matter, you gave a sworn affidavit dated the 20th of January, 2021?
Yes.
And you stand by the truth of the content therein?
Yes, I do.
Thank you. That's evidence in chief, sir.
Thank you.
Good afternoon, Ms. Smith.
Good afternoon.
So as you know, we're dealing with the trial in which you were the junior of LeVeck Roberts and Christophe Dure. And in particular, we're dealing with what occurred on the morning of the first day of trial when the jury were impaneled. You would agree, I think it's accepted, that the courtroom was very busy that morning.
There were many people in the courtroom that morning, many of the jury pool.
And lawyers and other people.
I recall lawyers and potential jury members.
And there was a lot going on, wasn't there? As there normally is on the first morning of a trial, big trial.
Explain a lot going on.
Well, there were lawyers getting their papers out. There were jurors being impaneled. There were witnesses to manage.
What went on that morning, the first morning of trial, is no different than what goes on the first morning of any trial.
Yes. And as junior, you're busy dealing with all sorts of things and people, correct?
No.
So you're not agreeing with me that you're busy dealing with all sorts of things and people on the first morning of a double murder gang trial?
No.
How long have you been?
What I do on the first morning of any trial is no different from what any lawyer who was there present with me had to go through. We had to impanel a jury, so we were all in the same boat.
I'm not suggesting what you were doing was any different from anyone else there, but I'm suggesting that there's a flurry of activity going on in the morning of a double murder gang Supreme Court trial where there are 60 or so jurors to impanel. That's what I'm suggesting to you.
I disagree.
How long have you been a criminal lawyer?
For 16 years.
So you've sat in and conducted many of these Supreme Court trials yourself?
Yes, I have.
So although you disagree with me that a lot of things were going on, one of those things is that you and Mr. Mahoney, your senior, got a list of the ballot. Those are the potential jurors to be impaneled, correct?
Yes.
And as you have said, this trial was the same as any other. You read through that list. You read through that list.
We look at the names listed, yes.
And you make notes of any jurors that you or Mr. Mahoney do not think should sit as jurors at that time?
No.
You don't do that?
No.
What's the purpose of reading through the list then?
To see if I recognize anyone or a name jumps out. This is Bermuda. So sometimes you have lawyers in the jury pool. Sometimes you have next door neighbors in the jury pool. Sometimes you have cousins in the jury pool. Just to see if a name jumps out that you recognize as being like one of those persons.
To see if you recognize anyone. And would you make a little note or a star against that name if you recognize them as a lawyer or a neighbor or that name jumped out to you?
No.
And what would be the purpose of seeing if you recognized anyone? Would it be to suggest that they shouldn't sit as jurors? Or is it just for fun? What's the purpose?
It will be to highlight in your mind who they are in case you need to discuss their presence with the judge or with opposing counsel.
In case you need to discuss with the judge or counsel.
Mm-hmm.
You'd agree that on this occasion, at this trial, there were no names that jumped out that you had to discuss with the judge or counsel.
I can't recall.
Do you agree that the jury selection process is a very important part of a trial?
Well, that's elementary, isn't it?
So on the morning of this particular trial, you're in court 3, is that correct?
Yes.
Which is on Front Street?
Court number 3.
And that's a very small, well, comparatively speaking, you would agree, wouldn't you, that this is a small courtroom?
It's tiny.
And there is a little door, or there are two doors, but there's the little door at the back on the left where members of the public, jurors, and people who are not permitted in the well of the court use to enter and exit the courtroom.
There are 3 doors, and the one at the very back is for, and what was your suggestion that one was for?
The members of the public, basically people who are not permitted to enter the well of the court would use that back one. Members of the public,
Yes,
jurors.
that is true. That is true.
And it's not a door, like it doesn't have a security system attached to it. It's just sort of a regular old wooden door.
I don't know if it's capable of being locked, but no, there's no special security feature attached to that door.
So you are sitting, well, I suppose I'll be consistent with how we've gone so far. If you're sitting in the judge's spot, you've got to the far right, the jury area in front of you, and then you're sitting to the left of that.
Yeah.
And you watch the clerk start the impaneling process by putting her hand into a bowl and pulling out a number and calling it out, a number and a name.
Yes.
And they're doing that in front of the other potential jurors. Is that correct?
Yes.
And you'd agree that when the name gets called out, everyone looks around to see who's coming up to the jury box.
I guess.
I suppose you can't speak for everyone, but you would tend to look around to see who's coming up.
No.
You're saying no, you never do that?
Are you asking me about what I did in this?
Yes, I'm interested only in what happened in this trial right now.
Oh, you just asked me if I never did it. So, because of the size of that courtroom, you cannot look around. You're not able to observe anything really. And what I tended to do in that courtroom was you just wait until that person comes up and takes their seat.
You're saying that in this courtroom, you cannot look around?
It wasn't easy because there were many people there and I was sitting in back of Mr. Mahoney and my back was right to the defendant's dock. And that dock is wide. So I just tend to just wait to see who comes up.
And Mr. Mahoney was sitting in front of you?
Yeah.
We know that Mr. Mahoney stood by a number of potential jurors in this case. Can you recall that?
No.
You can't recall that?
No.
And can you recall?
Oh, that a lot of jurors were excused for medical reasons and employment purposes by the judge.
You can recall many jurors were
Judge even saying that he feels like a postman because he was getting so many letters that day, either from persons themselves or letters which he had received from the Chief Justice excusing people. So I remember that there are a lot of stand downs by the judge.
So you're saying you cannot recall Mahoney standing anyone by, but you recall that the judge excused many jurors, that he said he was getting so many letters he felt like a postman, and that he stood down a lot of the jurors. You can recall that?
I can't recall if Mr. Mahoney stood down anyone. Maybe he did, maybe he didn't. But I'm saying that I know a lot of potential jurors were stood down by the judge. on that day.
Ms. Smith, with respect, I'm going to suggest to you that you're prevaricating here as you answer my questions, and that you can recall very well that not only did the judge stand some of the jurors down, but you also recall Mr. Mahoney stood by, and I'm not asking you to remember how many, but stood by a large number of jurors in this case.
With respect, Ms. Greening, you're not getting the answer you need, and that's not my fault. I'm only telling you what I could recall with respect.
So do you recall the police being present at court 3 on the morning of that trial?
No, I don't.
You would agree, wouldn't you, in your 16 years of being a criminal lawyer, that it would be extraordinary for members of the serious crime unit not to be present on the morning of a double murder Supreme Court trial?
But that's false, because there were so many persons, potential jurors, all potential jurors, at least 55 or 60 in that tiny public gallery of Supreme Court number 3. And the rule is that if police were present, they cannot be present in that same vicinity. They cannot mix and mingle with potential jurors.
My question was, it would be extraordinary for no one from the serious crime unit to be present on the morning of a double murder Supreme Court trial. And you said that's false.
Well, present where, Ms. Greening? Present in the precincts of the court, in the public gallery, or outside the doors? Where?
Were the police present in the court?
No.
You agree that you work closely with the police in the preparation and lead up to this trial?
I work closely with the police in the preparation and lead up with every trial, Ms. Greening.
I'm interested in this trial.
Yes.
I put to you that it's unbelievable that none of the police were present in that courtroom on the morning of this particular trial. Ms. Smith, you would agree, wouldn't you, that and now I'm talking generally, that it's common for the prosecutor to liaise with the police during the jury selection process or before the jury selection process?
I disagree.
I didn't want to go here, but you agree that I used to be a prosecutor.
That's elementary.
And that you and I have conducted Supreme Court trials together.
We've conducted one together. And I was actually the lead counsel and you were my junior.
I recall 2 in which both times I was your junior. And you would agree that on those 2 occasions, we liaised with the police prior to the jury selection process for the purposes of hearing what the police had to say about those jurors.
I don't recall.
I'm not talking about this case. I'm talking generally and about those 2 cases in which
I don't recall that.
So I suppose you won't agree that it's common to show the ballot to the police prior to the jury being impaneled.
It's not a practice I undertake or I ever conduct.
Have you been listening to these appeal proceedings?
No, not constantly, not consistently, no. I'm busy.
You would agree, wouldn't you, that the police are consulted for the purposes of seeing whether any of the potential jurors have previous convictions? Has Mr. Mahoney told you that he's agreed that happens?
Not that I know of. Mr. Mahoney hasn't said anything to me.
Now, you would agree that one way to communicate would be to talk to each other, like you and I are doing now.
In relation to what, Ms. Green?
Communication, basic communication.
That's elementary, Ms. Green. What's your question?
Well, my next question is that you would agree that there are other ways to communicate than verbally.
Ms. Green, what's your
Non-verbal
question, Ms. Green?
Would you agree that there are other ways to communicate than verbally?
Yes, Ms. Green.
Are the lawyers permitted to have their phones on their person in court? Well, I'm suggesting to you that the lawyers are permitted to have their phones in court.
It depends on the judge who's presiding over the matter.
So are you saying that there have been occasions where you've been in a Supreme Court trial where you have not had your phone present because a judge has not allowed you to?
Ms. Greening, you can have your phone in court. The question is, can you have it in the sight of the judge? Can you be using it in the sight of the judge? That's wholly different. Can your phone be on and can you be using it? And that depends on the judge who's presiding over the matter.
Now, you told us earlier that you would scan the ballot to see whether you knew anyone, any other lawyers, neighbors, any names that jumped out at you. You didn't tell the court in this case that we're looking at in the appeal of any occasion where a juror was known to you?
Well, if I didn't, I didn't.
There were no other lawyers as potential jurors in this case?
If there weren't, there weren't.
I'm going to suggest to you that the prosecutors did liaise with the police prior to the impaneling of this jury to get rid of the jurors or attempt to get rid of the jurors that the prosecutor and the police thought are less likely to.
Objection, sir. That is like 3 questions in one.
No, it's not. It's only one.
Please, I'm objecting. Please don't interrupt me. It's 3 questions, sir. One suggestion is, did liaise with the police? Then another suggestion is to eliminate. That's 2. And then counsel was going on to a 3rd question without the witness being asked to answer the first and the second question.
Well, it's a composite question, but I think it might be helpful if you took it in the proverbial stages, Ms. Greening.
Very well. I put it to you that in this case, the prosecutors did liaise with the police.
That's false.
And that they did so to eliminate jurors.
False.
In order to shape a jury that was favorable to the prosecution.
False.
You're saying false in relation to you, but you can't answer for Mr. Mahoney, can you? You can only speak for yourself.
Well, you said the prosecutors in this case, and Mr. Mahoney and I were the prosecutors in this case.
And I'm clarifying myself.
That did not occur.
How tall are you, Miss Smith?
5'5".
And I suppose—
I thought I was taller, but I am 5'5".
I suppose you might say it's elementary that you're famous for wearing heels.
Was famous for wearing heels.
In 2015.
Yes.
So add another 4 inches to that. So 3 or 4 inches to that, 5'8".
No, I never wore 4-inch heels.
Is Mr. Mahoney taller than you?
Yes.
Did any of the police officers that you say weren't present in court 3 indicate to you that the potential jurors were their wives?
I'd never had any communications with any police officers about potential jurors.
I put it to you that that's just false.
Do I repeat myself?
Those are my
Well-
questions. Thank you.
Any re-examination?
Answer.
Sorry?
None.
None. Just help me on this, Ms. Smith.
Yes.
When the jury was being empaneled, as I have understood it, you would be sitting in the second row
Yes.
and Mr. Mahoney would be in front of you in the first row,
Yes.
and leading and junior counsel would be to your right as you sat down,
Yes. Yes, my lord.
and the jury to your left.
Yes.
Now, you have been asked about whether there was any communication with police, and you said that there wasn't.
Mm-hmm.
And you were asked whether there was any communication with the police by the prosecutors. When you were with Mr. Mahoney, sorry, start again. During the time when the jury was empaneled, were you and Mr. Mahoney ever out of your seats in the front and second row?
No. No, my lord.
Right. And just help me about something else. You referred, I think, at some stage to a gallery. As I've understood the position, if you sit where the judge is, on the judge's left, there are two doors. I know there are three doors on that side, but on the looking down towards the dock, on the judge's left, there are two doors, and there's in front of him the dock, and where is the gallery?
The gallery, the public gallery is, you have the second door, and then there's the bench where I was sitting.
Yes.
Then right behind me is the dock, and the dock is wide.
Yes.
And behind the dock, there is a barrier that goes width of the room. And then behind that barrier, there exists the public gallery.
Oh, I see. Yes. So, but is this may seem a silly question, but behind the barrier there's a gallery, but is the gallery, as it were, at ground floor level? It isn't.
It is ground floor.
Yeah. Right.
Yeah.
Sometimes gallery means raised. Right. Okay. Does anybody else have any questions that arise out of that?
I might, my Lord President.
Yes.
Because of course I am the only one of us who's not familiar with this courtroom. Now, Ms. Smith, when you speak of where the jurors are, to the right of the judge as he faces you,
yes,
are you speaking about the jury box or the gathering of the potential jurors?
My Lord, I mean the jury box, the 12 seats are to my left, the judge's right.
I see. And when you spoke of...
Justice Smelly, I mean, if I can say so, I think the two subsequent photographs that came through to us are the more helpful ones, and I can take you through that and I think answer any questions you may have.
Okay, thank you. Thank you.
Thank you.
Thank you very much.
Thank you, sir.
Thank you. Ah, yes.
Yes. Right. Thank you. I give notice that Mr. Coelho has produced a series of photographs, which he will send to you. The first set of which are quite helpful, but the second set of which are very helpful because they show the whole arrangement, including the dock. And yes, somebody has sent me a sketch.
Yes, it's Mr. Pettingill.
That's Mr. Pettingill, right. Perfect. Well, we now have a pretty good sketch and B set of pictures.
My lord, could I get a copy of that sketch?
Yes, you will get a copy. Yes, everybody can have a copy of A, the sketch, and B, the photographs.
Thank you, sir.
Right. Very good. Where have we got to?
I think we're at the numbers now.
We are at the numbers, yes. Right.
I'm so sorry, did somebody say something? No.
Right. Well, as I said, what I have in mind should happen is that we will go through, insofar as necessary, the numbers. I hope beginning with the Crown identifying which are the standbys that they accept took place of jurors who were not later removed for cause or excused, and then counsel for the relevant appellant can take us through what he says are the relevant standbys. Who are we going to start with? Are we going to start with Mr. Pettingill?
I'm quite happy, my lord, to do that.
Right. Just wait a moment.
My lord, is it permissible to just to clarify something on Mr. Pettingill's sketch?
Yes.
On the sketch, I noticed that to the right of the sketch, there is a corridor where we have back wall. Actually, there is no space between the, if you look on the sketch where there is a jury box, the side jury boxes, there's no space between that section that has jury pool. Selecting jury pool, it actually goes all the way back to the wall. So if anyone is to stand, they would have to stand over at the side, where the door is, the entrance door is to the left. There is no room on the right side of the courtroom from where the judge sits for anyone to stand there. The seats go all the way to the back. Mr. Quinn, can you verify that, please?
Can I verify?
That looking from where the judge sits,
Yes.
in the public gallery where the public would sit, the seats go all the way to the back of the wall. There is no room for anyone to stand behind the seats there.
Yes.
It's only to the left side of the room where you enter the courtroom, where the public would enter. There is a little corridor behind where those seats are.
Yes, that's correct.
Thank you.
So wait a moment. Court door, just a moment. Court door, the one we're talking about, the second on the left,
Yes, sir.
which in this sketch is on the bottom right-hand corner. That takes you, you come into the court, and there's room behind the seating.
Yes, sir.
But what you're saying, as I understand it, is that on the far side, the left of the sketch as we look at, the seating, the seating goes straight to the back wall. Is that what you're saying?
That is so, sir.
Right, I follow. Okay.
I'm sorry to interrupt. Just as a former court clerk, there's also a door missing in front of the jury seating at the top of the page. So there are 3 doors.
Oh, yeah.
Well, 4 actually. They're all missing.
Well, the direction isn't there to the doors, is what I'm saying.
Yeah.
I think it's clear from the photographs.
Yeah. Yes.
The dock is inaccurate as well. The dock actually spans the width of where counsel would sit. The photographs verifies that.
Yes.
Yes.
Yes, well, I'm not going to spend time looking at them now. I'll look at them this evening. Right. Now, let us start then with the jurors in the Brangman case.
My Lord President.
Yes.
If I may, it's 5 minutes to 3. I'm wondering if we could just take 5 minutes.
I'm sure we could.
Please.
Yes. Okay, let's take a 5-minute break.
Could we have the appellants back, please? And Mr. Mahoney, are you there?
Sorry for being late, sir.
No, no, don't worry.
I don't see Mr. Pettingill. Oh,
Right. I think we're all assembled. And what we need to work with, I think, are the documents in what's described as supplemental bundle 2 of documents, which have the various details about the jurors in question. Ms. Pettingill, can I give notice that I don't think it's possible to take this as a canter, because I need to make a careful note of some quite complicated references.
Yeah,
So-
my lord, if I may, I think what will assist and what I was intending to do, and I won't do it to counter because I realize the importance of it, but of course the Brangman jury selection, my lord, is at page 343 of the record. My lord, I think with regard to your lordship's note, I endeavored when I made the leave application in November to very specifically analyze each one. And it respects my intention to do that again, if I may. And in that regard, if I could refer your lordships to my submissions on jury selection from November.
Yeah.
And forgive me, my lord, I'm not exactly sure where that's contained in the record.
It's in,
I have it. I apologize, I don't have the screen.
well, I can tell you where I've just told you. It's not in the record. There is a supplemental bundle described as supplemental bundle 2 of documents.
Yeah.
Which begins with the unamended version of section 519 of the Criminal Code and includes as item 7 the 3 whom the Crown accepts were simply stood by. But also includes as the next following document your submissions on jury selection of November 2020.
I'm obliged to your lordship. That, my lord, is what I think I will reference and can potentially expand on each one. But I think that will be a useful note because I don't intend to stray from that. So I could ask your lordships to look at that document, and I will not initially deal with the elements of the first part of that, nor the references to the code, but the standbys commentary and my summary of that begins at paragraph 9 with the heading "Standby, Stand Down Jurors."
Right. Okay. So
it references the page numbers, my lord, in the record of appeal at 343.
That's quite.
Yeah.
Right. So if we start at paragraph 9, this is where I need to look for the ones that you say are standbys. Is that right?
That's correct, my lord. And I go through each of that to get to the number that I do.
Right. Now, let's use the juror numbers. 26, 38, and 4 are the 3 standbys accepted as such by the Crown?
Yes, that's correct, Lord. Yeah.
Right. Then you refer to, just a moment, to another juror at page 16.
Yes, my Lord.
And if we go to page 16, which is at Record of Appeal, page 357.
Yes.
We get at what you describe as paragraph 19, a juror who I think is Miss Eve. If you look at paragraph 12, excuse me, I need to turn the light on.
I agree, my Lord.
Right. Right. So if you look at paragraph, or well, I would say line 12, we get Miss Eve, who says, I know the defendant's father, auntie, and the defendant.
Yes.
We have no issue with that. Deborah Wellman, and then the court, well, she does enough, that's enough. And
yes.
Ms. Keeler says, stand down, and the court says, only answer me okay. Now, the 2 questions arise. One is whether that, when the judge says, well, she does enough, that's enough, and thereafter Ms. Keeler says, stand down, please, she is in fact simply following what the judge has indicated.
Yes.
And is that right?
Well, my Lord, if I reference it at paragraph 9.4 of the submission, and what I say is this, my Lord, is actually what I would say falls into that gray area and tends to highlight in my respectful submission what the concern of this court should be. Because to your Lordship's observation, I take the view that his Lordship in this case, quite rightly, when he says at paragraph 21, indicates only answer me, okay, for the time being. So what happens is Ms. Keeler, or the prosecutor, does what she shouldn't do. She is the one that indicates stand down, please. In response to his Lordship, in the previous lines at line 17, saying, well, she does enough, that's enough. And at that point, what we say should happen and properly happen, so we don't run into these types of difficulties, the prosecutor, in any case, should stay out of the mix. This is the example I spoke of yesterday, where you may, in certain circumstances, have a very short preempt kind of hearing. But it has to be a matter for the judge, not for the prosecutor to be involved at all.
But Mr. Pettingill, the judge has said she does enough, that's enough. Surely the judge at that point is dealing in a practical way with and saying that the juror in question is excused. It's the judge's decision, is it not?
I would say, my Lord, it is. I'm not making great hay of this one, right? But I'm not. But I do think, and I didn't hear, but I do think it is a very pellucid example of, where the judge is seen to clearly make a decision or a ruling, albeit where I say the prosecutor shouldn't be involved by uttering the words stand down or stand by. In my respectful in my respectful submission, his lordship in this instance is indicating that. He's saying only answer me. Now it seems to go off the rails with regard to the ones that are to follow.
Right, but okay, we're just pausing there, but you accept in relation to this one, it is in fact the judge's decision.
I accept that this appears to be more the judge's decision than it is the prosecutor, but I would respectfully say that two things to this, my lord, that the prosecutor shouldn't be in the mix, and it does have the appearance, in my respectful view, of the prosecutor being involved in fashioning, running the show, because she intervenes in the judge's comments when he says, well, she does enough. The prosecutor seems to take it upon herself to say, all right, we'll stand down at that point. She's not letting the hearing progress. So I'm not saying it's not a matter of concern, and it's not certainly as straightforward as it should be. The judge makes the finding, the prosecutor should be out of it. So it doesn't.
Well, I follow all that, but I mean, the answer is yes or no. Do you accept that this should not be classified as a Crown standby?
I would say in this one, my lord, in the balance of it, that I could accept that it wouldn't be classified as a Crown standby because of the comments of the learned judge.
Right, thank you.
But with respect to the caveat, not to gild the lily, my lord, it doesn't help with the appearance. That's what I'll say, because of the intervention of the prosecutor, which ties in with the rest. But I do accept that. So, my lord, at 9.5 of the submission.
Well, now, wait a moment. You say you were prepared to accept that it's not a Crown standby, but then you said, but it doesn't help with the appearance.
The overall appearance. That would be my submission. It doesn't help with the overall appearance, the fact that the prosecutor wades in. And with respect, in addition to just the mere numbers, I think your lordships have to look at the overall appearance of the conduct of the Crown and in the jury selection process. So on this one, I can accept it would not count as a Crown standby. I would respectfully submit that it has relevance to be considered, that it doesn't help with the overall appearance of fairness and the avoidance of bias, if I could put it that way, because of the fact the prosecutor intercedes. And the judge warns her of it. Basically, you stay out.
But Mr. Pettingill, I suspect the reason my Lord President asked you for a yes or no answer is that it does appear from line 17 and 18, that's enough. So the judge is the one giving the indication. Crown Counsel simply assisting with moving the process on. Nobody looking at that would think that Crown Counsel has made the decision instead of the judge, would they?
I wouldn't say that much, no, my lord, not at all. I agree. No one would say.
Okay.
I would say the judge has made the decision there.
Right. Okay.
I'm respectfully saying that in these instances like that, the prosecutor shouldn't be involved at all. It should be a matter where the baton gets handed over to the judge.
Right.
Okay.
Well, if the judge says that's enough, he's effectively said stand down or stand by, and Ms. Keeler simply puts that into words. Anyway, right. Well, that's that one.
Yes, my lord. I won't split hairs with that, fella. With respect.
Okay, thanks. Right. Then we have just a moment. Yes, if we go to page 17.
Yes. Line 6. Apologies, I said paragraph 9. I should have said line. Line 6.
Yes.
So, if I may, my lord, Miss Glasford is called, says, I know, something indiscernible. Then she says Linda Wilson, Kathy Williams, Kirk Saunders, and she seems to have to think about it, Hassel, Vance Hassel. Miss Keeler at that.
Who are all that lot? That's witnesses, are they?
I gather those are people that are on the witness list, my lord. Yes.
Yes.
Don't know what. Now, point there is don't know who, what, or what roles they fulfill. So, Ms. Keeler's just got the list, to Mr. Mahoney's point. So she doesn't, those are people whose names are called. She knows no more. She says, stand down, my lord.
Mm.
That's it. Done. That is definitely a Crown standby.
Right.
All that's said is, I know 4 names. And at that point, there's no other comment. There's no further inquiry for certain. For some reason, the learned judge doesn't wade in at that point. And I'll come to a later one, which is important because he talks about doing enough. And I would submit that is very clearly the Crown running the show. There is no interceding by the court. There's no comment by the court. It's a straightforward standby. And that's your number 4.
Yes. But if we are looking at this on a wider spectrum as to whether or not there was an appearance of bias in the selection of the jury to a fair-minded and informed observer, leaving aside the question of numbers, if he's sitting in court and sees the prospective juror say that he knows 4 of the witnesses, 1, 2, 3, yes, 4 of the witnesses, and immediately the prosecution says stand by, would he think that that was an indication of bias?
Well, yes. And I'll indicate why, if I may, my lord. Because we rewind it back to the fact the prosecutor is controlling the show. And if he does an analysis on it, his view would clearly be the prosecutor is the one who decides who stands down. With respect, he couldn't think anything else. That reasonable observer, he's going to be thinking the prosecutor controls this process. Now, he may not, my lord, in his mind, label that as, oh, that seems biased. But because of what should occur, and because we know what the rules are, he in his mind would clearly think the prosecutor's running the show on this jury selection. And once he thinks that, in my respectful submission, it's akin to him realizing this is a biased process. He's realizing that the prosecutor is having more say than the defendant. He's realizing the prosecutor is having more say than the judge. On an evidential basis of those facts, it can't amount to anything else but the observation of bias.
But Mr. Pettingill, it's surely in a different classification than the first 3 that we've identified at the top of your paragraph 9, where standby comes right away.
Yes.
So isn't the impartial, reasonably well-informed observer going to say this is in a different category than the ones whose names were mentioned? Number 4, Herbert Crisson, and immediately you get standby. They're going to surely look at this case differently than those 3.
Well, my lord, what they're going to see, they're not going to see any form of any explanation. What they're going to see is the prosecutor issuing the word standby on the basis of the prosecutor's assessment. That's what they're going to
not just on the basis. It's the court that has said to Ms. Glassford, any concerns? Yes, madam. And she responds to the court saying that she knows these 4 potential witnesses. Ms. Keeler says, stand down, my lord. I mean, that's written like that could be interrogative. Stand down, my lord. You know,
to which he says nothing, my lord. This is the point. That had he said at that point, yes.
My question to you was, do you put this in a different category than the 3 clear standbys where the standby comment was made immediately?
I absolutely do not, with respect, my lord. I do not put it in a category at all. And if I may say why, it's because it doesn't matter if there is some verbiage around it, if it's just to preempt standby. Sometimes these things are mixed bags, or if it has some, reason that is given, right? It's the prosecutor in this instance that runs the show. And to your lordship's point, if that were to be read as a question, stand down, my lord, then his lordship doesn't answer. So it just is not within the control of the court, and it can't be, it has to be one or the other, in my respectful submission. And once your lordships arrive at the point where the prosecutor is the one that is determining the standby, and some of these are more lengthy, they're in the same category. It's the words and the result. And if there's no intervention by the court on an assessment, then it's the prosecutor's standby.
Pettingill,
Yes, my lord.
if you might turn back to page 346, where we see the judge setting the context from the very beginning for this exercise. Bearing in mind what the objective informed observer might think. If one reads from line 12, would such an observer be concerned that it's really the prosecution taking the decision, having been advised by the judge in those terms before?
I missed that last part, Justice, I'm afraid, sorry.
My question is whether the impartial and informed observer, having been aware of the judge setting the context for these challenges in the way he did at page 346 to 347, whether it might reasonably be thought that it was really the prosecution standing the juror down.
Well, my lord, I think that, and I'm obliged to your lordship for raising this, because I certainly, it is quite considered direction that is given by his lordship. I highlighted the key element at paragraph 6 of my submission on leave, in that the direction, if we go back even further, that he gives, my lord, at page 5.
Yes, that's page 346.
That's right. Yeah, that's it. Let me just get the.
Well, it's the next paragraph that you quote on page 5.
I'm obliged, your lordship. Yes. When the names of cause advise, you consider the following questions. That is there anything known to you that a reasonable person with knowledge of that information would say, you, by reasons of probable bias or favor, may be incapable of rendering a fair verdict in this case? If your answer to the question is yes, you should indicate and you may be excused. In aid to that question, you consider the following. 1, do you know any? Do you know the accused person or any of the witnesses or the relatives or the associates? And this is the key line, in such a manner or to such a degree that you may not honestly, that is without bias or favor to any side, deliberate in the matter on the basis of the law you shall hear and the evidence you shall hear in the trial only. My lord, the point is this, that has to be and must be something that occurs in the assessment of the court, not in the assessment of the prosecution. It is for
that is understood, but we see the juror volunteering the concern.
Yes.
The prosecutor, perhaps one might regard as directing, one might also regard as trying to assist, but then the judge acquiescing. Now, having given those early directions, could a reasonably informed observer really believe it was the prosecution taking the decision?
Well, when the prosecution, my lord, is the ones that tells them that you're off, then who else? They're going to go by what they hear and what they see and what their senses perceive. You've heard the directions, and then you've heard the prosecutor tell you, stand down, stand by. It's not an assessment by the court. And the next point is this, that it's not for the prosecution.
Mr. Pettingill, if I may, I mean, we all know that this jury selection took place in front of Mr. Justice Graves.
Yes.
If Mr. Justice Graves felt that his role as the decider as to whether a potential juror should be excused for cause was being usurped by the prosecutor, don't you think that he would have said so?
No, my lord, with respect, I don't. And what I think has happened through the course of this, and I said it at the beginning of these proceedings, is that all of us participating in the justice system, I think at times fell into bad habits. And there is one occasion here, my lord, well, to your lordship's point, if that is the case, his lordship said that previously when he said, just address, speak to me, address it to me. Sorry, let me just be very clear on that, my lord.
I've got it. That was
said,
one at page 16.
Right. So that, with respect, makes your lordship's point, if I may, a very important one. Because yes, it's Justice Greaves. If he intervened there, why didn't he intervene on the second one? I agree with your lordship. If he had a concern, he should have agreed. What, with respect, his lordship was doing was allowing the prosecutor to stand the juror by. That's a straightforward read of it. And I agree with your lordship, right? He has fallen into the trap of the prosecutor gets as many standbys as they want to. And I don't say this disparaging, my lord, but he's not bothering and going further than that. They've decided that this is the appearance of that, I would say, is a reasonable appearance. That the prosecutors decided, well, you know, that's enough. And he doesn't intervene. When, to your lordship's point, he should, shouldn't he? He should be saying, well, hold on a second, you're overstepping the mark, because he actually does that in this case on one occasion. So the question, it begs the question, why doesn't he do it on the other occasions? He should. And if he doesn't, it then becomes a prosecution standby, and it can be nothing else because there's no involvement of the court. My lord, that was
well,
so
just,
we
a
at,
just a moment.
Yes, yes.
If the question was, is there an appearance from the selection process that the jury was biased or might be biased, that must mean biased in favor of the prosecution. And the idea that the selection process was apparently biased in the prosecution because the prosecution stood by 4 witnesses in circumstances where the judge had given the indication that witnesses should speak, in effect, if they knew any of the jurors should speak if they knew any of the witnesses, seems rather bizarre. I mean, if I was sitting at the back of the court and saw that this was going on, would I seriously think that there was a real risk that the jury to be selected was biased?
My lord, again, what you would be thinking is, and let's go back to the direction with respect. The direction is a direction of the court. And what the court is saying is that it's a matter for them to assess whether they should, whether jurors should be excused, a matter for the court to assess. So what your lordship, with respect, would probably be thinking, and should be thinking if you were at the back of the court, and I say it's quite obvious, is that once the prosecutor steps into the role of excusing the juror, then it's the prosecution that is fashioning how they want things to go. They're making the determination, or this one gets stood by for the reasons I have heard. And those reasons, with respect, when one reads the direction, are not sufficient. That's the point. The prosecution's making a decision. That's number one. The prosecution's making a decision. And number two, it's on insufficient reasons. It's just calling a name. And his lordship's clearly given the direction. You can't, you know, you have to have a full of assessment. And what does he say, my lord? You may be excused. If we just go back to that, Justice Smelly raised it, it's at 347. He says, you ought to indicate so that you may be excused. That is a reflection of the function of the judge. And what he's saying is, I'll assess it, and you may be excused if, to such a degree, after examination, I consider that you warrant being excused, or if you should serve, or if you should serve on the panel, not for the prosecution to exercise what they take the view and what the court is taking the view. This is the problem in that time, that they have unlimited standbys and they can go ahead and call as many as they want to. It makes it, I mean, it makes it convenient at best, doesn't it, my lord? If the judge doesn't have to get in the mix on, the degree and all the rest of it, the prosecutor could just intercede and say, stand by, we press on. And the judge, in my respectful view, is falling into the trap of, you can have as many standbys as you want to.
Yes.
Again, you ask you to look at top of page 17, where the prosecutor's response to the witnesses raising the concern. She said, stand down, my lord. Now that suggests to me that the question of whether the juror should be stood down is one being addressed to the court.
With respect, my lord, I would say that's ambiguous. I would say that's just, we all use that term of phrase. Once you say, anybody would say stand down, my lord, as a sign of respect. Like when I'm speaking to your lordship, I say, no, my lord, yes, my lord. So it
one
possibly
doesn't normally call a juror my lord unless they happen to be one.
No, with respect, my lord. She's addressing the court because that's the way it goes. The prosecutor indicates to the court that there's a standby. So it's a valid form of address. On any of these, I think as we go through, sometimes perhaps there isn't the formality of it, but I would say that it'd be quite common and courteous and right for a prosecutor to in making that decision, say, stand by, my lord. That's what I would say. I've said it countless times over the years, stand by, my lord. I'm not asking the court the question. And by my lord, with the greatest respects, my lord, it would be reaching to try and assess that could somehow be a question that was being posed, because his lordship doesn't answer. And I would say that with respect, it simply isn't. And if she is asking the question, if we want to take it that far, if she is asking the question, then the court should go back and address itself on the process that is laid out, and the court should intercede at that point and ask the questions of that juror, particularly in this case where there's another one that we're going to come to, where his lordship indicates she doesn't do enough because Mr. Silvery says I went to school with him, right? He allows this to go, allows it to run as a standby. And that, in my respectful view, is unequivocally clear on reflection of this record, because there is an occasion where his lordship intervenes and says, well, hold on, that's not enough, only address, and here he does.
Right. But let's assume that the observer thinks that the prosecution is in some sense fashioning the jury. If he perceives that the prosecution is fashioning the jury because the putative juror has said that he knows the witnesses, why does that indicate bias, and in whose favor?
My lord, what it indicates, again, he's pulling it right back to it, is that what it indicates is that the prosecutor is making the decision on who comes on and who goes off. There's no explanation, and so it's not. And by the way, the reasonable observer may well think, my lord, well, that's not following the guidelines that his lordship just gave us at 3:47. That's what the observer's thinking, my lord, because he's probably saying, well, we have to take the directions of the law from the court. The court has told us if we know somebody, raise it. And then there has to be an assessment. And then there has to be a position of, does it go far enough? Is it to such a question to such a degree? So merely saying, I know these people doesn't get you home from the court standpoint. So I respectfully say the reasonable observer is saying, well, that doesn't follow the direction of the court. The prosecutor is making up their own decision on whether they're going to be on or not, contrary to the learned judge's directions just a few passages earlier.
Well, the judge's directions at page 346 of the record, when your names are called, you consider the following question. Next, you should consider the following: do you know the accused, the witnesses, or associates in such a manner or degree that you may not honestly, that is without bias or favour, deliberate to come to tum. And then skipping a few paragraphs, and do you hold any views that are so strong that they may affect your judgment? 15, if your answer to any of these questions is yes, you ought to indicate so that you may be excused. So the judge isn't saying, of course, if you raise any of these questions, we shall have to have a hearing. Simply saying, raise these questions in order that you may be excused.
Yes, my lord, but you've got to raise the questions, not just call the names. And then he sets it out. It's not good enough to say, I know Bob Smith. The judge isn't going to say you're excused on that basis. He's going to follow his own directions. What he's doing, he's letting the prosecutor, because of the habit of this, intercede and say, okay, stand by. He doesn't have to bother. I'm not saying that in any, let me be clear, I'm not being disparaging on Justice Greaves or any other justice, because this has happened time and time again, right? But what has happened in this instance is that it's an easy route, isn't it? The judge sets out quite clearly and quite pedantically, if I may say, what the process is of being stood by, because the next question from the court would be, how well do you know this person? You know, do you feel that you can make an honest decision? All of those questions. If they say no, 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 then the judge would say you're excused. So the read has to be there, you may be excused, as in not you'll have permission to be excused. That's number one.
Yeah.
It's that the court, when you use the excuse, is not a standby. Excuse is only a function of the court. That's number one. Number two, he goes through quite painstakingly a whole list of criteria that has to be met. So what happens in the challenge of this juror is that those criteria aren't even addressed. They're not even addressed. It's an easy one, and we don't know. And the analysis would be, we don't know what the reasons are. It's an easy one for the prosecutor in their mind, could be thinking, well, I don't like the look of this person anyway, not because of race or religion or for whatever reason, they're making that decision. Okay, we'll let that juror go. It could well be they don't like the look of them. We don't know. We don't know because there's no valid, proper assessment that the judge's direction has to occur.
Mr. Pettingill,
My lord.
if you go through the entire transcript, the occasions when the Crown is standing by a potential juror, every time the words used are stand by. We see that page 7 of the transcript with Mohammed, over the page 8 with Simons.
Yes.
And it's the same. If you then go through and see the instances, I'm going from the transcript numbers because I've got a hard copy that does it. Page 13 of the transcript is Ms. Outerbridge. She says at the end of page 12, I know Mr. Brangman. Ms. Kayla says, clear, top of page 13, clearly conflicted if she knows him. The judge uses the words, stand down, madam, stand down.
Yeah.
And then similarly with De Silva, and the court asks, what role does he play? The court says, page 14, line 18, we're not going to go to that deep. Then he steps down, we can always call him back. And again, the prosecutor, top of page 15, uses the stand down phrase after the judge has given some reason why the juror might be put to one side. Then on page 15, you've got at line 9, Christen, immediately stand by. So the prosecutor's using the right language. Then at 16, at line 19, this is after Ms. Eve has said she knows witnesses. Again, the prosecutor uses the language stand down. Ditto with Mr. Glassford over the page.
Your Lordship, see, with respect to your Lordship's point, the line after that, the judge intercedes and says, only answer me, okay, for the time being.
I've seen that. I've seen that. Yeah. My point going through all of these is that where the prosecutor wants to stand a juror by, she uses that language. And the language of stand down is used both by the judge and the prosecutor, but seems to be where there is some cause, knowledge of witnesses and so on. And I just go back to my Lord's question. In those circumstances, is the reasonably informed independent witness going to say that there's a difference between the two? I think so.
Between, well, I hear your lordship,
between the ones where the prosecutor said stand by as soon as the name was called, and the occasions when there's been familiarity with a witness and the stand down language is used.
Well, my lord, I think I'll come on to those because I think it's a mixed bag. Sometimes we hear stand down, sometimes we hear stand by. That's why, and your lordship's raised this before, they seem to be interchangeable.
Almost. No, that's exactly, Mr. Pettingill, why I went through the exercise that I did. They're not interchangeable. Where the prosecutor wants to stand by, she says so right away. There's no reason given that might be a grounds of excusing a witness because of knowledge of a witness. And the stand down language is used where there is knowledge of a witness, and it's used by the judge and by the prosecutor.
My lord, the position becomes this. I've got to go through the rest of these because they're not with respect. I've seen the ones your lordship has seen there, and I would highlight that by saying, yes, in the ones that you pulled out, his lordship gives an indication on there. The trouble is that the prosecutor, with respect, should be in the mix. These are matters for the court when the question is raised, and that shouldn't be set down.
Mr. Petty, I understand that point. You say the prosecutor's usurping the function of the judge. Got that point.
Or even that, my lord, even go this far, that they're working in concert with the judge, I would say creates the appearance of bias. That shouldn't exist.
Right.
So not usurping. I said it yesterday, they seem to be working in tandem or they're tag teaming, or they're involved in the decision-making process. That, in my respectful submission, the appearance of that is unfair. Those are separate functions that are unequivocally set out in law as between what a prosecutor can do, what a defendant can do, and what the court should do. And there should be no marrying up between the prosecutor and the judge in that regard. My lord, I think that point gets made at, and I said yesterday, my lords, it has to be that these lines are drawn. Why else would they be there? These are matters of law that are set out in the legislation. We can't have it where a square peg gets fit into a round hole and that a license is given for the prosecutor to be seeming to somehow be making a decision or influencing a decision or fashioning it or, or taking away the function that the judge should be doing. So, my lords, at page 19, which is 360 of the record, at line 3, oh, sorry, if we go back, to 18, my lord, because that's where it starts. The court calls Clifton Webb. The court says...
Yes, the next one is Clifton Webb.
Yeah.
You deal with that at item 6 of your letter.
Thank you, my lord, yes.
Line 6.
Yeah.
Just a moment. Clifton Webb, 49, just... Right. And he says, know the family of Mr. Darrell.
Yes, that's at 18. Yeah.
The court says, Mr. Webb says, Nathan Darrell. And the counsel says, stand down, my lord.
Yes. That's it. There's not the question isn't asked there. It's the counsel that intercedes. She hears it. Very limited facts. Knows the family. Doesn't go through the process that his lordship indicates. What's the question of degree to such a degree there? The court's not doing the assessment. The learned judge is leaving it to the prosecutor. She's exercising a stand by, stand down, whatever it is. She's removing the juror from the process, not the learned judge. The court makes no inquiry about the extent of the relationship, as he indicates in directing himself that should be done, whether Mr. Webb is capable of acting without any bias. It's the prosecution that in this instance stands down. And to Justice Bell's point, the court doesn't raise an issue of stand down there. There's no conversation. There's no assessment by the court. The only thing the court says, he asked the question, quite rightly, any concerns, as every juror gets asked. His only next comment is, whether that a question mark, whether that means, because, well, one can see what it is. I know the family of Mr. Darrell. The court says, he says Nathan Darrell. In comes the prosecutor. Stand by. No comment from the
no stand down, not stand by.
Stand down, right? Stand down, my lord, right? But that's not the prompting of the judge. There's no assessment there, my lord, surely. It's a You know, and by the way, could it be a question of to the prosecutor? And this is the problem, I say, arises. Is that a question to the prosecutor? Are you going to stand them by? You know, or
he may simply not have heard what he said when he said Darrell.
I'm sorry, my lord?
He may simply not have heard when he said, no, the family of Mr. Darrell. He may not have heard Mr. Darrell.
I think that's probably what it is. I think it's probably what it is, which makes it even, which it goes even further. So there's absolutely no consideration. There's no question by the learned judge. It's just getting the full name, Nathan Darrell. The judge doesn't then say, well, how well do you know Mr. Darrell? Or what family members are you talking about? Do you feel that you can do this just, fairly? Do you feel that you can reach an honest decision? That's the function of the judge. Doesn't happen. The prosecutor steps in and runs the show. And my lords, in this one, to highlight, anybody observing it is going to be saying the prosecutors made that decision because the prosecutors heard that he knows Nathan Darrell. The courts had no involvement.
Mr. Pettingill, it's important that we bear the context in mind, because while your point is well taken as to what the law requires for a challenge for cause, we are here concerned about what a well-informed, impartial observer might think. You mentioned earlier what I might describe as a tradition for which you partially take the blame and you think all your colleagues should.
It's a bad habit, I would call it, my lord.
If the tradition is that the judges are relaxed about pronouncing a decision where challenge for cause is apparent, why would one think, observing that process, that it is lopsidedly in favor of the prosecution and result in an impartial jury, in a partial jury, rather?
Well, my lord, let's take your lordship's key word there, apparent. How do we arrive at apparent? I would say that means it's clear, it's unequivocal. That would involve an assessment and a process.
Wouldn't the putative observer we are talking about be deemed with an understanding of the tradition that we are discussing?
No, with respect, no, my lord. Those jurors aren't court all the time.
Law requires.
I'm so sorry, my lord, I spoke over you.
Well, I think I got my question across.
No, I think I with respect, I think I missed your last question, my lord. Your last question.
Right. The putative observer.
Yes.
For whom we are all concerned.
Yes.
Being aware that this is a tradition in the courts, that the judge will not formally rule upon every challenge once cause is apparent. Why would such an observer observing this process come away with the impression that the jury would have been partial as a result of it?
Thank you, Lord.
When I say this process, I mean a situation where prima facie cause has been shown based on the directions the judge earlier gave. These would be matters for consideration. The prosecution then proposing standing down, the judge not disagreeing. Why would an impartial observer be concerned that that results in a rigged jury?
Well, my lord, it's going a bit far to say that it's a rigged jury. If we could roll it back, your lordship says, one, tradition that the jury pool would be aware. With respect, I disagree with that. I'm aware of it.
Just a minute. The proposition of a tradition is not mine. I'm going on the basis of what you said earlier. I may have attached the epithet tradition to it, but this is a practice you said it was developed, and you all should perhaps take the blame for it.
I've certainly.
If that were so, and the informed observer is aware of it, that the judges tend to be relaxed about having to rule on every challenge for cause, which is prima facie established, why would observing that process leave one with this impression?
Well, I'm aware of it because I've been there a lot. And so it's a mea culpa of mine to say, not a tradition that we fell into the bad habit, but it might be, as is often the case, that the person on the jury panel, it's their first time there. And what's the rules, my lord? They have to follow the directions of the judge. And the judge very clearly, and thankfully in this case at the beginning, sets out, as your lordship's endeavoring to figure out now, here's the criteria for reasons for which you may be excused by the court. So that I with respect disagree with your lordship, that observer isn't going to know, oh, this is how they do things and thinks it's all okay. He's going to hear what the judge has said. He's going to hear that there should be a process of examination, which does not occur. And what he's going to see is the prosecution stand down the juror. And what he's going to assume is that the prosecution can do that, that's their right to stand somebody by. It doesn't have to be the judge, because the prosecutor is the one who's making the determination and not the judge. And this one, with respect, that we're looking at now is very clear on that. Surely your lordships could not reasonably, with respect, consider that what happens here at 18 is following the guidelines that his lordship sets out a few pages earlier, which are quite extensive. Your lordships can't consider that in the case of somebody saying, I know the family, not Mr. Darrell, I know the family. I mean, he's gone wide, it's Bermuda. He knows the family. Right? There's no question as to degree or to extent or to what it is. There's no assessment. It's Ms. Keeler, just 2 lines later, very peremptorily says,
well, my question is not based on the proposition that is following the guidelines.
Right.
Obviously not following the guidelines. The question is, well, what impression should one take from that?
Thank you, my lord. The impression is the prosecutor's running the show in that instance as to who gets excused. That's the impression, because that's what happens. The prosecutor is in charge of that juror being stood by. That has to be, in my respectful submission here, as clear as a pikestaff for any observer looking at that. Oh, that's one where the prosecutor is deciding that person has to go, not the judge. And once you arrive at that, you've got a problem. You've got a problem, a very clear problem. And it's made very clear in the instance of Webb, as much as any of the others, very clear. And I don't think, with the greatest respect, my lords, that, are we going to endeavor to fairly build that out to say, well, it could be that, there's an assessment there, and that the reasonable observer is going to look and think that's a decision of the court? It simply isn't. It just simply isn't. There are others. I take Justice Bell's point. There are others where the judge says it. The judge says that's enough. She does enough. Okay, that one's gone. Not this one. And this is where it's not a tradition. This is where the bad habits come into. This has been Mr. Mahoney's whole submission has been based on the Crown were operating on the basis of the law, that they had this right. And what's being argued in these appeals is that while this was going on, all along it was in breach of the Constitution. It just wasn't raised and flagged like it should have been, but it was. It wasn't that a new law changed it. It was constitutionally wrong. What happens here at page 18, my lords, is constitutionally wrong. It doesn't follow the guidelines of the court, and the appearance the appearance on any fair measure of it is that the prosecutor, with regard to Webb, is the one that makes the decision that she has to go. My lords, the next one.
Just a moment.
Yes, my lord.
Let us assume that it appears that the prosecutor is making the decision. Why does that mean that the jury will not be impartial?
My lord, it doesn't necessarily, and this is the point with respect to all along, it doesn't necessarily have to go to the jury may be impartial. It's about the prosecutor fashioning as to who gets on it and who doesn't. Once, and we've said all along, once you get to that, it doesn't necessarily ergo mean the jury will be impartial. This is why, you know, in
Sorry, you've frozen.
Yep.
in Trot.
I'm sorry, you froze somewhere back.
Because of the black and white instance and because of the affidavit, it was very, very in the circumstance. My lord, I'm so sorry. Am I back, my lord?
You are now.
Am I back, my lord?
Yes.
Apologies. I didn't even have the excuse of being in Turks. My lord, forgive me, I forgot my train of thought there. To your lordship's question. One doesn't have to go as far as
no, you're breaking up again, I'm afraid.
Ergo, this means that the jury is going to be impartial. That's yeah. Am I better now, my lords?
Yes.
Okay. One does not have to go as far as saying, is the jury going to be impartial as a result of this? It's the action itself of the prosecutor breaching the principles of equality of arms, breaching the principles of the Constitution by having the ability to control the show.
Wait a moment. You say you don't have to show that the jury is going to be, you said impartial, but I think what you meant was you do not have to show that the jury is going to be partial.
Yeah, to the prosecution.
Yes.
Yes, Lord. Yes. Yeah. Sorry. Yes.
It's important to get the negatives right.
Apologies.
You don't have to show that the jury is going to be partial to the prosecution, but do you have to show that there's a reasonable suspicion that the jury will be partial to the prosecution?
No, I with respect, my lord, I would say no, you don't. This is all about, and this is set out, and your lordship's pegged this earlier when we look at paragraph 32 of Trot, I think is very insightful by the learned Chief Justice on that point. But can I just commend that to you? No.
Just a moment.
Okay, my lord.
Well, I see that he says because the Crown has a greater would have a greater role in fashioning the jury.
Yes.
A fair-minded observer is likely to conclude that there was a real possibility that the jury may be biased between the Crown and the accused person. But if the juror sees that each time the Crown takes a greater role in fashioning the jury, it appears to be doing so in order to avoid a position where people who may have a conflict sit on the jury. Would the fair-minded observer conclude that there's a real possibility that the jury might be biased as between the Crown and the accused person?
It's the risk, my lord, that arises. And the risk arises once we give a license to the prosecution to be able to, for whatever reason, fashion that jury or determine, you know, what occurs.
Sorry, you're breaking up again. Right.
To the makeup of that jury for whatever reasons. Impartiality. I'm so sorry, my lord, I don't know. His lordship says offends appearance. My lord, I'm just going to, if I'm assuming, I'm just going to try and plugging in. It may be that it's I'm not getting enough juice. Can you
Right.
hear?
Yes, like I think so. Well, we looked at Clifton Webb, and then the last one is Angela Seaman.
Page 19.
Yes. And the court says, any concerns, Ms. Seaman? Yes, I know Vance Hassel and Linda Wilson. They're witnesses, aren't they?
I believe so, my lord, yes.
And the Crown says stand down.
Yes.
So that's in the same category as Clifton Webb.
Yes. Yeah. No interaction. The court just says repeat. Sorry, my lord, I didn't hear the second witness's name that she mentioned. That's Miss Keylor. The court directs, obviously, the proposed juror to say repeat. She says the name. No assessment, no evaluation. Prosecutor stands them down, stands them by.
No,
Yes.
no, Mr. Pettingill. That's exactly the point that I was making before. She, on all of these 4 additional ones where questions have been asked, she only uses the language stand down. She does not use the language stand by.
My lord, I see that, and I don't. I've indicated with respect to your lordship, having done this a number of times, I respectfully say, I mean, that's just an interchangeable term. That sometimes one says stand by, and sometimes one says stand down. Now, I appreciate in this instance,
Is everybody frozen?
I'm still here, my lord.
Ho-hum.
Is everybody frozen? No.
I'm still here, my lord, if you are.
Yes, well, so am I. Are you with us, Mr. Pettingill?
I'm here, my lord, I'm with you.
Right, okay.
I think it's my Lord Bell who's has lost us.
Are you, Mrs. Bell, are you back with us?
You're mute. Your mic is muted.
You're mute.
Yes, I'm sorry, but everybody froze a little while ago, and I found that if I wait, it comes back. But Mr. Pettingill was speaking, so I missed his finish.
Right, my lord. Actually, it was the exchange between your lordship and I, because I was indicating that, in my respectful view, these are interchangeable terms as commonly occurs.
No, they're not. Mr. Pettingill, that was exactly the point of my raising it. When the prosecution wants to stand by without any suggestion that I know such and such a witness, they did use the correct phrase stand by where there was a concern that they might, the prospective juror might know certain witnesses. Both the judge and the prosecution used the phrase stand down. I accept you say that it's the judge's function, not the Crown's, but there's a very marked difference between the use of stand down and stand by.
In this case, I accept that, my lord, yes. The 3 initial things are, now, whether it's because there's this discussion involves the word stand down after the challenge on Nolan Simmons. I'm not sure if the judge then uses that term, but with respect, my lord, I would say this: it doesn't matter what the term is. I mean, would your lordships have a?
I mean, I get the point. I was only picking up on you. You said there was a regular confusion between stand down and stand by, and with respect, I don't think there is. They were used separately.
With respect, my lord, in this case, I accept your lordship's point. What I was indicating with respect on experience, that in my view, they used interchangeably sometimes. You know, between stand
and wrongly so.
I'm sorry.
And wrongly so.
Yes, I would say, and wrongly so. But I mean, that is again another bad. You know, but that's what.
Ms. Keeler was not doing that on this occasion.
Ms. Keeler didn't do that on this occasion. Ms. Keeler shouldn't have been, with respect, doing anything, my lord. If Ms. Keeler had said, "You're excused," she'd have fallen into the trap.
I have that point.
Right. I don't. I'm trying to assist, my lord, and it seems that your lordship's taking the position that if the term stand down is used in these circumstances, it somehow it makes it different to the role the prosecutor is doing. And I
Mr. Pettingill, I'm not taking a position. I'm just drawing to your attention that prosecution uses stand by in one set of circumstances and stand down in another.
And I agree with your lordship on that. Forgive me, I'm not indicating your lordship taking a very firm position on that, but I want to be very clear that well, I'm hoping that I am being, that it doesn't matter what the term is. She could, with respect, say, "Okay, you're off," or "Go away," or whatever it is. It's still the prosecutor is the one.
It should be the judge. We have that point.
Yeah. Okay. So, my lords, sorry, coming back to it then, Justice President, we're at paragraph. At page 19.
Yes.
Seaman, I think it is. Beginning of line.
Yes, my lord. It's at 19, line 14.
Yes.
Yeah, sorry, that's the Van Tassel one. That's what we just wonder where Miss Keeler says stand down.
Yeah. So where we've got to, let me just make sure that you say the standbys in the present case are the first three, which is Mohammed, Simons, and Crisson, which the Crown accepts, and Eve, Glassford, Webb, and Seaman.
Yes, Lord.
Just a moment. I've lost. Just a moment. There he is. Yeah. Right. And you say, as I understand it, that offends the entitlement to equality of arms.
Yes.
And you also say that it means there's an appearance of bias.
Yes.
Because
the perception of the reasonable observer is that the prosecutor is running the show on who stays on and who goes off. And now I think about it, my lord, let me make this submission, because Justice Bell's just caused something to the pen to drop with me. This case is even worse, because I'll agree with Mr. Mahoney, and to Justice Bell's point, there are three standbys. What makes it really offensive is that on a straightforward read of it, there are three stand downs by the Crown. So those jurors, if they're being excused by the Crown on the basis of analysis, it makes it even worse in this case. That the Crown goes well over the line. They're not just doing standbys, they're now doing stand downs. They're now doing excusing of jurors. So candidly, it gets worse than just being a number of standbys. And the the stand downs or the jurors being excused are not being done properly. They're not being done on the basis of an assessment of those facts. But it's clear, unequivocal, that it is the prosecutor that is making the call, if I may coin a phrase. The prosecutor is the one who is making the call in all of these instances. So we have at page 7, page 8, page 15, jurors 26, 38, 14 are stood by. There's no interaction. The other ones that I highlight are the stand downs, as Justice Bell rightly points out. Even worse. Even worse. The prosecutor running the show on who gets on that jury and who doesn't. And that's the point of this whole case. So we're a minimum of 6, even if your lordships are considering that, as I effectively conceded, I say it's gray, and it's not that the juror at page 16, that's where the judge say she does enough, and very clearly it's the judge is the one that excuses her with the use of the words that he does. So when the judge comes into play, makes an assessment, it's excused, as it rightly should be. It's not for the prosecutor to pick up the baton and start standing jurors down or excusing them on the basis of her assessment. There has to be that assessment by the court. And the appearance then can be nothing other than the prosecutor is the one that's making that decision.
And I suppose you say that that has the appearances that the prosecution is making the decision, which means that it is possible that the jury is not impartial because jurors who might be on it have been taken off.
Embrace that, my lord. Thank you. That's what I would say. And let's be clear, in the instances of the first 3, this is the risk in this case. Those first 3 may have come back. One may look at it because, to Justice Bell's point, that these are stand downs, that they're gone. They've given a reason and they left the building, as it were. It's even the prosecutors in this case has gone beyond her function of excessive standby.
Doesn't that suggest they're not actually being used as standbys?
I missed you, my lord. I'm sorry.
Suggests they're not standbys in the proper use of that word.
Yes.
Words.
Yeah. They're worse. They're worse. That I oblige your lordship for highlighting that, because when one looks at the circumstances involved, as I've endeavored to do here with each of those, it's not even in the ballpark of any form of analysis. It's not in the ballpark of the judge making the decision. It's the prosecutor. Clearly, stand down. Now I see it worse.
Which one are you referring to? The first 3 are stood by.
Yes, my lord.
And the others are stood down.
By the prosecutor. Yes, my lord.
Yes. Right. Okay. Thank you very much.
As I can be of further assistance, my lord, I'm obliged.
Not currently.
Thank you, my lord.
Right. Now, I'm not quite sure what's the most appropriate method of proceeding. Would it be sensible to ask Mr. Mahoney if he wishes to make any observations in relation to Brangman?
I'd be obliged, Ron.
Yes, sir. In respect of Brangman, sir, my submission is that one have to take a practical view of the whole process. And on the occasions where a juror has indicated some basis upon which they could have been excused for cause, and the prosecutor interjected by saying, stand down. The prosecutor was actually trying to be helpful, and the judge acquiesced. When that happens, the juror does not leave the courtroom, as what Mr. Pettingill suggests. Although the prosecutor said, stand down, they are, as we had indicated earlier, sometimes it is, well, stand down, stand by used interchangeably to mean stand by, generally when a prosecutor says stand down. And they remain in the courtroom until the judge tells the person or the panel that they can leave. Taking a practical view to the whole process, because in effect, if we were to go through the whole process of for cause, we still would come back to just 3 jurors who were stood by with no reason given, and would ask this court that, looking at the whole process from a practical perspective, that the persons who gave reasons which would be sufficient for them to be excused should not be counted in the standbys, as invariably they couldn't sit on the panel anyway. Specifically, I wish to just briefly address that juror that is referred to at page 14 of the transcript. This is a sorry, it's not 14. I'm looking for the one where the judge said to address me. I think that's Miss Eve.
Page 16 of the transcript.
Line 19. Yeah.
Thank you, sir. One should also take into account what transpired above line 19. We're starting from line 4. Miss Eve says, Marie Iris, Robert Goodchild, Marie Iris is aunt. Mr. Richardson interjected, they are not contentious. Ms. Keeler, Your Worship, I don't think there are going to be any difficulties with that. Mr. Richardson, they are contentious. All right, next one. Miss Eve, I know the defendant's father, auntie, and the defendant. Mr. Richardson, we have no issue with that. Then Miss Eve responded, Deborah Wellman and the court, well, she does enough, that's enough, stand down, please. And the court says, only answer me, okay, for the time being. It could,
who's that addressed to? I can't understand who he's saying. Only
well,
answer.
my lord, it could very well mean Mr. Richardson, because Mr. Richardson, Miss Keeler said one thing, then Mr. Richardson, then Miss Eve answered, then Mr. Richardson, and then Miss Eve answered, responded. So when the court said, only answer me okay for the time being, it could very well include Mr. Richardson. Does the court follow?
No. I mean, only answer me means don't answer somebody else.
Yes, sir, but it could have included Mr. Richardson, because Miss Eve, if one goes back up at line 12, Miss E said, I know the defendant's father, auntie, and the defendant. Then Mr. Richardson says, we have no issue with that. Then Miss Eve said, Deborah Wellman. And then the court interjected. So a bit lower at the bottom at line 21, when the judge said, only answer me okay for the time being. It is possible that it could have included the exchange between Mr. Richardson and Miss Eve.
Yeah. Pretty obscure.
Yes, sir. So in my humble submission, sir, it's really 3 standbys without, that could not, well, 3 standbys without any excuse, sir. All the other persons had sufficient excuse that would have removed them from sitting on the panel in any event. And from a practical perspective, one cannot include those persons when looking at the numbers.
Right.
And that's all I have to say in regards to that matter.
Okay. Right. Okay. Well, shall we go on to the Smith-Williams case?
Certainly.
Just wait a moment. Now, in relation to that, we have just a moment. Trott and Duncan's letter. Sorry, schedule. Moment.
There's a schedule at page 152 of the supplemental bundle, and then there is the latter pages of our response to your lordship's questions, which covers some of the issues raised in that schedule.
Well, 152.
Can I suggest we go to the schedule at 152 of the supplemental bundle of authorities?
Just a moment.
Mr. Lynch, while the President's just looking for that, I'm going to be difficult because I've received a lot of material in hard copy, and so I'm not looking at the cloud. So if you can identify the document for me, I should be able to locate it.
Yes, it looks like that.
That I have. Thank you.
Oh yes, I see. The trouble is that I have got, I know exactly the document you mean. I have got it in the all-purpose bundle.
The one your lordship ordered to be put together.
Yes, but it doesn't matter. It's the same document.
It's the same document, yes.
It's the same document. But in that bundle, it is followed by your letter of the 26th of February. Well, that's fine. But before we start on that, I have been told that the Crown accepts that there are 6 standbys, properly so called, and I'd like to be clear which 6 they are.
Yes, I can help you with that. And it may be useful to look also at the original transcript so that we're clear about those that they do not accept our standbys. We say raise at least the additional feature of the prejudice that your lordships have sought to identify. in the eyes of the well-informed observer.
Mm.
And so if we can take it through, if your lordships go to the schedule, first of all, that's been prepared by the Crown, the first thing I would say is if the entry numbers, where it says juror number, if we use that numbering system just to identify which line we're talking about, the one that's on the, that would help. The number 7 and number 8 are 1 and 2 of the 6 that they concede. And Mr. Mahoney, if I've got this wrong at all, please do interrupt me. But that's my understanding, is that 7 and 8 are 1 and 2 of the 6 they concede. And then if you go over the page to the second page, line 34 and then 29, which comes after 34, are 3 and 4 near the top. So 34 on the left and 29 to follow. That's 3 and 4 of their 6.
Yes.
And then the next one is 32, which is a couple of columns, a couple of lines down. That's number 5.
Mm-hmm.
And then the last entry on that page is number 6.
Sorry, last entry.
The last entry on that page, line 10, mark 10 on the far left. Last entry, that's number 6. Those are the 6.
Right. Now, is that
Those
right?
are the 6.
Could I, Mr. Lynch, what do you say in relation to the third page and the jurors who are numbered 18 and 16 on that page?
Yeah, they're standby as well. On that page, they are the alternates that were selected by process in court. They formed the additional potential jurors who sat throughout the trial but didn't actually ultimately end up on the jury.
Thank you. I see it.
And I'll come to those in a minute, if I may.
I'm sorry. I'm sorry. Which ones are the 6? 7, 8.
7, 8. Next page, 34, 29,
32, and 10.
Yes.
That's Marion Darrell, is it?
Correct.
I'm sorry. The 6 that I have are Tony Lee Curtis. That's number 8.
Yes.
Next one is Charlene Simons.
Yes.
That's number 34. The next one is Crystal Simmons, number 32. And then Marion Darrell, that's number 4.
What do you mean number 4?
Oh,
I see the number 4 of 6.
Yes, yes, sir. And
that's juror number 2.
When we go over on the back page to the alternates, Keshante Hippolyte would be the 5th one. And the 6th one would be Shanae Headlam Latham. Those are from the alternates.
Right. Well, I'm obliged to that friend because I have misunderstood him, and it's going to be necessary, I think, to look at them all.
What is the concession in this regard?
The Crown says, as I understand it, that it accepts that there are 6 standbys who are jurors numbers 8, 34, 32, 10, 19, and 16.
Yes.
That was what I understood the Crown to be saying. So I was slightly confused by Mr. Lynch.
Well, I'm sorry about that, but I obviously misunderstood.
No, it was very easily done. Right. Well, that's 6 for a start.
Yes. But can I please, in an attempt to try and set out what we say the position is.
Yeah.
Overall, rather than simply those. And before I look at them individually, can I make one observation in relation to what Mr. Mahoney was saying to your lordship earlier? There has to be something more than sheer numbers in order to satisfy the exception test that your lordship was asking him about. So that once we get to the finality principle, the only way one can step outside of that is if there was something more than simply identifying a number, whether it's 4, 5, 6, whatever it is. Can I say, if I may put it in this way, the folly of that and what follows from what he submitted is that if he were to challenge by way of standby all 32, is his position that he is saying that that would still not give rise to what we would submit is the necessary substantial threshold that has to be reached in order to discharge the jury. Our submission is that it simply cannot be right that a miscarriage of justice can be characterized by something in addition to numbers, where the numbers might be significant in a particular case. And whatever criteria your lordships might ultimately apply, if any of these appeals are to be permitted, it cannot be in our submission to exclude numbers to the point at which Mr. Mahoney was suggesting. If I may say so, he seemed to confuse actual bias with apparent bias.
Just let me interject here, Mr. Lynch, please.
Certainly.
I have found reference to another juror who was regarded as stood by, General Parson, juror number 25, on page of the transcript 20, lines 12 to 24.
Yeah. Can I take your lordships through each of these? I hope relatively briefly, but
I'm interjecting now because I think we've just tried to identify those which the Crown concedes were standbys. And
yes,
I'm wondering what the status of this person should be from the Crown's point of view. So that is General Parsons on page 20 of the transcript, lines 12 to 24.
I can actually assist this one, Jerome.
yes.
Ms. Parsons actually sat on the jury. She was included in our letter as well of the 26th of February, my Lord Smelly. The transcript doesn't make it automatically clear who is stood by and stood down. Sorry, stood by or who sat.
So after having been stood by, she came back and was selected as a juror, was she?
Ms. Parsons actually was never stood by. She sat as juror number 1.
I see. Well, if you look at the reference I just identified, page 20 of the transcript.
Yes. Line,
beginning at line 12.
yes.
And that line 21, Mr. Mahoney says, stand by. And the court says, you might be recalled at line 22.
Yes, I think there's a little confusion there because I think what was happening at that point is that the judge was going along the front row of jurors that were already sitting and was effectively pointing to each one and saying, any concerns? And then saying none, as each person shook their head. And then he got to somebody at line 20 and somebody had indicated that there was a concern. And at that point, Mr. Mahoney says, stand by, sir.
I see. So it's not in relation to Ms. Parsons then?
No, it's in relation to someone else.
Mr. Lynch,
courts. Yes.
Mr. Lynch, just at risk of confusing things, that's the document that you produced in November. I wonder if you can see that.
That's our schedule, yes.
Yes, which does have Janelle Parson on with standby Crown, no reason. But I think Ms. Tucker's given the explanation that there was an initial standby, but second time around, she went on to the jury.
Yes, I don't think she actually was ever was on standby. I think on listening to the transcript, what we were able to identify is the judge, as I say, going along the road, which is a way in which he does it from experience, pointing to each.
You actually did, you presented the name as someone who was a standby.
We thought so, yes. And that's why I'm not relying on that document now. And I'm seeking to utilize the one that the Crown have identified. Was never a standby.
Yes.
Right, so we can forget about Parsons.
You can, yes. What is not clear in my Lord Smelly's observation at page 20 is who in fact was stood by Mr. Mahoney at line 21. It was obviously somebody on the jury panel who'd already sat there. And what had happened was Mr. Mahoney said at line 21, stand by, sir. And then at line 20, you might be...
I'm looking at my notes, and Janelle Parson came after Altino Lopes.
Yes, that's right.
Yes.
Right.
Anyway, it doesn't detract from what I'm saying. What I'm saying is that somebody on the jury was being stood by the Crown, which has not, we've not been able to identify who that is, unless it's suggested that was Altino Lopes.
Yeah.
Lopez.
Well, if you're all agreed that for these purposes we can forget about Janelle Parsons, that's fine by me, as the president says.
I think you can. What I am concerned to identify, though, is that somebody was stood by at line 21.
Well, quite.
My Lord, I'm trying.
It wasn't her. It wasn't her.
No, I'm trying to assist because I have my notebook with the notes, and Miss Parson replaced Altimo Lopes. So Lopes was stood by, and then Parsons' name was called to replace that person on the panel.
All right. Thank you.
So the name is not shown in the transcript, but that is what actually happened.
Right.
So sorry. So what exactly happened at page 20?
So what had happened is the juror Altino Lopes,
yes,
indicated that she had a concern, and then I said stand by, and she was replaced by Janelle Parson.
right.
And if one looks at the affidavit, the attachment from Miss Alboy, the police, the jury officer, this is at attachment EA3, you will see the names of the persons who actually were on the panel.
I wonder if it is, rather than diving into the middle of the transcript and the middle of these jurors, it would be more helpful if we just take them one after the other, and I make the observations that we wish to make as we go through. Otherwise, it's going to be somewhat disjointed, and if you'll forgive me, it may be more useful to approach it in that way. And if we use, I'm sure it would be. If we use the schedule that the Crown have prepared, and we can make our observations, make our annotations on that as we go along, then we'll all be working from the same document. And we can make, as I say, our observations as we go along. Can I, in that case, to the transcript at page 375, please?
$375, yes.
375, and that deals with Marilyn Coupidor. She is the first juror that the Crown had put on standby. And your lordships will see at 375, line 12, what happens. She's called, number 7, Marilyn Cooper-Dore, and then Mr. Mahoney says, stand by. And a prospective juror says, stand something, and then she's obviously asked to go and stand by. So that was a standby. That was the Crown standing by a juror. No reason was given, no explanation was given. What the Crown now say, you'll see in their schedule, the reason was given. No reason was given, but she was known to the Crown HR representative for the DPP's office. Is it being suggested, so that I can understand this position, is it being suggested that the reason why she was being stood by at that time is because my learned friend Mr. Mahoney somehow was able to contact the Crown HR representative for the DPP's office and was making a standby on that basis? Or is it something that he's learned subsequently and is now seeking to introduce that as a reason why that person could not have served in any event? I simply don't know. And can I say this, that from a perspective, well-informed casual observer to the circumstances here, can it be said that there may have been some reason that lies behind why my learned friend said standby, but they're not going to know that. Nobody knows that. So in our submission, on the face of what happened, is that that juror was stood by the Crown for no apparent reason. Now, if, and it's important to understand this, there is a process. Whether or not the Crown had a whole plethora of standbys at their disposal, it is not really, even given that that was the law at the time, it's not really a good enough excuse to say, well, we never utilized the challenge for cause process. If this person was genuinely known to the Crown at that time to be an HR representative for the DPP's office, then that should have been stated, not least because it would give us an opportunity that, notwithstanding that, we still wanted this person on the jury. No exercise was ever able to be entered into because the Crown sought to use, right at an early stage, this particular right, as they saw it, to stand this juror by. So in our submission, your lordships should approach this on the basis that this was a standby, irrespective of the fact that there may be now some argument as to whether or not that person could properly have sat on the jury. And it wouldn't be, as I said earlier, in general submissions, it wouldn't be proper for you now to place yourselves in the position of the judge and decide whether or not this person would have been excused.
Mr. Lynch, just to clear up one point, and I'm looking back to my note of last November, and as I understood Mr. Mahoney at that time,
yes,
he was saying that he knew when he said stand by of the prospective juror's employment position, but he accepts that he didn't share it.
Well, I'm afraid that, well, if that was what I make clear, if Mr. Mahoney says that that's what he knew at the time, I'm not going to go behind that at all. I mean, I have no reason to disbelieve what Crown Counsel says. If that's what he says, then that was the position. So if he knew, he knew. But that doesn't really help us.
I understand your point. I just was clarifying that one point.
Thank you very much. Well, I'm grateful for that reminder. I certainly didn't recall it. And if he has said that, then I accept it, of course. But that we invite your lordships to view that as a standby and nothing else. The second one, it seems, is accepted. That's Tony Lee Curtis. That's accepted as a standby by my learned friend for no reason. And then the next one is Anna Anthony, where it was clear that the juror, prospective juror, was a was a cousin of Miss Greening, and she'd been involved in an associated case involving Mr. Saltus, and it was obviously appropriate that she should not serve. But that was clear to everybody, and properly stood down. And if your lordships go to page 377 of the transcript, you can see precisely how it came about. Because,
sorry
yes.
to be difficult. When you give the number for the record, could you possibly give me the transcript number too? I mean, I have it on page 9.
I can. Yes, I can. And in fact, if you use that schedule, my learned friend, Mr. Carrington, has put the number on it. He says page 9.
I found it. So you're quite right. I can get there that
so
way.
Page 9 and 377 of the record. And your lordships will see at line 12, prospective juror, my cousin Victoria Greening was a defendant for Saltus. I don't know if that's related, and so on. And then the court says, was a defendant, lawyer, and then it becomes clear what the position is. Prospective juror not to make it. Mr. Mahoney says, stand down, sir. I think really it should have been left to the court. I don't take any particular point on it. It shouldn't have happened in that way, but the court says not yet, because I might want to find out more later. Very well, says Mr. Mahoney. And then the court says yes. In fact, that person never served. For obvious reasons, and had we been engaged in it, we would have, of course, agreed that that juror should not should not sit on the jury. So no complaint is made about that at all. But at least it's become clear what the issue is. It's not because Mr. Mahoney has said anything; it's because the juror did. And then we go to Sheridan Ming, which is.
Let's be clear, Mr. Lynch. That juror was Ronald Matthews.
No, that juror was. Anna Anthony.
She's not my cousin.
Right.
She thinks she is.
I don't want to.
I don't want to be on the jury.
Anyway, she had whatever reason, she regards you as her cousin, and that being so, we had no reason to undermine the position. But in any event, I take no point on that person. We understood what the position was, and that person didn't serve. And then we have Sheridan Ming in their list, and this person at page 378 or page 10 of the transcript. Your lordship will see at line 10, prospective juror, yes, sir. I do have some concerns. I'd like to write them down for you. So this juror wanted to write down that he had an issue.
But is this in fact Sheridan Ming? Because if you go up a few lines, Court Associates just called number 6 Sarah Cook.
Yes, I think it is Sarah Cook rather than Sheridan Ming. But it perhaps doesn't matter exactly what name it is, but the person, I think we should change that to Sarah Cook.
Well, I don't know, because when we get further down, Mr. Mahoney saying, may he be excused. So that's not Sarah Cook.
Yes, I'm wondering whether or not this is the moment when the judge is pointing to any jurors at the front of the jury box, and that somebody has indicated that they have an issue.
And I suspect it should properly be Sheridan Ming, as the Crown has it.
Yes, I think they might be right.
Well, I think it must be, this must be Sheridan Ming, because he says, I do have some concerns. The court says, if anybody else has concerns, write them down. Just has to be short and to the point. Sir, no books.
Yes,
I don't think
it's a sir rather than a lady, yes.
So
again, no point taken. Either way, no point taken. And a proper procedure having been gone through. Mr. Mahoney says, may he be excused, sir. And then the court says, stand down, sir. That is the right procedure, no complaint. And then we come to the next one, which is Barbara de Souza, which can be found at page 385 and page 17 of the...
I mean, I can get there on my own, Mr. Lynch. Now I'm working from the Crown document. So
thank you. 385. And at line 17, prospective juror, with all due respect, I work for myself. I'm part-time. Oh, sorry, I work for myself. I'm part-time housekeeper. When I don't go to work, I don't get paid. That's my only concern. Okay. All right, down the front line and so on. So at that point, she complains to being a worker. And then later at page 398 at and 9, I think if we can just roll forward 380, 98. It's revisited at line 22. All right, madam, in seat number 2, I think that's that person, Barbara D'Souza, who has to work for a living. You may stand down. That is seat number 2. Let me look here first. This is the judge going along the line as I've described before and allowing that lady to stand down, she having indicated earlier that she was working. So again, no complaint here at all. And then we come to William de Grilla. Have to go back to 379 in our transcript.
I mean, sorry, this maddening nomenclature, but you said she was stood by and then stood down. In fact, I think what happened is that she was excused.
Yes, yes, she was ultimately excused. Yes, forgive me.
Yeah, there's nothing wrong with her sitting on the jury. It's just there was good reason for her not to.
Not to. So we go back to 379. And at 379, William de Grilla, at line 12, again, the judge going along the front line. If you go back a few lines from 12, you'll see still going along the front line. Any concerns, madam? And no audible. Yes, sir. Any concerns? Yes, sir. My only concern is I'm a caregiver to my mother who's had stomach cancer, breast cancer. She's also battling multiple sclerosis and so on, and gives what might be regarded as a pretty good reason for not serving. Ultimately, she is I think I suggested a little further on that person should be excused.
And you were pulled up for it.
I was. That shouldn't interfere, apparently. It seemed to me to be a good reason why that juror should not actually take part in the jury, given the litany of suffering that his mother, who he had to look after, was suffering from. But anyway, there it is. Again, no issue. That person was properly excused. And then we come to page 389, Mr. Bendel Trott. I think it's a man.
Just a moment.
381.
Wait a minute. We've been looking at de Grilla, haven't we?
Yeah.
Yes.
Yes. Just a moment.
That's the one that was looking after the ill mother.
Yes. Yes. Sorry. Yeah. Okay.
Yeah. So Bendel Trott at 381, line 20.
Yes.
I think the same process being done again by the judge, going along the line, and it gets to prospective juror. I have a note here from my doctor. He has some fibromyalgia in my left shoulder and bursitis, I have no idea. Anyway, he's got some injuries and I can't sit too long. I'm in constant pain and so on. Mr. Mahoney says, stand down, sir, before the judge has an opportunity to say anything in response to it. The courts goes, and Mr. Mahoney says, stand down again. And then the court says, stand down. I concede that it was a proper basis upon which that juror could be excused. It was unfortunate, perhaps, that Mr. Mahoney took on the role of the judge, but it was endorsed by the judge, and I make no further complaint about it other than that observation. We then move to Ronell Matthews, and that can be found at 382 at line 14. Again, the judge doing the process. Court associate says, number 35, Linda Simons, yes, okay, that person goes into the box as I understand it. Not you yet. And then yellow shirt, yes. The judge, as it were, dealing with somebody on the jury who's wearing a yellow shirt. And prospective juror says, yes, I have some concerns. I'm a school psychologist and the only one in the school that I serve, and I'm in the middle of doing some cases. And the court then, in the middle of what? Doing some cases. So school just started back, but I started it. It's what I'm saying. I need to continue. You can continue doing what you do. Don't run from me. Don't pack down. I've got to test you. If you pass, you pass. If you don't pass, you know. I'm just concerned if the session's broken up. You still have me a little confused. I'm not sure what you mean. I'm thinking that if I'm a psychologist, I'll be talking with you when I get to talk with them. I don't have to talk continuously. It's not just talking. I do assessments as well in terms of learning and so on. There's this exchange between the judge and the prospective juror. And it culminates at page, ultimately at page 399. The juror wasn't released immediately, but ultimately was. And one goes forward to page 399, and in which it will see there that at line 3 to 9, she was eventually excused.
Sorry, where just a moment.
So there was a proper exchange, as I put it, at page 382 to 384 between the prospective juror and the court.
Yes, but when is she finally excused?
If you go to 399.
Yes. Oh, yes, I've written her name.
Is the judge saying you're stood down?
Yes.
Yes.
Matthews or Karen Scott?
No, that was Ronell Matthews at 399. Let me just a moment.
Although the name Karen Scott appears in line 2, the judge has moved on. But,
yes, and he's gone back to the psychologist who's working at the school.
But the 8 is not the juror number. Is it a seat number? Or?
The seat number, yes.
Can you just explain to me what happens when they start going through the jury list? Do 12 persons go into the jury box?
Yes and no. It does depend sometimes on the particular judge. The habit of Mr. Grieve, my experience has been that he tends to have the names called. They go into the jury box. Sometimes they're asked to stand by before they get there by Crown Counsel. Other times they get in there and then they're asked to stand by. And then yet further occasions when some particular feature is raised by the juror, the Crown Counsel stand by again. So that it can vary depending on the particular circumstance. Certainly there have been occasions when a juror would be stood by before they even enter the jury box.
But if they're stood by when they're in the jury box, presumably they've got to come out of the jury box.
Yes, they have to come out of the jury box. There's then left a hole where that person sat. The judge will go along and see if there are any further reasons why a juror might not serve.
Yes.
And then they're filled in as fresh names are called.
Yeah.
So, so far as Ronell Matthews is concerned, again, no issue. Can I say, but as we get to the end of this first page, what has happened is we've had two, in our respectful submission, we've had two standbys for no apparent reason. I appreciate Mr. Carrington Mahoney is saying that, that the first one, there is a reason, but it was not ventilated, and in our respectful submission ought not to feature at this stage. So at the end of that process on page 1, a number of jurors were selected quite properly, and a number of jurors were either excused or stood down by the judge, or at least with his assent. And I make no complaint about those other than that which I've already observed. But what happens on the next page is a rather different kettle of fish in our submission, because it somewhat changed. The first one is Sarah Cook, and she can be found at 385. At line 16. Here she, yes, ma'am. So again, prospective jury, yes, ma'am, says the court, at line 16. And then the prospective juror says, with all due respect, I work for myself. I'm part-time. Oh, sorry, I work for myself. I'm a part-time housekeeper. When I don't get work, I don't get paid. That's my only concern. Okay, sorry. All right. Down the front line, yes, I have a job. Commitments from 10th to 15th, and then travel dates.
So where
and then the court.
Wait, isn't this Barbara D'Souza?
Yeah, I was asking where you're reading from.
I'm reading from 385, line 16.
Page 17 of the internal number, page 17.
Yes, it is. Page 17.
But you read this to us before. This is Barbara D'Souza. I'm a part-time housekeeper. When I don't work, I don't get paid.
I'm reading the wrong. It's a long day, and I'm reading from the.
I wonder what it was.
Right. So it's Sarah Cook on the previous page.
Yes. So page 16. Forgive me. Page 16 of the transcript. Page 384. My annotation is wrong. That's why I was in the wrong place. Yep. 384 of the record, and 384 at line 16. So we just above that we got 12. So down the front line, any concerns? Answer yes. Prospective juror, yes. So pausing there for a minute, what that seems to suggest is that there are now 12 people sitting in the jury box.
Yes.
The judge is going once again down the row, as it were, to see where we are. We got 12. So down the front line, any concerns? Prospective juror, yes, I received permission to be off island from the 20th to the 28th of October. And then I don't have it with me, says the prospective juror. I didn't realize I had to have it in my office, but I sought permission in the normal process and received it back because I knew I was going to be off island. Yes, yes, stand down, says the court. Yes, court associate number 34, Shirlene Simons. So that person has now been stood down.
No issue with that one.
No issue with that one, my lord. None at all.
No issue with Sarah Cook.
No.
Right.
Right. And then starts what I would describe as a series of standbys.
Can I just ask something? We got to a stage, I can't remember where it was, where there were 12 people in the jury box.
Yeah.
Yes. That's right. It's at page 384 or page 16, line 14. We got 12. Yep. So they got 12 by then. Then the judge asked whether there are any concerns.
Yes. Yeah.
Would they not have been asked whether there were any concerns before they got to the jury?
Well, again, it's a different procedure in different countries,
Yes,
and with different judges. In the United Kingdom, it would work rather differently because people would express concerns before they went into the jury box. Here very often they go into the jury box. Sometimes what happens is that they hear what others have said by way of an excuse. That person's been excused by the judge, or the prosecutor stood them by, and so they think, well, I've got an idea here too.
I've got something as good. Yes.
Yes.
And so sometimes they've initially sat into the jury box, and then it's only later that that issue is raised. And in fairness to the judge, he is, as it were, double checking as he goes along to make sure that there's nobody in that jury who has a perfectly good reason for being to be excused.
Right.
And as we've seen, sometimes there may have been someone who might have indicated they have an issue, but the judge said, well, you wait there for a minute, we'll see how we get on. So no complaint about any of this so far, other than that Melanie Friend has now used up, in our submission, has used up 2 of his standbys that we say were limited to 3, albeit not at that time, but we say, looking back, that would have been a proper approach. Anyhow, what we then get is the next juror, which is Charlene Simons. And Charlene Simons can be found at 38, I think it's 6. Let me just.
Well, she's accepted as a standby, isn't she?
Yes, she is.
385.
Thank you, 385. I have got the number slightly.
17, top of the.
Thank you, Malone. But there's no issue here. And then a friend accepts that that is a standby. He says that's the second one. We submit that's the third one. So next is Maria Rewan, and that can be found at 385 at line 7. So Crystal Simons, Charlene Simons, I think it was, that she's identified as. Standby, that one we've dealt with. And then Siobhan Hollis, no concerns. Red shirt, still stay with me. You've got to answer me. No concerns. Yes, you're the only man in the red shirt. That makes you so easy. Right. No concerns. And then you can see what's happening is going along the front line, and none. And then somebody in a blue dress at the bottom of page 386.
I'm sorry, I've got lost. Which one are we on now? Which one are we on now?
We're coming to Maria Rewan.
Yes.
We're dealing with it as we move along from page 386.
No, but Maria.
Wait a moment.
Put it into context.
385.
Yes, Maria Rewan is at page 385.
Dealt with straightforward standby. Number 29, Maria Rewan, standby.
Sorry, I got the wrong page again. My own annotation. I've gone wrong here. 386. I've got the next page. I thought we were leading up to Rewan, but we weren't. We were now coming back to that. So Rewan is already dealt with at page 385.
Yeah.
So what happens here is that Rewan, we've had Charlene Simons.
Yeah.
At line 4-5, stand by, says Mr. Mahoney.
Yeah.
And then at line 7-8, we get Maria Rewan. Stand by, says Mr. Mahoney. At line 10-11, Altino Loops, still on the front line. Madam, yes, I have one concern, and I'll come back to that in a moment. But Maria Rewan, we submit is standby number 4.
Yes.
Melanie Friend says that although on his notes, no reason given, but she was the former accounts clerk at the Supreme Court, now employed at MDM. I'm bound to say my immediate response to that is, so what? What has that got to do with the price of fish, as they say? It seems to us that if that were the basis upon which that person was being asked to stand by, that should have been ventilated. There's absolutely no reason at all why that person could not serve. I simply don't understand why somebody who might have been an accounts clerk at the Supreme Court could possibly be a rational reason why that person could not serve as a juror. And now it's not even as though the person was still at the Supreme Court. The person's now employed at the at MDM. So in our submission, it's simply not a good enough reason. It makes no difference whether she was an accounts clerk at the Supreme Court or was working at MDM. I'm bound to say, as I say, frankly as that, so what? And so to proffer that now as a basis upon which the Crown was seeking to stand that person by is to deny us the opportunity to properly ventilate whether or not that person should have sat on the jury, and indeed denies the court the opportunity to do so also. If the Crown simply asserts standby, the judge has no opportunity to consider whether that person should or should not sit on the jury. Unless, of course, she goes to the back of the queue, and then it comes back again, in which case he would be entitled to ask, well, what is the basis for the standby? But it never happened. So the random selection there is being interfered with by virtue of the Crown seeking to stand this person by. We say now standby number 4. And if that were a legitimate reason why he was seeking to stand that person by, he should have said so, because we see absolutely no reason at all why that person could not sit.
Mr. Lynch, it's now in England 8:15,
Yes,
and we've had quite a long day. Would this be a convenient moment to adjourn?
I'm entirely in your lordship's hands.
Well,
I can't conclude in the next 5 or 10 minutes, so there's little point in proceeding.
No, absolutely. Well, there's no point in proceeding but on the express assumption that we shall finish tomorrow.
Yes. Well, certainly as far as I'm concerned, I've probably got a half an hour maybe or so to take you through the remainder of these.
Yes.
I'm happy to do that in the morning.
Yeah.
Whatever hour you determine, with all due to my lord, Mr. Smelly.
Yes. Ms. Greening, I wonder whether you can help us, because you accept, as I understand it, that in your case, just a moment.
There were 33 jurors stood by,
Yes.
28 of which were excused for cause eventually.
Yes. And 3 were...
3 sat on the jury and 2 were actually stood by and didn't get called back. So in a nutshell, the Crown was successful only in successful in his attempts only in respect of 2 actually. Out of those 33 standbys, 13 were stood by with absolutely no explanation at all, just the Crown standing up and saying stand by. And the other 20 were stood by in a similar fashion to what Mr. Lynch and Mr. Pettingill have been going through, where a juror has passed up a note or written to the Chief Justice or said out loud when called that they have some particular issue, and then the Crown has taken it upon themselves to say stand by rather than the court getting involved. So out of those 33, 13 were stood by without us knowing what the Crown had in their mind about those 13. The others we do have in our mind, but my argument is consistent with the other appellants' counsel that notwithstanding knowing the excuse or reason, it was not for the Crown to be doing that, and it creates an appearance of bias to the trial process. And in my submission, with potential jurors sitting there about to embark on a very important task, having them witness or observe the Crown running the show, I guess is the expression we're using, takes us even further in my submission to potentially real bias, because they're watching the person that's then going to be asking them to convict the appellant in control and influencing and
well, just a moment. I'm very puzzled by this, because what you said in answer to various questions is, in response to your letter dated the 26th of February, as stated in my oral submissions at the hearing for leave, I do not argue with the Crown as to the number of standbys, those excused, challenged, or who eventually sat as jurors. What the Crown says in this schedule is that there were 33 who were originally stood by, that there were 28 who were excused or stood down for cause, and that there were 3 who were went on the jury, meaning that at the end of the day, the numbers of people who were truly stood by was 2.
Yes, and I don't disagree with that, but if you split the jury selection process into 2 parts, just to simplify it, the first part is when those names are called for the first time. The Crown has stood by 13 of those with no explanation or prompting of any sort. When those 13 and the others, so in the first part, 13 of them were stood by with no explanation whatsoever, stood by. There are a number of them, the rest of them were called, either had a note, a letter to the Chief Justice, or it was somehow already known that there was an excuse, and that was discussed. And the Crown in the first half, before you get to the bit where you have to challenge for cause, took it upon themselves, or was somehow directed by the court to, silently, it seems, directed by the court to say stand by after they'd given an excuse. So 13 of them said absolutely nothing. It was just like, Victoria Greening, stand by. Then there were a number of others who came forward. Victoria Greening, oh, she's got a note that she's traveling. And then the Crown took it upon themselves to say stand by after that was explained. And then what the second part of the jury selection process, when they'd exhausted the jurors and they had to bring the standbys back, which are supposed to be in order for a reason, but didn't seem to be particularly in order in my case, then the ones that have either given their reason and put back into the pool or hadn't been called yet. No, there couldn't have been any that hadn't been called yet, because all of them had been called. So the ones that were coming back for the second time, having been called the second time, then there would be a discussion between mostly the judge, the juror, and the prosecutor about whether cause had been established. And I think in all but 2 cases, cause was established, and in those 2, it wasn't established, and they had to sit on the jury. So whilst I maintain my position that I said in my email in reply to your letter, that I don't have any argument with the Crown's breakdown, it's not quite as simple as that.
I'm afraid I'm not following this. I had understood, as I thought you accepted originally and a moment ago, that at the end of the day, there were, the first time round, there were a number of people who were stood by, but at the end of the day, the makeup was, as we were saying, that 28 of the 33 who'd been stood by were either excused or stood down, and 3 were engaged on the jury, where 3 became members of the jury, so that those who ended up having been stood by numbered 2.
Yes, and at the end of the day is the crucial phrase, that is what happened. But my submission is that the damage had already been done by then, because in the first half of the jury selection process, it was 13 of them were stood by without anyone in the courtroom apart from the prosecutor knowing why they were being stood by. He might have been standing them by because he didn't like the last name Wellman. But then it turns out when Wellman comes back the second time round, he says that he can't sit for a particular reason, and then he's excused for cause.
So although this was somebody whose case was considered and who was properly excused for cause, the fact that he was stood by originally is fatal. Is that what you're saying?
Yeah, at the end of the day, when he's called back the second time, so if someone is called, Michael Wellman stands up, the Crown says, stand by, he goes to sit back in the gallery. We don't know.
But the question is that fatal?
Yes, I'm saying that that creates the appearance of bias that I've been going on about since the start of this appeal. Yes, that creates the appearance of bias, the abuse by the prosecutor of Section 519 by standing by so many people.
By standing by someone for whom there's a good reason to stand down.
Well,
for cause.
Later on, we find out that that person can't, doesn't want to sit because they've said they're Victoria Greeding's cousin, but we don't know why the prosecutor has, well, two things. We don't know why the prosecutor has stood that person down, stood that person by. And secondly, it creates this appearance that particularly Mr. Pettingill and I keep going on about, that the prosecutor is running the show in control and influencing how the jury is.
That point.
Yes, yeah. So
the bias operates even though all the people who stood by and didn't sit on the jury, save two of them, were properly stood by, as it turned out.
Well, like I said last week, I think it has taken, three extremely clever judges, 4 or 5 extremely engaged lawyers, and gosh knows how many hours and days to figure out who was stood by, who was excused for cause, who was excused for cause by who, tables, amended schedules, submissions, written, oral, to figure out. The reasonable observer sitting there watching the prosecutor do what they did is not going to say, oh, well, it's fine. At the end of the day, 33 got stood by, 28 of them came back, and 2 of them, and 3 and only 2 in reality.
Okay, well, we'll have to consider that. But I mean, my knee-jerk reaction is that if juror A stood by for no apparent reason, there might be a moment at which the fair-minded and informed observer would think, oh, I wonder what's going on there. Mm. But if half an hour later he comes back again and is properly excused for cause, the suggestion that some bias has been injected into the system simply disappears.
It's an appearance of bias.
No, well, the appearance of bias disappears because the chap has been excluded, or the lady has been excluded from the jury for a perfectly good reason, which is apparent.
Well, it may be so for juror A, but if juror A, B, C, D, E, F, G, up to M, or all the way down to Z and back again, have been stood by one person who's supposed to be part of this adversarial system and engaging in a fair process, is standing by all these people. The appearance is, as my client said in his affidavit, that the prosecutor is attempting to shape the jury favorably to him.
and manifestly hasn't succeeded.
Why, if there are 33 people called, and out of 33 of them, say just for simplicity's sake, half of them reasons and excuses and letters are discussed, why wouldn't the prosecutor offer up the reason for wanting to stand by the other 13, other than that A, they didn't have to under the old law, and B, there's a reason that they don't want to give the court. They don't like their last name. They've heard their wife is on drugs, you know, whatever it is. They don't want that person to sit on the jury because it's going to affect their chances of getting a conviction, to put it bluntly. And I apologize. I had thought that my submissions had made clear that my argument rests solely and strongly on this appearance of bias. The trial process is not fair because...
Okay, well, we'll have to consider that in due course, but on that basis, is all that we need to do in going through the list to see which are the 13 who were stood down first time round?
Yes.
Right, well, that won't take very long, will it?
No.
Right.
At least that's
okay.
Something.
Sorry?
At least that's something.
At least that's something. Right, well, we will sit tomorrow. Now, Mr. Coelho, what is the arrangement about timing?
We could start tomorrow at 9:30 for this matter.
What time is the commemoration of Sir Austin?
Well, I was going to say let's get through an hour of tomorrow and then deal with the commemoration sitting at 10:30.
And we can do
or 11 o'clock.
Well, I don't really mind. Okay, well, shall we start at 9:30 tomorrow? Is that 9:30 Bermuda time?
Yes.
Right. Well, until then.
Thank you, my lord.
Thank you very much.
Thank you, my lord.